Yes, correct.
But may you be allowed to do the affiliate side mentioning?
At the time of appellate side. There are a few matters in there. Yes. Columns.
Matters. Item number 1.
Your Lordship's last order, my lord, 20th of November. And I have talked.
What happened in the...
What had happened, my lord? So, my lord, I was only praying, my lord, kindly keep it, my lord.
After Justice Kumar returns, or after that?
No, my lord. Kindly keep it, my lord, sometime in January.
January, very well. Because otherwise also in this bench, if you keep it parted, it would be of no use. I mean. So January...
towards the end, my lord, because my learned friend has personal problems.
Yes.
So, my lord.
So should we keep it on 22nd January? I mean, that would...
Very well.
That's a Wednesday.
Very
so, good. It is informed to the court that the injunction application has not yet been disposed of by the learned single judge. Full stop. Accordingly, let the matter be listed on January 22, 2025 for hearing of the appeal. 22nd January for hearing of the appeal.
Only one thing.
Yes, Mr.
You would recall, my lord, this is, my lord, one appeal is from a refusal to grant interim order at ex parte stage. Another, my lord, is, my lord, before at the new motion stage. Now it's all ready for hearing, my lord, after affidavits. Your lordship wanted to, my lord, dispose it off. My lord, saying everything there.
Yes.
My learned friend wanted, my lord.
No, my lord, I had said with that observation.
No, that observation is.
That observation is a crucial observation.
That observation, whatever is there, I'll take that risk and let it go. I carry it in mind.
We hope and trust that it is over in the trial could be. Thank you. Yes.
Item number 3. Art individuals private units.
And in this matter, my lord, I am for the appellant intervener, my lord.
Intervener.
Intervener,
Where
my
are
lord.
the appellant and the respondent? Yes.
But I prefer the respondent.
Who is the appellant?
I am for the appellant one. Appellant intervener, my lord.
Appellant intervener. How can the appellant be the intervener?
Intervener before the trial court, my lord.
What have you challenged?
My lord, challenge is, my lord, initially we have made an application for direction upon the receiver to walling up the particular property, my lord, because there is an order of Honorable Supreme Court of India, my lord, and it is determined, my lord, everything is determined, my lord, only
What have you challenged?
challenge is, my lord, that that application, we have made an application for walling up.
You are appearing in person?
This person.
You are for the respondent number?
7A.
7A.
Very well. You are being supported.
7B.
You are supporting each other.
Yes, yes.
Very well. Yes.
So, my lord, we have made an application. That application was not, my lord, accordingly we have prayed for, my lord. That is why we have prayed for another application for
Wait,
recalling of
what
that
is the suit for? First, tell
The
us. that.
suit is, my lord, partition suit, my lord.
Partition suit, you are not a party there?
I am not the co-sharer of the party.
Very well. You are an intervener. You were added as a party.
No, I am not added as a party. I am added as
You have filed an application for addition of party.
yes, my before the Supreme Court, my lord.
Not before the suit court.
Not before the suit.
So what is your ground of addition?
My ground of addition is, my lord, there is an order of the Supreme Court that in that Supreme Court order, my lord, I am the party to the proceedings, my lord. Because there is an arrangement between the co-sharers, my lord, and the co-sharers has been assigned to us, my lord, for development to particular properties, my lord, and we have developed particular properties, my lord.
But you don't have a current right in the property. Don't have current title in the property.
No current title in the property.
So you sought to implead yourself before the Supreme Court. What was the order of the Supreme Court?
Order of the Supreme Court, there was a terms of settlement, my lord. The terms of settlement was recorded, my lord. We are the party to the terms of settlement, my lord.
The Supreme Court disposed of the partition suit.
But not dispose of partition suit, my lord. Only a particular order was passed for development of the property, my lord.
That is neither here nor there. But if you are still not a party to the suit, then how can you hear it?
Well, yes, my lord. Still, there is a right, my lord, because there was a direction of the Supreme Court. Your lordship, kindly come to the order of the Supreme Court, my lord.
Where is it?
Well, that is page 55 of the
Paper book.
paper book. Well, I am led by Mr. Ghosh, Mr. Dhruva Ghosh.
Yes, sir.
I am led by Mr. Dhruva Ghosh. He is coming, man. Page 55,
Page
my lord.
55, yes. Delay condoned, substitution allowed, appeal disposed of in terms of signed order. And signed order is it follows.
Thereafter, my lord.
This appeal was preferred by whom? You?
No, no, my lord. Appeal was before
One
the
of the
Supreme Court
parties.
was one of the co-sharers, my lord. That is Pratima Mollik and another.
Appeal was preferred against what?
Appeal was preferring that, my lord. Initially, we have been assigned to development property, my lord. The time is over. That is why they have made an application before this honorable court. Honorable court,
Who made an application before?
that co-sharer made an application before this honorable court for removal of the,
The
develop-
original suit is pending before this court.
before this.
What
it
was
is
the
also-
application for?
This application for, my lord, for removal of the order, removal of the developer. Initially, my lord, removal of developer from the agreement between the parties, my lord. That is co-sharer.
That
and
was
the-
turned down. They went up to the Supreme Court.
No, that was allowed, my lord. Thereafter, we preferred an appeal before the division bench, my lord. That was in favor of, in our favor, my lord.
And it was held by the division bench that?
That we should develop the property, my lord.
All right.
Thereafter, they went up
How
to
do you
the,
come in even? You are not a party to the suit.
my lord, but right accrues,
Developer doesn't have a right locus standi to.
there was a settlement between the parties, my lord. There was a settlement between the parties, and that
But
settlement
partition suit is still pending.
partition is still
Your
pending.
rights are independent. You could have filed a separate suit and
No, no,
that could be heard
Your Lordship,
conjointly with
kindly-
this.
kindly this order of the Supreme Court, my lord.
Yes.
I am a very specific, my lord. I am not interested in the property, my lord. I am only directed to develop the property, and I want to develop the property. And we have developed a few properties, my
Very
lord.
well. As per this, you are permitted to develop.
Permitted to develop.
Then what is the present application?
Present application is, my lord. Your Lordship, kindly come to page. I'm sure, your Lordship.
After this order, you have filed another application which is now before us.
No, I have that was before the single bench, my lord.
Acha.
At trial court. That order.
What was that application for?
application for compliance of the order passed by the Honorable Supreme Court?
What was the order of the trial court
Order-
which were?
that order was not passed, my lord, and directed us to go before the Supreme Court, clarify the order of the Supreme Court, my lord.
What is the
They-
learned single judge's order?
What?
Give us the page.
Page, my lord,
We mean the order impugned before us. That is
order,
that order.
order impugned, my lord.
That is the impugned order.
No,
The
there
order
are
of the
two
sim-
orders, my lord. Two orders. Thereafter, we made an application for modification of that order. That is before your lordship, my lord.
Acha. What is the modification sought?
Modification, my lord, there is, according to us, my lord, there is a discrepancy between the premises number. So we have modified that application. We have made an application for
So
modification.
you
of the-
did not challenge the order whereby the implementation was refused.
No, no, that is also challenge. That is under number 4, my lord.
Acha. So there are two appeals.
There are two appeals, my lord. They both are connecting.
Well,
Original
yes.
order-
Modification. What modification?
I'm led by Mr.
Mr. Ghosh, apparently you sought to intervene yourself. I mean, in this partition suit before the Supreme Court. That agreed order was there.
Yes.
So you are permitted to develop.
Yes.
Subsequently, you came to the suit court and took out two applications. Apparently, up to this we have understood.
Yes.
One application for implementation of the order of the Supreme Court, and the second is for modification of what order?
The first application was for
Okay.
implementation of the Supreme Court order.
Yes.
There were two sets of prayers. ABC is to there were two properties. The receiver in the partition suit entered into a development agreement with us.
Yes.
We developed the first property.
Hmm.
And all the Addi family, the 100 defendants, they were accommodated.
Hmm.
But my friend here, they were in the second property. So they were to shift into the first property. That was the order. And if not, they are to get compensation.
Yes.
Now they chose not to shift. That's in their affidavit also. So this building was built. It's a multi-storied building. Everyone else shifted. They did not shift. So then, my lord, as far as developing the second property, the order was you partition part of it. One defendant gets her portion, and the rest we had to develop. So we took out an application saying that, okay, you have to, since you didn't shift to the new building, we will accommodate you elsewhere and build this building, and we will give you new place in the new space in the new building. Now that was our application. That was, my lord, heard, and more or less it was allowed. But the last line, the learned judge wrote that we will give them accommodation. The new building will be built, but they will be accommodated in the plot A.
The first one.
Yes, so I thought it was an innocuous mistake, my lord. We made an application
the second
for
appeal.
modification.
Yes.
And the first three prayers had been ignored in the judgment as far as the partitioning of the second plot is concerned. So we thought it was a simple modification application. Then his lordship heard it and reserved it for some time. Then when the judgment came, he said the Supreme Court has said they are to be accommodated in plot A. So I cannot touch.
So what is your answer to that? I mean, if the Supreme Court said that,
My answer is that if the Supreme Court order is to be implemented, then it's either plot A or compensation. Now, he has written in his opposition that he was not happy with what he got, so he did not take plot A. Now, he has to get compensation and he has to vacate the second property.
Let
But
us
as a offer, page 17 is
you
the
give an extra offer that they may be accommodated here. I mean,
yes, we will accommodate them in the meantime and give them space in the new building.
But if they don't accept that, they are entitled
Then
to
they
seek
are-
an implementation of the Supreme Court order.
Then it's compensation.
They will get
They
compensation.
will get compensation. But the compensation, I don't know if. So I tried to explain that because of my friend is
Yes.
appearing in person.
Yes.
So in a way, I'm at a disadvantage.
Yes.
So I've tried, but then my lord,
So
the learned judge himself, my lord, understood. If your lordship sees,
let us
I'll
see that
just
order.
show your lordship
Yes,
quickly some pages. Page 17 is the other prayers for my first application. Now, as far as prayer A, B, and C are concerned, it has nothing to do with defendants 7A and B who are appearing now. A, B, and C is to ask the receiver to partition the property in accordance with the Supreme Court order.
This property is plot A, lot A, or plot
Well, I am calling it B,
B.
84 Rakal.
B is the one which you have already developed.
No, A is the one.
Second one.
That is on my designation.
So you want a partition of B?
Of 84, of B. This
84,
prayer
right.
A, B, C, we had argued it, but it was ignored in the first order. We asked for modification. Again, it was overlooked, I think. So it has to be remanded back, or your lordship can decide A, B, C. Then, my lord, D, we asked the defendants be directed to accept compensation. That was our first prayer. That is there. I'll show that order. In lieu of 500 square feet, there's a to get.
Which they are already in occupation of.
No, they are in occupation of plot B. They were supposed to
No,
get
557 is the area of their present occupation.
No, they were supposed to get
Oh,
557.
acha, acha.
The proportionate, there was some calculation.
Either get 557 in A
in A.
or get
compensation.
compensation in lieu of that.
Yes.
Right.
Now, what alternative, that E was our alternative,
Yes.
that they be directed to surrender the in plot B and to the petitioner in lieu of compensation. But we offered them, this is not in the prayer, we offered them space in that. So this order is passed, that's in volume 2. Your lordship will have to see page 227. 227, the order was passed. Means that 227, the cause title is used.
Yes.
239. 14th of July. Well, my prayers are all the first page. It's set out that even that I asked for partition is there.
Yes.
By the intervener praying for receiver to demarcate. That order he forgot to, or his lordship overlooked to pass it. That was my submission, the first part. Then the Honorable Supreme Court framed the scheme detailing the things to be done. Learned Counsel for the developer submitted that 7A and B were offered two appropriate flats in the newly constructed buildings located at 27 Chitla. That is A, what I'm calling. But they refused. And on the direction of this court, a number of meetings were held between them. As well as the intervener, options were explored and offers were made in terms of para 4 in page 15 of the scheme. The learned receiver held the meeting with 7A and B. Subsequently, we also held. Then the Learned Counsel for Defendants A and B submitted today that if appropriate flats were offered, their clients are ready and willing to accept the same in the newly constructed.
Different numbers A and B means who? You are different number
7A.
and you are B. Well, please take your seats. You don't have a seat behind you. Sorry.
Okay, right.
Yes, well. Yes, Mr. Coach, please continue.
So this is the part, my lord. Willing to accept the same in the newly constructed building at 27, that is plot A. So
Yes.
my submission was that this was by mistake, the modification. This should have been they willing to accept the newly constructed building to be made an 84.
But you submitted in the third paragraph, they were offered to appropriate flats in the newly constructed building.
Then they refused. That third paragraph, they refused. Initially, Supreme Court order was 2013. I built this house. I gave them the place. There are two buildings. One is a higher building, one is a smaller building. They were to get only 500 square feet. We offered them in the smaller building. They refused.
So they said it's not appropriate.
No, they said yes. So if they refuse that, the Supreme Court has that alternative compensation. That's my prayer D. Now here, this is where, because there's no question of this main building, whatever, even if I try, Manoj, if I've given all the possession to everybody else.
By now it has been given to us.
Yes, because that was built in 2018 or so. Then after hearing the parties, it is all, and the learned receiver, it is ordered that. Now this was what was decided at that hearing. Intervener shall accommodate defendant 7A in suitable accommodation during
But 5 goes against you. 5 is in plot A.
A, but C1, my lord,
Yes.
that we will accommodate him in suitable during construction.
That is during construction.
Plot A has been constructed. This was obviously
Even at that juncture, it had been constructed.
Yes, it had been constructed and it's full. We had offered them earlier, they refused. So this, at least our understanding was that they'll shift out. We will give them suitable
So
accommodation.
you wanted later on a modification of 5, Roman 5.
Yes, that should be, instead of 27,
84.
it should be 84.
All right.
Similarly here, in the earlier page, in the newly constructed building, they had said, there was some confusion. What
No, but
happened is-
they are sticking to 27 and 90.
This also we asked for because that
Then you
time-
want a modification of the entire order.
No, yes.
It's recorded there. They want it in the newly constructed.
So I wanted a modification that they had not said this. It's
Mr.
not-
Ghosh, in the third paragraph, it stated 27 and 92.
92
agree.
Yes, Your Lordship,
always-
see
Please,
the last
please.
line of that paragraph,
Yes.
but they refused.
They refused.
We
And
offered.
then again, they renewed that.
We offered. Now the practical situation is that building is now full. We had offered them, they did not take under the
Let us see
Supreme
the
Court order.
next order, Mr.
Yes,
Ghosh.
they were
once.
So then
The
I
modification.
wanted modification of
Yes, yes.
these two lines, that 240 and the last 5.
Wherever there is 27 and 92, you wanted 84, basically.
Now, after that, we took out the application that says at page 243. That's the notice of motion. What modification we wanted. This 243 appeal, my lord, the paper book is ready. The other appeal has not yet been moved. Then I also preferred an appeal from this original order
Achha.
because
This is the present appeal is against the modification order.
243, yes.
Right.
So there
But-
has to be an order that other appeal will be heard along.
243 carries on forever, the cost title.
Yes, cost right. 59.
Recalled
I'm
modified.
sorry, 258.
Yes, 250. Yes, whatever you said. But where is the order on that, Mr. Ghosh?
Yes, the order on that.
Again, the cost title
ensued order,
starts. Yeah.
That is at 526. That's on volume 3. I'm sorry, 326. I'm very sorry. 326. Again, of course, that's the cost title. Begins at 341. Now, several applications, other applications were taken up. But my application was 149.
Hmm.
So that is at page, my lord will ignore the others, page 345.
Yes.
So here, the learned judge, after he reconsidered, he said, no, what you are asking for is contrary to the Supreme Court order. You are supposed to give him in plot A. But we agreed in the first time, we agreed that they will be suitably accommodated, new building will be built, then they'll obviously be put into the new building. Why will I put them back into the old building? If I could, I would have done that now also. So it's filed by the developer for praying for modification, recalling or correction. To the extent that the penultimate paragraph of the order, the words shall hand over suitable flat at 27 be replaced by 84. Lordship says that.
Yes.
Then he filed an opposition. Then the court, on hearing the parties, passed appropriate order in the presence of the parties. It was directed to the developer to carry out the scheme of the Supreme Court in true letter and spirit. Then those points A, 1, 2, 3, 4 would not have been there if it had not been agreed. But that's my alternative prayer E. Otherwise, I'll stick to prayer D. Then I give him compensation and he still has to leave. The Supreme Court order of, I'll show this order, 26th of February 13, amongst others, directed the co-sharers who are in possession of 84, this is 7A and 7B, shall hand over their possession to the developer at the time of handing over flats, proposed buildings to be built at 27 and 92.
Yes.
Within 3 months of completion. In the meantime, the developer shall be entitled to apply for sanction plan for 84. The direction was reflected in the order of 14th July. Then that, what the present petitioner proposed in the guise of amendment of the order of 14th July is modification in disguise of the Supreme Court order. Well, we had come very clearly and asked for that. We didn't want to suppress or disguise or surreptitiously do it. That either we pay them compensation under the Supreme Court order, or my lord, we made this offer. And from what we understood, he had agreed. Both of them had appeared in person at that time. But the order went down. No, you go back to square one, the first plot. Then the application was therefore dismissed with costs of 25,000. This has been stayed since payable. Then the amount of cost shall be deposited and
Whatever.
this thing.
So what is the Supreme Court order, the relevant
Yes,
portion?
the
Also?
relevant portion, that order is at page 57 and also at 308. I think 57 is
57.
this. So this is a long order.
No, let us cut it short by
Yes, I'll show.
just the relevant
This
portion which.
basically,
Yes.
Mr. Bhaskar Gupta had been appointed as amicus.
Yes,
He sat with all of them. There are 100 defendants. And 6 judges have released the matter because sometime or the other they have appeared for this
we
partition.
must have appeared. Justice Kant may not have. I must have appeared for some of the parties. We feel tempted to do that as well.
No, we searched and in the
Unfortunate.
justice, you could only find your lordship. Now, 57 at
yes.
page
The relevant portion where
70, from 70.
70.
Oh, well, if I start at 69, my lord. 69. There was some term.
All right.
In view of the above, the terms of settlement are also accepted and shall be a part of the order. The terms of settlement are as under. This was drafted by Mr. Bhaskar.
Yes.
The first part is not so significant. My lord comes at the last paragraph of that. It is recorded that the respondent is already in possession of the portion of 27. This is plotting. And the vacant lands of 27 and 92. That comprises of plotting. Then 2. That the co-sharers who are in possession of 84, that is 7A and B, and this other lady, shall hand over their possession to the respondent number 1 at the time of handing over of flats in the proposed building to be built on 27 and 92 within 3 months of completion of construction. Meantime, the respondent developer shall be entitled to apply for sanction.
So at the outset, they were only to hand over if you provided them accommodation in
So
27.
now we built our cases, we built the building, we offered them accommodation. They refused. That is admitted by them. So that is the subsequent event. So this was the order. Then the 3 is important. Co-sharers having less than 1% interest in the properties, which is my
Them.
friends, clients, and my friend is less than.
But do not have physical person does not apply
do
to
not
them.
have, this doesn't apply.
So it is
not
and
applicable.
therefore this clause
The
does.
next paragraph for people who are in possession. 4.
Yes.
4.
Four.
That's 71.
Right.
Co-sharers having less than 1% in the properties and have physical possession in any of the properties under the development agreement and have not sold their undivided interest may form a group. They can form a group to add up their interest, the properties to 1% or more, to take developed superbuilt accommodation in the building to be constructed according to the rate of 345 square feet per square feet per 1% interest. Such
To be built up means this refers to which one? 84 or the other?
I think it's the
Maybe
first,
either of the two. It's vague.
no, it's usually the first one because they were supposed to shift. I'll give them. I'll get the 84 by myself. I will be able to construct. So it would have come to me empty. So then this is in respect of 27. Such co-sharers shall also be entitled to compensation of 30% of the total land value fixed under the grant. That is, the land value was given that time at 80. Then car park, etc. are linked. So those are the relevant ones. So I'm saying that under
This compensation was irrespective of you giving them possession. You had to give them possession. This is over and above that.
no,
Entitled to compensation of 30% of the total land value fixed under the grant.
because
does not
they'll
refer
have
to
to
those-
first form a group. It's a minuscule part. If every
They may
share is
form a group
taken-
and get that compensation. This compensation, Mr. Ghosh, is not in lieu of not giving them possession in terms of the first clause. That is irrespective of this. You have to give them possession. It is recorded that respondent of clause
We have
1
given
says
something
you
already.
have to give them possession. So these are not interchangeable.
No, no, Paisha. Yes.
Clause 2 is very relevant. You have not complied with 2, Mr. Ghosh.
No,
Can I
Yeah. Let me-
We'll hear you. Before hearing you, we won't pass an order. We won't take your seat. What is your name, please?
join to Addi?
Mr. Addi, please take your seat. We'll call upon you. You will have your turn.
my lord, if I may read for, like your lordship is.
4.
reading,
4.
I think this is if I don't give them that flat, then I have to
That is
pay.
not there. Just see.
Co-sharers having less than 1% and having physical possession of any of the property. So that's my dependent number 7A under the development agreement and have not sold their undivided interest may form a group. They have to first form a group so that they add up to 1%.
If they're not in possession, they don't get anything. Or whatever
This
is there in
clause 3.
clause 3, whatever.
Clause 3.
Then also they have a similar clause. If they're not in physical possession, they're entitled to get only that compensation. Form a group and get that compensation. And if they are in physical
And they will
possession,
get in addition, they will get that.
yes, exactly.
So the ones who are not in physical possession. Now, in this one, I'm just seeing if that words in addition is here. That's
Not there, not there, Mr. Ghosh.
in paragraph 3.
Hmm.
It is there. In addition, they will get this compensation of 30%. This last sentence of 4. Such co-sharer shall be entitled to compensation of 30% of the total land value fixed under the grant.
So therefore, Mr. Ghosh, from 3, it is clear that the intention was that this 30% for land value is a fixed amount for both. Those who are not in physical possession, they will get compensation paid up value for the area which they'll not be given possession. They get this the additional compensation.
Yeah.
But that 30% is for the land value, which is applicable to both in possession and not possession.
That is the agreement is 88 lakhs. All of
Yes,
them will get.
the
Their percentage they will get.
Mr.
from
Ghosh,
that price.
apparently from 3, a combined reading of 3 and 4, it is evident that for land value, both of them get 30% if they form a group. In addition, those who are not in physical possession get compensation for that possession which is never given to them, and these people get possession. So this compensation is over and above that, Mr. Ghosh.
So 3 is not applicable now to these persons.
No, no.
4 is.
3 and 4 we are comparing.
Yes.
So what's the difference between people who are not in possession? Otherwise, they are similarly placed. These people who are in physical possession, who are not.
So in 4, first they say if they form a group which is above 1%,
I'll try to convince you,
then
Mr. Ghosh.
they're entitled to possession.
Mr.
If-
Ghosh, there are two
Yes,
categories.
yes.
This 3 and 4 are otherwise similar. Difference is 3 does not have possession, 4 has possession already. Regarding 3 and 4, both 30% of this land value will be given as compensation. That's common for both. In case of 3 who are not in physical possession, they won't be given back physical possession. Over and above that land value, they will get a compensation for that possession which was never given to them. But for 4, instead of that, since they were in possession, they'll again get back possession.
They will get the physical possession. That's the first sentence of 4.
Yes, then they will have.
Form a group, they are entitled to physical possession and that compensation.
No,
Yes.
forming a group is not
No, your
a
lordship,
precondition
they have to
for.
hit the 1%. So 2 of them
No,
together.
that 1% that is common for both 3 and 4. 1%, and they have to form a group, and then they get compensation that's entirely dedicated to land value. Compensation for total land value.
Yes.
That is common to 3
compensation
and
is the
4.
same. That's what-
Compensation for land value is same for both.
same for both.
Not in physical possession, in addition get some compensation, and 4, in addition to that land value, they get physical possession because they were already in. So
Yes.
therefore, this land value is irrespective of that, in addition of that physical possession. So therefore, you
Yes,
had to
will
give.
also be entitled to.
Yes, therefore, in any event, they are entitled to that land value,
That
which
we-
is there.
That we are willing to give always.
That is, yes, you are not on that. They are also not.
So now
That
your
is
lordship
divert with the
seeks-
physical. You have to give physical possession. Justice, the learned single judge was right. You have to give physical possession in
Now I'll show that. Now
27 and
when I
92.
offered them physical possession in plot A, in number 27, at the time it was constructed, they did not take it. Now I'll show that. Now then what happens? That is why I'm asking for an alternative prayer. We can be hyper technical and say that yes, you go to Supreme Court and get it cleared.
All right.
2013 matter to reopen, and it's for this small share, the 500 square feet. We are willing to compensate him in whichever way he wants.
Now the question is, what happens if that physical possession cannot be given now? It's not possible now. Yes.
What happens if it was given and he didn't take it? Then he'll only be entitled to this compensation.
That is not in terms of the Supreme Court order. That's
So the
independently there.
Supreme Court order, the way your lordship is interpreting it, he will get the compensation in any event.
Land for that is for land. 1% formation and land. That's different. That's not, that has no nexus with
Now
this
what
physical
happens
possession.
if he does not, when we offered him, now your lordship.
He has two courses of action, Mr. Ghosh. One is that taking out appropriate proceedings against you for not complying the Supreme Court's order, where you have a very good defense that they refuse. And alternatively, they can seek compensation before the suit court also will.
That they haven't done.
That they haven't done. They
Now
have.
we came forward and we want to solve. As far as partition, I didn't show your lordship that part.
But
of
Mr.
it.
Ghosh, we need not go into that. As of today, whatever.
No, because that portion is a separate portion. As far as the
But what is the
partition
wrong in the single judge's order then? This learned single judge was justified in saying that yes, Supreme Court, this is the order of the Supreme Court, you comply it.
Then it's a stalemate forever. That is the thing.
That is why we are saying they can now.
That is why we made this application. That after he refused, we made this application saying that we will give you alternate. We'll still give you new space in this building where you live now. Once you vacate, we will build it. And they agreed. And that's why that order is there. Points 1, 2, 3, 4. Why is it there? If that was the question, why will they agree? I agree to put him up in suitable possession when this building has been built and it's already full. So my whole idea was that. So we thought we sorted out the problem. Oh, it can be done by consent. I know your lordship is coming to that. If it's the ultimate, is the Supreme Court order, you go there.
No, not that. No, we are not coming to that. Actually,
Will be,
let us be pragmatic,
Yes.
more pragmatic. You're right. You are being pragmatic, very pragmatic. But because today it's not
first
possible.
time round, I felt learned judge was pragmatic. But then when he reread it, he said, no, then this will be contrary to the Supreme Court order. Supreme Court doesn't say that you give them space in
Mr.
84.
Ghosh, yes, even if they refused, because they refused, they were offered to appropriate flats, that's your contention. The
Yes.
learned
I'll
judge,
show that
that's
affidavit in opposition.
because
Page
they must
100
have said that you are not giving appropriate flats. That
Page
must have been
103.
their ground.
Then they would have taken steps and said that we are in contempt, etc. They have not.
They
done
can still do
anything.
that.
No, they are sitting on this now lovely plot. They're sitting there. We are stuck. Our money, half our money is invested. Now, this is definitely one part of the matter. The other,
Resolve it outside court, Mr. Ghosh.
I've tried.
Must
I
have
thought
tried.
we did. I thought we did. That last thing, what the pinch the learned judge's conscience. That no, how can I tell
No,
them to
not
go
that,
back to
because
84?
it was recorded categorical throughout that order that you
No,
offered.
just in those two places. That paragraph 5 and the last paragraph line of that other line. Because otherwise, it's
3 places, Mr. Ghosh. Please come to page 240 once. 340, 240, I'm sorry. 240. All the references are to 27 and 92. There is no reference to
the
84.
first 240 third paragraph. That is the correct reference because I said
You said they refused. It's your
they
submission.
went there, they refused, and that's in their opposition. I'll show
Yes.
that.
And we can bind them only to the last paragraph of page 240,
Now
which
here
says
he says newly constructed building. Now this
at 27 and 92.
right. So this I had said
It
that-
was a newly constructed building. It was not the old building.
no,
It was a newly
it was
constructed.
Newly after 2013, no doubt.
Even then, it was
But-
a newly constructed building. It was not to be constructed.
Yes.
Future tense is not used.
Yes.
Clients
So
are
no,
ready and willing
no,
to
if
accept the
we-
same in the newly constructed.
we go outside and I talk again to my friends here, well, I will be saying the same thing. So I'm putting them that the newly constructed building we meant 84. Let us put it, just read it once that way. Then that's why one makes sense. I shall accommodate them in suitable accommodation.
You meant it, Mr. Ghosh. They
Then
did not.
two, demolition work will be initiated on shifting. I don't demolish my already built building. And there it's
No,
already
not that.
it's already recorded 27.
No, Mr. Ghosh, probably you are not correct there because they are sitting in 84. You are not being able to construct in 84. You will
I-
demolish
so I
84
want-
after removing them.
we shall give them suitable accommodation outside 84 during construction. That was our reading. Now, that was what happened. And demolition will take place. Then we shall carry out the scheme. And then
Mr. Ghosh, apart from your stand, everything falls in place. The rest is in line.
Hmm.
Only what you are submitting is an aberration to this entire scheme. Supreme Court said you have to put them back in 27
not
and
back.
92.
They were never in 27. They were in 84.
Sorry,
I have to put them in.
we delete the back. You
We
have to put them in possession of 27 and 92.
Show that I offered them.
But
They
the,
did not
the
do.
rider in the Supreme Court
But
was that they will leave possession of 84 only when you give possession at 27
When I
and 90.
offered possession, they did not leave. Does that
That
mean-
is only your submission. There is nothing
No,
else.
no, I will show that. Their affidavit I will show. I'm
For
sure.
the first time in the appellate court, you cannot
No.
because we are our
Not
conspectus is very.
first time. It's there in the both the applications he has filed affidavits. I'll just show that.
There is no scope of
And that's
interference.
why he will also vouch for it. He'll say that I didn't like the place where he gave me. I'll show that.
No, we cannot decide that in this appeal.
Before your lordship decides.
There is no
makes
wrong
up
in
your
these
mind.
orders.
No, as far as prayer A, B, and C,
Modification means it was erroneously recorded by the learned judge.
as far as prayer A, B, I'm just on another topic. Prayer A, B, and C was in the Supreme Court order. Priya Datto, one particular defendant, had gone up and she was given 84. She's in possession of 84. Her portion is to be demarcated. So prayer A, B, and C was that. Nothing to do with my 7A and 7B.
Hmm.
Though there's a dispute between them, 7A and 7B are sitting in her portion. Now her portion has to be divided. 7AB. Now in this order, at page 240, your lordship will see we've recorded that. The first paragraph, praying for a direction on receiver at 240 for physically demarcating such and such as per
Page 240.
240, the first paragraph.
Yeah, physically, yes.
So that
Yes.
was my prayer. So that was one portion of the prayer. That prayer, there's no order.
At least you want to build up the other portion where they are not.
I have to demarcate. Now, the other portion after I have to, then my
So, Mr. Ghosh, we can do at best this. We are opening up our mind. I mean, you can submit on that further. Regarding the other part, we are not satisfied sufficiently to interfere. But regarding the first ABC,
Yes.
yes, that demarcation court has to, that learned trial, the single judge has to consider
Yes.
and pass an order.
And
on it.
again, in
We
the
can demand.
modification, again, he lost sight of that because he got.
We can do that subject to hearing them. We can do that, remand it for that limited purpose of considering the first repairs. Regarding the rest, it's very clear.
Or even that ABC, your lordships also can consider. It's
So for the first time, we won't.
both the times because I
No, the ramifications has to be considered by the trial court. What will be the ramification on their? What will be the effect of?
now as far as
The feasibility of that may have to be an engineer commissioner's report may be required to be looked at.
comes to page 103, which is a
Yes.
part of the defendant 7A and 7B's affidavit. It begins at 93. 7A's affidavit. Page 93, Mr. Joyanto Addi's affidavit.
All right.
Now, if my lord comes to page 103. Three and at 107.
Yeah.
Now, the Honorable Supreme Court by its order dated 26th March, it should be 26th February,
Okay. Okay.
directed the developer to complete construction within 3 years. That is within 2016.
Yes.
Then, from the date of the receipt of vacant possession of 27. And in default, the developer shall pay to the co-sharers who have not sold their undivided interest compensation at 15% of land value for a period of 2 years, etc. And after that, they will be at liberty to apply to the trial court for further orders. Then the surveyor was appointed, then page 107. From the total fact, page 107.
Yes, yes.
It is crystal clear that your petitioner 7A and his brother 7B and also their father did not want developing and always denied to give their residential portion to the developer. The receiver and co-sharers of the RD estate clearly acquainted with the facts from the beginning. The developer was always of a depriving tendency and forces your petitioner to accept a small single flat. So depriving efforts of the developer must be stopped at any cost, otherwise your petitioner will suffer injury. Developer has already earned crores of rupees by selling luxury flats, the G+11, and is trying to drive away your petitioners from their dwelling portion silently and mischievously and suppressing the original fact of the court. So their stand is that we never wanted to shift in the first place, but the order has been passed. Then paragraph 8, your lordship will see the bottom part of paragraph 8.
Yes.
Page 108. Sorry.
Right.
The developer accommodated the defendant such and such in a luxurious ground plus 11th floor building in the precious southeast corner of 27 Chetla Central Road. But the developer is going to allot second-hand flat to your petitioner and his brother in a 13-year-old building in the premises, 78 by 80 Rakhal Addi Road, violating the Supreme Court order. It is said that no male member of the Addi family alive could live in this premises. So nobody in 84 can take a flat in the building in 2006. It is heard that the developer is selling the flats from this thing. So there are two buildings. Now
They rightly refused, Mr. Ghosh.
he's calling
He did
that-
not offer them 27 or 92. That
No,
was the direction of this.
This thing is.
You never offered
I'll
them
show-
27 or 92.
Now I'll show the other affidavit. Then this was in 2006, then page 303. The affidavit begins at 287. This is 287 is our affidavit. That is your understanding. One second, Manoj, I'll just find the beginning of the affidavit. Yes, page 299, your lordship will see. Compensation. Yeah. Page 299, this is Mr. Joyanto Addi's affidavit, then at 303. He's dealing with our paragraph where we have said that we had offered him and refused. The paragraph 7. With reference to the statement contained in paragraph 8 and 13, your petitioner submits that after the order was passed by the Honorable Supreme Court, the developer constructed two new buildings. G+11 luxurious building at 92 Rakhal Addi Road and a G+4 building in 27 Chetla Road. Now it doesn't say it's a 13-year-old building. It was built in 2013. Now we built two buildings. Every other member of we have accommodated. It's been a long haul from 2001. I think this has been going on. Then, so this G+4 is where we offered them. Besides the Maruti repairing shop. If your lordship crosses Chetla Bridge, I don't know if your lordship knows after the Kauratala, it's on the right. It's a lovely new building at the corner.
Where it's written, I love Kauratala.
No.
I love Kauratala with a heart sign. We have. I remember that.
Beyond that. Then
After crossing that, if you can cross that.
I had gone there recently and the boy who was giving tea, so he's asking me, how are you? So I said, how do you know me? You look familiar. You're in the High Court. He said, no, I know you from here. So
Must have gone there many times. Yes. Kauratala and Nimtala, people may know us. I mean,
Yes, that's
advocates regularly go there.
great surprise. And so why not then? But they were going to allot the flat. Now your lordship will see. Maruti repairing shop.
It's actually
According to the Supreme Court order, as per the agreement of 9th December 91, that's when we entered into the
Yes.
development with the receiver. Defendants 7A and 7B desire to take a flat in the precious building in 92. But they were going to allot the flat in the ordinary G+4 building beside the Maruti shed. So they didn't like the place. That's it. Where the defendants 6, 8 and 10 of 84 Rakhal are allotted. So the other defendants went there who were in 84. They have gone. Only this person did not go, these two. Defendants 6 to 10 was shifted by the developer for 8 years and the developer had to pay the rent of their accommodation. So we had shifted them out and given them accommodation while this new building was going on for 8 years. This is his complaint. But they stayed back. They did not move. But your petitioner 7A and 7B had to repair their dwelling portion more than 20 years and had to live and sometime used to live in rental accommodation. The developer did not pay the repairing cost or the rent to the petitioner. Again, the developer in his application on 8th September 88 offered to give co-sharers built-up accommodation flat. But after Supreme Court order, they offered super built-up flat. So the carpet area has decreased. Again, the developer did
Mr.
not.
Ghosh, instead of selling out all the flats in those 27 and 92,
It's sold out.
should have written to and taken out an application for implementation of the Supreme Court order.
I've given him the developer
could have taken
obeyed
it
your petitioner and sold the flat to outside.
Now, post facto, we cannot decide what can we do. Just imagine at the point of time when they were not shifting, you should have made an application for implementation of the order of the Supreme Court, and it would be decided by the court whether that's equally suitable.
Well, hundreds of meetings we've had with them, and they chose not
Could have
to.
taken out a single implementation application, Mr. Ghosh, and ask for their shifting to that flat. It would only have to be decided by the court whether that is commensurate with whatever the Supreme Court said, appropriate or not. That was the simple question of adjudication left. And they would have been directed to go there, either directed to go there or compensation or whatever. Now it's too late in the day.
No,
Now
but then it's nothing will happen. They will remain there.
As of today, yes, you did not file any application for implementation of the Supreme Court order.
No, this application was our application, which was heard, disposed of on 14. The alternative prayer is to give him because it is not possible.
But the alternative is not given in the Supreme Court order. In the agreed order, it's not there. That alternative is not there. That the court has to carve out now. The
Yes,
trial court
it
has
can
to.
be done. It can be done by.
They will never leave the property, right? They will not file any implementation application. Why should they? They're in occupation of 84, and they have a handle to manipulate you basically.
Because
Not in a bad sense necessarily. They may have a right to do that also, but they do have that now position. Now you have to enter into a new agreement
Your
with them.
Lordship will see even after that we have made attempts.
And in this partition suit, the entire endeavor in the partition suit, I mean, it beats us.
So they managed to sort out such a. There's so many heirs and there are only two.
So, but you always leave a chink open, Mr. Ghosh. Whenever you say appropriate position will be given in appropriate accommodation or whatever. Appropriate creates difficulty. Supreme Court said appropriate. Everywhere it said appropriate. They say it's not appropriate. Now what is to be
So
done?
This thing has happened. We went back. The High Court has also arranged these meetings, and after all these meetings, it was decided that we will give them.
Mr. Ghosh, now even if you say that that was appropriate, you offered him rightly, and he did not take it. It's his fault.
Yes.
We cannot carve out a niche out of that Supreme Court's order. We cannot add something to that order because your entire rights flow from that Supreme Court order. Your rights in this suit, there are
Yes.
no other rights you have in this suit.
No, I have an agreement. I have a
That agreement which was given the shape of a
agreement.
that is there. You
I
can
have a
file a
development. I have a.
they were
independent
parties
right.
to it. They were also parties.
Yes, everyone was because the receiver on behalf of all the parties have entered.
So then you can
In 91.
then you can file an appropriate suit for that.
I know, but your
But that will
lordship-
take many more
your
years.
lordship thinks about it. 91, this developer has come in.
I fully
And
we
this-
fully appreciate.
So I think we'll be able to sort it out. Your lordship, here's my learned friend. As far as A, B, and C, I'm quite clear.
Well, let us hear them.
No, then I show your lordship that we have made even up to 2022. We are sitting and having.
We
and
get your
now,
point, Mr. Ghosh,
as
that you
far
have
as-
offered this,
as
they
far
did not.
as that other defendant is concerned, Priya Dutt, who's
Let us see if a
also passed.
solution can be arrived at. Mr. Ghosh, we have heard you. Please take your seat. We will just hear them. Yes, Mr. Addo. What can be the solution?
Solution.
At first,
Give us a solution because 84 you are sitting there at 84.
Yeah.
Obviously, you have been successfully blocking them from constructing there. You have a right to do that. You may argue that you have a right because they did not give you commensurate equal property somewhere else in 27 and 92. Now they don't have 27 and 92. Now what can be done? Will you be satisfied with appropriate compensation or some other accommodation which is equivalent to this? Other accommodation which is equivalent to that the present accommodation you have.
I said, this is the Supreme Court order to give me 92 Calcutta Road. or
27 or 92.
92.
Right.
Our 92 is a spacious building in the luxury building right corner.
Forget that because they have already given it to others. Third party rights have
And,
been created.
this valuation of the OAC much better than the site he 27 beside the Maori Garden he constructed G+4 building.
So you want some flat which is equivalent in valuation to that 92.
Yes. And secondly, 84 valuation is more or less. It is inside the Rakalsadi road. They should have to increase the share.
Let us see the Supreme Court order. What was
Yeah.
the directive of the Supreme? Let us see what you agreed with the Supreme Court.
Wanting more compensation, let him say it.
You give him an accommodation
Yes.
somewhere else. Equivalent
No, but then I'll have to build it and I'll give him somewhere else. I'll build it in this new 84 and give him in there. That's my offer to him. That's my prayer, alternative
You
prayer.
build it in 84.
84.
Till then, what happens to them?
No, we will. That's point number one. He agreed. We will put him in suitable accommodation wherever he wants. We will pay his rent. But because of these two persons, it's the entire thing has been stuck, and I can't even demarcate for the other, which is the second part of the Supreme Court order. I have to demarcate and give that. The Priya Dutt, she succeeded in getting her portion out of the partition deed, partition arrangement, and she has also passed away. Her. And where they stay is a very old building. I'll have to demolish it. That's point number two. Then I'll build the house and I'll give it.
Mr.
And
Addo,
otherwise,
please.
if he wants somewhere else, if
Yes.
we can accommodate it, 545 square feet.
Mr. Addo, let us come to
Right.
page 69 of the paper book once. Volume 1, 69. Page 69 is the Supreme Court, that narrative, your agreement. Now, see the first paragraph. By way of compensation, the first sentence speaks about compensation, yes. Second sentence starts from the 8th line from the top of para 1. Such compensation shall be paid to the co-sharers according to the respective area in the properties on making over their possession in 27 Chetla and 84 Rakhaladi Road. Next, it is recorded that the respondent number 1 developer is already in possession of portion of building at 27 and 92. Para 2 gives you a right that the co-sharers who are in possession of the building at 84, it covers you and him, shall hand over their possession to the respondent number 1 developer. Now comes the click. At the time of handing over the flats in proposed buildings to be built on 27 and 92 within 3 months of completion of construction of new buildings, right? So meanwhile, the respondent number 1 shall be entitled to apply. Now what happens is they will have to hand over flats in 27 and 92. So 27 was also included in the Supreme Court order.
Yes.
So they had an option to offer either 27 or 92 to you. They have offered 27, you say 92 is better, I'll go there. But they have a right to implement, they have a right to say that as per the Supreme Court order, they can offer even 27 also, beside that Maruti storeroom. So, but you refuse to take that position.
No, my lord, he always saying he refused. He did not give any letter to me. I again and again visit to
There
the
were so many meetings between you and the receiver.
meetings, but she already want to going to against the Supreme meetings held, always trying to
No,
get.
but Mr. Addo, you have stated in your affidavit, your affidavit says that you did not go, you refused because that was a better plot. 92 was a better flat.
Yes.
But you did not have that option as per the Supreme Court direction. If you look at the Supreme Court direction, Supreme Court recorded that they agreed to give you possession either in 27 or 92.
Yes.
So wherever they give you possession, it has to be within 27 and 92. You had no right to refuse 27.
No, no.
So, but you refused on the ground that 92 is better. They did have the right to give you a lesser flat also.
When I refused, when the application made in the single bank, they want to give me flat in the 78, 80 Rakhalasa Road, which is built second-hand flat, and in 96, 13 years old. Then I said that when they said in the court that I want to give him 27 Rakhalasa Road, but he refused, but then I didn't it. They want to give me a letter. Whenever I go to the office, they always said, go to the court, go to the court. They give me no letter to give me the letter to.
In your affidavit, where have you
You are
stated?
going to 27.
Let us come to that second-hand allegation of yours. Where is that, Mr. Ghosh? Second-hand allegation. Let us look at page 103. 303 we have, yes.
When it's held in the court, then I didn't it. I know, but they did not give it. I want to discuss with them and go to the office, but they always said go to the court because they are always made agreement to the receiver and the developer.
So second-hand flat, page 102, 103.
There were agreement between the developer and the receiver is done 1991.
Yes, 108.
108 bottom, 13 years old building. This is something, this is another property.
Oh no, that is in a different property.
That is in a different, but in 300.
But they say you never gave them any, offered them any flat at 27. They've never admitted that you ever gave them any flat at 27. They don't
If
say that.
offer later come, I will go. They do not-
You say that they never
say-
offered you a flat at 27 or
No,
19.
no. After when the case is going on in the Sogoto, then he said, "I give me the." I offered him flat in 27. Then I read it in the 27 is low, not precious. This was precious. Then I have written. They do not get any letter. Always go to court. Go to court.
After that, ultimately they gave you 27. After they offered you a flat at 27.
Have 92 or 27, anyone can offer me. But
They
do
had
not
offered you.
no, offer no. Do
They
not offer.
never offered you any flat at either 92 or 27.
No. Agam directly in 78 and 80.
78 is a different property.
Huh.
They cannot compel
No,
you.
no, they did not give
They
any
never
letter.
offered you any flat at 27 or 92 according to
No,
you.
yes.
Then
Though I know. So I go to his office. But always go
so
to
that we understand. That we understand.
and the agreement is done in 1991 and during 99 to 2006 2006 they
Sir Addo, you can speak in Bengali if you like. Mr. Justice Kant, my learned brother, can understand if you speak.
yes.
He will be able to manage.
আচ্ছা।
Or I can translate for him. But the relevant portion,
এই 2006 অবধি 91 থেকে 2006 অবধি ওনারা 325 টাকা স্কয়ার ফিট হিসেবে কোষাদের কাছ থেকে ফ্ল্যাট
that's a different proposition. They are developers, or a developer, or a earn করতে
they
পারে।
are fast okay fast they were all frustrated in during the
We are concerned with only one aspect. একটা জিনিসই আমরা চিন্তিত, সেটা হচ্ছে সুপ্রিম কোর্টের অর্ডার ছিল যে 27 অথবা 92 তে আপনাকে ফ্ল্যাট অফার করতে হবে আপনাদের দুজনকে।
হ্যাঁ।
আপনাকে কি কোনো সময় 27 বা 92 তে কোনো ফ্ল্যাট অফার করা হয়েছিল?
না করা হয়নি
This much. You agree with that? What is your version?
The affidavits are very similar to each other. 7A and
So you have to agree. I mean,
Yes,
27, we don't find any admission on your part that 27 or 92 was offered to you.
admission that something was offered, but
78 by 80, we are not bothered.
it's
That's
not
a different
27
thing.
or 19. There is no clear admission.
303,
Yes.
says, but they were going to allot flat in ordinary G+4 building beside Maruti Repair. He has said it, and that's why I've said that. Page 303. They wanted the luxurious flats in the 11-story building. We offered in the 4. They've said that.
Yes,
yes I want it
But
okay
now I'm এখন জজের ইস্যুতে এখন
হ্যাঁ,
কি
এখন-
চান কি করে
Mr. Addo, they offered you at 27.
Yes.
You have admitted that in your review.
no offer no offer
Page 303, come to that. Page
That
303.
I have written no letter is given no
You have written, you have admitted.
I have admitted
You have admitted you cannot resile from that.
no
You
no
cannot
I,
change that.
I know
So they offered you at 27. You said it's beside Maruti
I
showroom.
know
and-
we're going to 27 but they did not I will go to for discuss কথা বলতে গেছি কিন্তু ওনার সবচেয়ে কোর্টে যান বলেছেন আমাকে ডিসকাসই করতে দেননি
ডিসকাস না, আপনাকে 27 এ যদি ফ্ল্যাট অফার করে আপনি নিতে বাধ্য সুপ্রিম কোর্টের অর্ডার অনুযায়ী 27 অথবা 92।
হ্যাঁ আমি তো 92 বলতেই পারি যে
না,
আমাকে
92 আপনি ইনসিস্ট করতে পারেন না যে 92 তেই নেবো, 27 এ নেবো না। আমরা বলছি না, সুপ্রিম কোর্টে অর্ডার রয়েছে হয় 27 নয় 92 তে ইউ ক্যান বি অফার্ড।
হ্যাঁ সে তো বলছেনই
তো 27 অফার করেছে, আপনি নেননি, এখন আপনাকে তো তাহলে ছেড়ে দিতে হবে। তাহলে অল্টারনেটিভ অ্যাকোমোডেশন ওরা অফার করছে অন্য জায়গায় নিন। কারণ আপনি কিন্তু 27 এ আপনি অ্যাডমিট করছেন 27 এ নিয়ে দিয়েছিল ওরা ফ্ল্যাট। দে অফার্ড ইউ আ ফ্ল্যাট ইন 27, বাট ইউ সেড দ্যাট ইট ওয়াজ বিসাইড দি মারুতি রিপেয়ারিং শপ, therefore you did not take it, and they were giving others better flats.
হ্যাঁ
may-
হ্যাঁ
they may.
সেখানটা ভুল হয়েছে যেহেতু কোর্টে উনি বলেছেন তাই জন্য আমি এই কথাটা লিখেছি এখানে তাই জন্য এই কথাটা আমি কোর্টে বলেছি তখন লাস্ট অর্ডার
But can
কোর্ট
we just
দিয়েছেন
because they say that
এই যে
they were offered at 27.
লাস্ট অর্ডারটা দেখুন
Either 27 or 90. You either agree to an alternative accommodation, whatever is given to you, or you agree to compensation. And this applies to you also.
Please,
Agree to
last
compensation.
order, T46 in the third volume.
346.
In the third volume.
Yes, 346. Yes, we are there. Yes, 346.
Yeah. Is the this was last second paragraph.
Korun.
That direction was reflected in the order of court dated 14 July 23 that the present petitioner proposed in the guise of amendment. However, Court of Order 20 July 2023 is modification in disguise of the order of the Supreme Court of India. There is no provision in this scheme that the defendant number 7A and 7B shall be allotted in 94 Rakhalda Road. The road. So the application is therefore dismissed. The cost of 25,000 payable to each defendant number 7 and 7B. The amount of cost shall be deposited in the learned receiver to 7 days.
Mr. Addo, আপনি যেটা বুঝতে পারছেন না সেটা
Please cooperate, Mr. Sir.
Hmm.
The learned receiver shall submit the report whether the compliance order is Supreme Court or not. Second page, 347. The court July is complied or not. Also, whether the cost of director has been deposited with him or not. The developer and the present petitioner is liberty to approach in the Supreme Court or Court of India for modification and clarification of the order. If any type of clarification of the Supreme Court order should be go to the Supreme Court. Justice Shogutman said, I do not cannot এ করতে পারবো না, কোনো অর্ডারটা মডিফাই করতে পারবো না, যে কোনো অর্ডার হোক না কেন আমি সুপ্রিম
সুপ্রিম কোর্টের অর্ডারে মডিফিকেশন এখানে চাওয়া হচ্ছে না। সুপ্রিম কোর্টের অর্ডার যেটা রয়েছে সেটা রয়েছে।
উনি সেটাই করুন যে সুপ্রিম কোর্টের অর্ডারে
সুপ্রিম কোর্টের অর্ডার উনি মডিফাই চাইছেন না, আপনিও চাইছেন না। আপনি তো জাননি মডিফিকেশন চেয়ে, উনিও চাইছেন না। উনি বলছেন সুপ্রিম কোর্টের অর্ডার যেটা রয়েছে অ্যাজ পার দ্যাট অর্ডার ইউ হ্যাড টু টেক আইদার অ্যাট 27 or 92. লেট আস বি ভেরি ক্লিয়ার অন দিস। 27 or 92 আপনি আপনার একটা এফিডেভিট অ্যাডমিট করেছেন 27 was offered, you did not go because you did not like that, you said 92 was better, because therefore you have violated Supreme Court order.
No, there should be in the agreement.
We are not negotiating anything with
No,
you.
no, in the
You have violated the Supreme Court order, then we are entitled to take steps of violation.
In the agreement it is written যে after the plan is sanctioned, this meet a meeting এ বসবে, কে 27 এ নেবে, কে 92 তে নেবে, কে এটা এগ্রিমেন্টে করা হয়েছে, ওনারা এগ্রিমেন্ট মানেননি, সেই এগ্রিমেন্টে সিটিং করেননি।
But may we do this? May
Yes.
we do this, my lord? I can understand.
We'll give them liberty to approach the trial court for seeking your eviction, and we'll record categorically that you have admitted that you have not
Yes.
complied with the order of the Supreme Court because they offered you 27, admittedly you did not shift there.
My lord, for
And
now,
we have
I will-
given you the offer here. If you don't accept, we'll record in our order that you flouted the order of the Supreme Court by not
that's there.
taking that their offer of 27, and therefore they'll be entitled to apply for eviction of your client and him from the
From
premises
84.
without
I-
any compensation
I
now.
fully appreciate, but my lord, what the difficulty I can understand is
Yes.
is whatever flats were offered in 27 or 92 was not to his liking. It was not
Yes.
appropriate enough. So
Yes.
I think, my lord, without taking any instruction from my client, I think, my lord, that is the only grievance. Now, my lord,
Now that cannot be resolved.
now that
If
cannot
that
be
flat is
resolved, flats
sold-
have already been sold.
Yes.
So, my lord, if we can do now, if we can now sit together again and try to make my client understand and him understand that this is the outcome, this is the
Because
consequence
otherwise
that
there's
they'll
no
have to
other
face.
option.
Yes, but I understand that the consequences that they'll have to face.
We'll record an order to that effect, and we can relegate you to mediation if all of you agree.
That was attempted once. but
Mediation, proper
not
mediation.
not
What
formal
my
mediation.
learned friend wants in the conciliation meeting or whatever, I can have a talk with my learned friend. But that my client's apprehension is that we've done this many times
Yes,
since
that has
then.
happened.
So if it is decided, if your lordship points down the agenda that this is the thing, that 545 square feet, I'm assuming that subject to correction now, they are to get 557. Okay, 557 square feet.
Where do we
Now-
get that? 557?
That's the share, the calculation is admitted. Super built up area. Now he's saying it should be carpet area, super built up area, etc. So that, my lord, we are willing to give him in the new flat. He'll have to wait if it is he wants to stay in his own 84.
So you are
Otherwise-
agreeable to give 557 in 84 newly constructed,
Yes,
and for the time being, he will be accommodated somewhere in, and
while we are constructing.
you will bear the rent.
Yes, we will bear.
Fair enough.
And we'll construct the building and then he will get 554 there.
Some timeline should be
Other-
given for
Yes,
constructing.
definitely. That's what happened in as far as the people in 27 also, we accommodated them. Also, the other people who were staying in 84, they went into suitable accommodation, then they shifted back into 27. Only the two brothers, they want to stay there. They've been born there, etc. So they want to stay there. And now they are also, I'm not being able to, I'm in default of the demarcation because I have to demarcate that Priya Datta's area separately and then the rest I will develop. But this is just stuck. I've negotiated with everyone else.
Let us
except them.
once again see your other prayers.
Yes, ABC, page 17,
7.
the Supreme Court. Page 17.
Let us see whether we can allow that. ABC will grant. Because demarcation has
Prayer
to be-
8.
his portion has to be segregated from the other, and the other they can carry on with the thing.
Receiver will demarcate this 5,000 square feet
ABC, all right, that was not dealt with.
and then we will build the wall at our cost and they may be directed to surrender possession. No, C, I don't know what the C actually involves, I think, my A and B, I would say. A and B is for the partition. C would include the
E is that they will surrender their possession and they'll get compensation in lieu of 557 square feet.
so that is E, yes. Yes, 557, we will compensate
But this
them.
3,000 compensation is for the
That is
land.
in that clause 3. What
That
was
was
read in clause 3 was 30% of land value.
Acha.
And in addition, they
Right,
will
right.
get, the people who are not in possession, they will get this
So in
3,000
parity with the others who did not have
Yes.
possession. Yes.
who are getting possession.
ওরা সুপ্রিম কোর্ট পেনাল্টি করেছিল
No.
মানে ডিলে করেছিল বলে
The 30% is the penalty.
No, no, not
Now in the
penalty.
Supreme Court order,
Yes,
on
yes.
page 67, I am only on prayer A and B now. Now
Right, right, right.
for a moment, I'm leaving 7A and 7B. But page 67, 67. Yes. It's a part of the terms of settlement and the order. We have prepared the second last paragraph, third last. We prepared a site plan for the premises. We have shown portion of Priyadat is 5069 square feet. The said portion has got frontage on this thing. Then that portion, next page, partition করতে বলেছে? Yes, in 68. Direct access to Chetla Road, etc. In our opinion, this is not, that's not the part. Oh, sorry. Then page 68 at the bottom, we see no reason not to accept the report of the surveyor. We also notice that all co-sharers have accepted the proposed terms of
Now,
settlement.
Mr. Ghosh, what we find that for the co-sharers who did not have possession, physical possession, they were given an additional right apart from the land. In any event, they're entitled. You will have to pay them that 88 lakh something. Regarding the other part which was given to the people who did not have possession, we'll give something equivalent to them. We can give something
That's
equivalent
the 3,000 rupees per
3,000 rupees per square feet.
But he's getting, I'm offering him the square feet. Then let him say what
You
he
are giving him
wants.
an offer of equivalent to accommodation at
557.
84.
Yes, fully.
Now, if he does not take that offer, we cannot compel him to.
No. So if
We'll
you're-
record that
if
he is
you're
not
settling, let him come to a price if it comes to that. But if he wants this thing, let him have the option to come back to 84 if he wants to, if he's born there, etc. I understand that sentiment. Otherwise, if he's saying that his brothers and all have got a more luxurious
He's
flat,
saying
etc.
precisely that.
So if it's the money, we'll give him the money. This whole project is held up for 500 square feet.
Yes, what do you say?
But I do believe that we should sit together again and if we can make our
Yes,
clients and him
But my
understand.
1 week's
client
time,
is
if you
very
can't.
worried about
1 week's
sitting.
time, but 1 week's time.
আচ্ছা এটা কি সম্ভব যে আমার যে ভ্যালুয়েশনটা অনেক কম হয়ে যাচ্ছে পেছনে 84 রাখালদাস রোডে তার যে আমি পেলাম না তার জন্য কি শেয়ারটাকে বা আমাকে কিছু ইনক্রিজ করা যাবে আমরা দুটো ফ্যামিলি থাকবো কি করে ওই 350
প্রিসাইজলি সেই কারণেই তো আপনাদের মিডিয়েশন করতে বলা হচ্ছে। আপনারা দেখুন যদি
এখন
রিজলভ
ওনারা কতটা
They are
বাড়াবেন তার উপর
entitled
নির্ভর
সেটা
to
কথা বলে
65
দেখুন,
months.
এক সপ্তাহ
It
দিচ্ছি
should be
আপনাদের,
enough
এক
for
সপ্তাহের
65.
মধ্যে যদি না হয় তাহলে হবে না। আপনারা দেখুন মিডিয়েট করতে পারবেন, আমরা একটা অর্ডার রেকর্ড করে দেবো আজকে যে এই সিচুয়েশন আমাদের এই মনে হচ্ছে, এই সার্কামস্ট্যান্সেসে আমরা আপনাদের আরেকবার লাস্ট চান্স দিচ্ছি রিজলভ করার। যদি এক সপ্তাহের মধ্যে না রিজলভ করতে পারেন আমরা অর্ডার পাস করে দেবো, যা মনে করি সেটা করবো।
আর এটা কি 15th না, এটা একটু 15th এর পর দেওয়া যাবে?
হ্যাঁ, আজকে হচ্ছে কত তারিখ? আজ 4 তারিখ। 15th এর পর মানে 18th হচ্ছে, তাহলে আমরা জানুয়ারি মাসেও রাখতে পারি, কিন্তু জানুয়ারি একটা স্পেসিফিক ডেট দেবো আমরা, 8th জানুয়ারি। Mr. Coach, 8th January. But we'll record an order today. We're doing that. The present, all of you can take your seats, please. আপনিও বসুন। The present appeals arise under peculiar circumstances. Full stop. The litigation originally arose in connection with a partition suit between the co-sharers of the subject property at 84. What is that? 84 Rakhal Das Oddi Road. Full stop. 27 and 92 are also included within the hodgepodge.
Yes, 27 and 90.
27 and 92 is plot A,
And 84 is also there. Very well. 84, comma Rakhal Das Addi Road, comma 27, comma Chetla Central Road, and 92, comma Rakhal Das Addi Road. Full stop. Next para. During pendency of the suit, comma, the present appellant stroke developer sought to intervene on the ground that a development agreement had been entered into between the developer as well as the co-sharers of the property. Full stop. The
receiver they took leave on 9th of December 91 was the development agreement.
Acha.
With the leave was given in 1990 to the joint receiver,
between the developer and the joint receiver,
representing all the share.
comma, yes,
May I have your lordship's leave?
yes, between the developer and the co-sharers na kore and the joint receiver who was representing the interest and the estate of the co-sharers. Full stop. Next para. The matter ultimately reached the Supreme Court, where, comma, by an order dated February 26, 2013, passed in civil appeal number 6702 of 2009, comma, the Honorable Supreme Court was pleased to accept terms of settlement between the parties and dispose of the matter in the light of the said settlement. Full stop. Certain salient features of the settlement were that by way of compensation for unavoidable delay in construction of flats, comma, the respondent number 1 stroke developer would pay proportionate share of 30% of the total land value fixed under the agreement, that is rupees 88, 19, 130 to the co-sharers who had not sold stroke exchanged undivided interest in the properties. Full stop. Such compensation was to be paid to the co-sharers according to their respective shares in the properties on making over their possession in 27, Chetla Central Road and 84 Rakhaldas Addi Road, Kolkata, as the case may be. Full stop. It was further recorded that the respondent number 1 stroke developer was already in possession of portion of the building at 27 Chetla Central Road and vacant lands at 27 Chetla Central Road as well as 92, Rakhaldas Addi Road. Full stop. Next para. In clause 2 of the said terms of settlement, comma, it was stated that the co-sharers who were in possession of the building at 84 Rakhaldas Addi Road would hand over their possession to the developer at the time of handing over the flats in proposed buildings to be built on 27 Chetla Central Road and 92 Rakhaldas Addi Road within 3 months of completion of construction of the new buildings. Push up. Next para. Importantly, comma, in clauses 3 and 4 of the said terms, comma, provisions were made respectively for co-sharers who did not have physical possession in any of the properties under the development agreement and those co-sharers who had such possession. Full stop. Clause 3 enumerated that co-sharers having less than 1% interest in the properties not having physical possession and having not sold their undivided interest shall get compensation of proportionate share of 30% of the land value fixed under the agreement to the tune of rupees 88, 19, 130 and also, comma, in lieu of their entitlement in developed super built up space in the building to be constructed, comma, the value of the same at the rate of rupees 3000 per square feet. Full stop. Next para. In terms of clause 4, comma, co-sharers having physical possession would, comma, apart from having the compensation at the rate of 30% of the land value fixed at rupees 88, 19, 130, comma, would also be handed over yes, physical possession in any of the properties. Full stop. Next para. Any of the properties covered by the development agreement. Full stop. Next para. The sticking point arose thereafter, comma, as the developer constructed new buildings at 27 Chetla Central Road and 92 Rakhaldas Addi Road, and, comma, according to the appellant stroke developer, comma, offered flats in the said newly constructed premises to the co-sharers who were in physical possession of 84 Rakhaldas Addi Road. Full stop. Although the other co-sharers agreed, comma, the present respondents being plaintiff being defendant numbers 7 small a within bracket and 7 small b within bracket, big A, very 7 capital A and 7 B in the suit, comma, resisted such efforts on the part of the developer. Full stop. The version of the developer is that the said defendants were offered commensurate accommodation at 27 Chetra Central Road, but the said defendants refused to have the same. Full stop. Next para. The said defendants, comma, in one of their affidavits, comma, which is a part of the paper books, comma, took a stand that the accommodation offered to them at 27 Chetla Central Road was immediately beside a car repair workshop and was nowhere near the flats given to the other co-sharers at 92 Rakhaldas Addi Road, comma, the latter flats being much more luxurious and better in quality. Full stop. Next para. Subsequently, comma, the appellant stroke developer applied before the suit court seeking several reliefs. Full stop. The developer, comma, apart from seeking a direction on the receiver for physical demarcation of 5069 square feet or 7 kata 0 chataks 29 square feet in premises number 84 Rakhaldas Addi Road as per the report accepted by the Honorable Supreme Court, and for appointment of a contractor to build boundary wall at the cost of the developer for the portion so demarcated at premises number 84 Rakhaldas Addi Road, comma, also sought a direction on the beneficiaries of the estate of Bipin Bihari Addi to surrender their possession in premises number 84 Rakhaldas Addi Road to the developer in lieu of the portion demarcated and walled up in premises number 84 Rakhaldas Addi Road. Full stop. Apart from the above reliefs, comma, the developer stroke appellant also sought a direction on defendant numbers 7A and 7B to accept compensation amount as per the Honorable Supreme Court's order and surrender their possession in 84 Rakhaldas Addi Road to the developer in lieu of allotment of flat measuring about 557 square feet on ground plus 4-storied building at amalgamated premises number 78/80 Rakhaldas Addi Road, comma, in the alternative, a direction on the said defendants to surrender their possession in 84 Rakhaldas Addi Road in lieu of compensation amount as per order of the Honorable Supreme Court and value of 557 square feet at the rate of rupees 3000 as per their entitlement. Push up.
তাহলে কি আমরা কি বাড়ি ছেড়ে দিতে হবে?
বসুন বসুন, কোর্ট অর্ডার পাস করছে এখানে,
একটু গন্ডগোল।
এটা গল্প হচ্ছে না আপনার সঙ্গে। Next. The court, comma, the suit court, comma, by the first of the impugned orders. Where are the impugned orders?
First order of 14th July is
Just give us a page.
227.
227. Right?
And the other order, my lord, is at page
Yes.
326.
Yes, yes. First of the impugned orders dated July 14, 2023, comma, recorded the submission of the developer, comma, inter alia, that in terms of the report, the defendant number 7A and 7B were offered two appropriate flats in the newly constructed buildings located at 27 Chetla Central Road and 92 Rakhaldas Oddi Road, but they refused. Full stop. It was further recorded that several meetings were held between the receiver and the defendant numbers 7A and 7B, as well as between the developer and the said defendants, and options were explored and offers made. Full stop. Next para. Ultimately, it was also recorded that learned counsel for the defendant numbers 7A and 7B submitted that if appropriate flats were offered, their clients were ready and willing to accept the same in the newly constructed building at 27, Chetla Central Road and 92 Rakhaldas Oddi Road. Full stop. Next para. Apart from that, comma, certain directions were passed directing the developer to accommodate the defendant number 7A and 7B in suitable accommodation during construction, comma, to initiate demolition work on shifting and or reallocating defendant number 7A and 7B, comma, for the developer to carry out the scheme framed by the Supreme Court dated February 26, 2013 in true letter and spirit under supervision of the learned receiver. Full stop. The receiver was to submit a compliance report after 6 months and the intervener stroke developer to hand over suitable flat to the defendant number 7A and 7B after construction at 27 Chetla Central Road and 92 Rakhaldas Oddi Road. Full stop. Next para. Subsequently, however, comma, the developer sought a modification of the said order. Full stop. It was submitted on behalf of the developer that the intention of the developer was not to offer a flat to defendant number 7A and 7B either at 27 Chetla Central Road or at 92 Rakhaldas Oddi Road, comma, since the newly constructed flats at the said premises had already been handed over in favor of third parties. Full stop. Next para. It is submitted that accordingly, comma, the order of the court be modified and it be recorded that the defendant number 7 and 8 would be temporarily accommodated at alternative premises commensurate with their present accommodation, and after construction of the new building at 84 Rakhaldas or Oddi Road was over, comma, to hand over equivalent flats to the said defendants. Full stop. Next para. However, comma, the learned single judge, comma, by the second impugned order dated February 2, 2024, comma, while dealing with the said modification application bearing GA number 149 of 2023, comma, observed that the direction of the court was reflected in the order dated July 14, 2023, and that the developer stroke petitioner now proposed in the guise of amendment stroke rectification stroke recall of the court's order, modification of the order of the Supreme Court of India. Full stop. It was further observed by the learned single judge that there was no provision in the scheme that the defendant number 7A and 7B shall be allotted flat at 84 Rakhaldas Oddi Road. Full stop. The application was accordingly dismissed with cost of rupees 25,000. Full stop. The receiver was directed to submit a report whether compliance of the order of the Supreme Court as well as of the learned single judge was done, and also whether the cost was deposited with him or not. Full stop. The developer stroke petitioner was given the liberty to approach the Supreme Court for modification and or variation and or clarification of the order and scheme framed dated February 26, 2013. Full stop. Upon hearing learned senior counsel for the appellant, comma, the respondent stroke defendant number 7A appearing in person, and learned counsel for the defendant number 7B, comma, we find that the newly constructed flats at premises number 27 Chetla Central Road and 92 Rakhaldas Oddi Road have already been transferred stroke handed over in favor of third parties, full stop. As such, comma, it would not be pragmatic at this juncture for the defendant number 7 and 8 to insist on being accommodated there. Full stop. Insofar as the compliance of the order of the scheme framed before the Supreme Court is concerned, comma, in paragraph number 7 of his affidavit in opposition, comma, the affidavit in opposition, comma, as appearing at page 287 of the paper book onwards, comma, the defendant number 7A categorically admitted that the developer constructed two buildings, comma, one a G+11 story luxurious building at 92 Rakhaldas Oddi Road, and another a G+4 storied ordinary building at 27 Chetla Central Road beside a Maruti repairing shop. Full stop. It was also admitted there that the developer offered the said defendant stroke were going to allot the defendant number 7A a flat in the ordinary G+4 storied building beside the Maruti repairing shop, where certain other defendants, being numbers 6, 8, and 10 of 84 Rakhaldas Oddi Road, were also allotted. Full stop. Next para. It is stated in the said paragraph that the defendant number 7A and his brother, defendant number 7B, would have to repair their dwelling portion, etc., and that they refused the said offer of being accommodated at 27 Chetla Central Road because better flats were offered at 92 Rakhaldas Oddi Road to other co-sharers. Full stop. Next para. Thus, comma, we find that it is admitted by the defendant number 7A that he was offered a flat at 27 Chetla Central Road but did not take it on certain grounds. Full stop. We find from the scheme framed before the Supreme Court that no option was given to the co-sharers in possession of 84 Rakhaldas Oddi Road between 27 Chetla Central Road and 92 Rakhaldas Oddi Road. Full stop. It was always open for the defendant number 7A and 7B to approach the learned single judge and or the Honorable Supreme Court to seek appropriate orders in the event adequate flats were not offered to them at 27 Chetla Central Road, full stop. However, comma, after having admitted that flats were offered and they did not take it at 27 Chetla Central Road, and in the absence of any option in that regard given to the defendants by the Supreme Court's order, comma, we do not find it rational for the defendant numbers 7A and 7B to insist now to be accommodated, to resile from such position and seek to be accommodated at 27 Chetla Central Road or 92 Rakhaldas Oddi Road. Full stop. Next para. Thus, comma, apparently the remedy open before the developer now is to approach the suit court and seek an eviction of the defendant numbers 7A and 7B subject, comma, however, comma, to them being adequately compensated in lieu of the accommodation already enjoyed by them at 84 Rakhaldas Oddi Road. Full stop. Next para. Insofar as the first three prayers sought in the application before the trial court are concerned, comma, we find that the prayer for demarcation and consequential orders were justified and ought to have been discussed by the learned single judge. Full stop. However, comma, at this juncture, it transpires that there is still scope of amicable settlement between the defendant number 7A and 7B and the developer, since the developer is willing to offer alternative accommodation adequate equivalent to the present accommodation of the defendant number 7A and 7B at 84 Rakhaldas Oddi Road for the time being, and to go ahead with the new construction at 84 Rakhaldas Oddi Road, full stop. Upon such construction being completed at 84 Rakhaldas Oddi Road, comma, the developer is also willing to uh, hand over possession to the defendant number 7A and 7B flats equivalent to their current occupation,
They are now on the whole 557 square feet.
flats equivalent to their entitlement in terms of their shares. Full stop, next para. The developer also offers that the developer would bear the accommodation charges temporarily for the accommodation of the defendant number 7A and 7B at the alternative premises till they are handed over their commensurate accommodations at the newly constructed building at 84 Rakaldas Oddi Road. Full stop, next para. In order for the parties to explore such options and consider the chances of settlement, comma, the matter is adjourned till January 8, 2025. Full stop, next para. It is expected that good sense will prevail and the parties will be able to reach an amicable solution in the light of the observations made above. Full stop. However, comma, it is also made clear that if the parties fail to reach any understanding on such count before the returnable date, comma, the appeals will be taken up for hearing and decided on merits on the next returnable date. Right. We have decided nothing finally, Mr. Ardhur. It's 3 and 4 tax. It's still open for you to argue, to mitigate among yourselves.
allowed to mention the appellate side.
Yes, please.
Application first, collection.
Applications and order for tunes, please hand over. Hearing not now.
Application, my lord, from the city civil court. City civil court.
Yes, yes, absolutely. Applications hand over without even mentioning.
My lord, may I be permitted to mention one matter, my lord?
Yes.
My lord, this matter, my lord, on November, 21st November and last Monday, my lord, I have mentioned this matter and your lordship are allowed for taken up the matter under the hearing to be mentioned, my lord. But the matter
Not
is
appearing.
Not appearing, my lord.
The hand over the slip, এটা আসছে না কেন দেখুন তো।
21 তারিখ করেছিলাম আর লাস্ট সোমবার দিন করেছি।
দেখুন তো কি হচ্ছে। Yes. Please call the list.
Item number 1, I am for the petitioner.
Yes.
In this matter, my lord, it is a
You're for the respondent.
Respondent number 6.
suit.
Yes.
There is 6 responded, my lord. Suit
Yes.
has been filed because
No, respondent. Yes.
the shares of in the name.
Is the microphone on?
Yes, sorry, I have.
Is it on or?
It is
Yes,
since
yes,
on,
please
my
carry
lord. Am I audible, my lord?
Yes, now you're on.
My lord, the petitioners initially it was the name of the Gaylord Industries Limited, and it has held 2,290 shares, and thereafter the name has been changed to the present petitioner Diplo. Now, after the change of the company name, they have applied for the share transfer of the. It has
Yes.
been transferred. The share has been transferred from the certificate had been issued, and it has been through post. It is supposed to come before the petitioner. In the midst,
So, Lyra, you can take your seat, please. Yes. Yes.
in the midst, it has got lost. Thereafter, they have made several correspondence, and thereafter, after filing of the suit, or before
Yes.
filing of the suit, it found that the 1,550 shares has been transferred to the various person. This defendant number 3 to 6 and 3 to 7. 1,550. It was the share was for the 229.
The shares were, you were the owners of the shares.
I was
Shares in some other company.
He started Iron Steel Company.
Starting this.
Yes.
Earlier.
Different,
So then what is the suit for?
suit for declaration that the plaintiff is the owner of 2,290 of share of 10 of each of defendant number.
The shares have already, the names have been transferred.
Transfer thereafter, it is for the physical share. It was supposed to send through post.
So it
to
has
the-
been retransferred in favor of the defendants, no?
Yes, yes, it has got transferred. And thereafter, the original copy, the share supposed to be transferred through the post. In the meantime, it got lost.
Very well. So what is the present?
Present
It was dismissed. The suit was dismissed. Why dismissed?
Because they are saying that we could not prove that there is any fraud, that the
All right.
transfer of the 1,550 shares, which has
Very
already been
So what is this application for?
this application, my lord, because of the 1,515, there is dispute. But court, in the trial court, in the decree, they have mentioned that the 770 share is still in the name of the plaintiff company.
So that will be decided in the appeal.
My lord, that is already decreed. There is no cross appeal. That is in the decree that has been already mentioned.
Yes, in the application, what have you prayed?
The same may be transferred to the different petitioner's company. Duplicate share may be issued.
That is also the subject matter of the appeal. Appeal paper books are ready in the appeal.
Appeal has been ready. Appeal is ready.
Paper books are not filed.
Paper book has been filed. Yes.
Yeah, we submit them.
There is no cross appeal. That is the observation.
What is the can which you are hearing? Appropriate order 8.
Yeah, 8, my lord. Yes.
Let us see the prayer.
What is the order?
The judgment, yes, the relevant portion of the judgment. First of all, let us hear Mr. Lahiri, are you agreeing to this? That this portion was recorded, then we can direct that at least to be transferred. Why not?
Question is, my lord,
Yes.
there is no fine. Court has held that this falls outside the purview of the court's jurisdiction. That is not the subject matter of the suit. Court has held so, my lord.
Achha.
That is found in the order itself.
As in civil court, I mean, civil court does not have jurisdiction.
No. Court says that since the shares are not the subject matter of the suit,
Achha.
those shares were not 740 shares or so. Court has held that they were not the subject matter of the suit.
Achha.
Now, my learned friend says that those shares are to be transferred in her name, since the court has said that this is not the subject matter.
Wait, let us hear them then. We understand. Yes,
That is in the name of the defendant also, plaintiff also.
yes, your Ms. Mukhopadhyay.
Yes, my
Ms.
lord.
Mukhopadhyay, please place the relevant portion.
My lord, page 45 is the decision with reason.
Yes, yes.
And page 45,
Hmm.
my lord, this last two paragraph, the before that, my lord. And there are total, the peerless finance company and those transfer were effected from.
You're reading from?
799,
You're reading from which?
last two paragraphs.
The peerless general. No, you're reading from the middle of a sentence.
Middle of the paragraph, my lord, because
Middle
that
of a
is
sentence, yeah, and the peerless. Further fact is the start of that sentence.
further facts that the present suit is filed on 1st of April 1905, but after receipt of the injunction order passed by the court dated 4th of April 95, started share registry limited informed Deepak Finance that the disputed share had been sold and transferred in the name of the transferee as per the list after the injunction.
Hmm.
Govardhan Das Kejriwal, Unit Trust of India, Atul Lokhandwal, the Peerless India Finance Limited, and those transfer were effected from 8th July 94, 2nd June 94, 16 January 95, and 8th July 94. And these are total 1,550 shares, which are subject matter of the suit. And the facts remain that the balance share of the stand in the name of Deepak Finance Private Limited, which is not subject matter of the suit. But my prayer was for to transfer the ownership. If my lord come to the plaint, my lord, my prayer was.
If that is not the subject matter of the suit, then how can you pass directions in that? Even the trial court could not pass directions.
No, my lord. May I place the prayer of the plaint? Page 37 is the, my lord, prayer of the plaint. The plaintiff is the owner of 2,290.
Acha, that is those 1550 plus those 700.
740 shares of rupees 10. And for permanent injunction, restraining the defendant number 1 and 2, transferring.
Why does the court say 1550 shares are the subject matter?
My lord, court has not gone, has given, my lord.
What about there's an adjudication on the other 700 something?
700, there is no adjudication. Nobody is claiming, my lord.
If there's no adjudication, how can the appellate court sitting in appeal pass a direction on that?
My lord, there is no cross appeal. Court has already found the record that. And I also prepared for that, my lord. 1 and 2. 1 and 2 has not even participated in the suit, my lord. It has gone ex parte against 1 and 2.
Or you wanted mandatory order directing them to retransfer 1550 shares.
That is one.
And regarding 740, you want issuance of duplicates.
Yes.
So why do you need a court order for that? You can do that, get that duplicate. You are still the owner of those.
Yes, my lord. That is what I'm praying for, my lord. The duplicate share may be issued to in my name only. They cannot have objection because they are not the owner of that. In the suit,
Mukhopadhyay, only when you decide the appeal, we can pass that. We can remand it to that limited extent. That has to be decided. You say that those are standing in your name.
That has also.
But court has not entered into that at all.
No,
Said that.
Court has also expressed that.
Where is that?
Page 45, my lord.
45, the balance share stand in the name of, stand in the name.
Yes, that is the degree. The court has found that.
So you want this portion of the degree to be granted?
Yes, my lord.
But that would be pre-deciding a portion of the appeal.
That is, my lord, the portion that court has already accepted by my prayer, my lord, my claim, my lord. And there is no cross appeal as well.
So you can do that.
And there is no one, my
That
lord.
direction and restrict the appeal to the 1550 shares. Yes, Mr. Lahiri, what do you say? The court's finding is very clear. There is no cross objection. She is right on that. No cross objection, and you don't those stand in the name of Deepak. That's, I mean, found in the judgment itself. So let them have a issuance of duplicate.
The question is, my lord, the case that was made out in the plaint was that, my lord, they wanted to have the shares, entire 2,290 shares or so, transferred in their name. And with that Indian view, my lord, they send the transfer clips. My lord, all these arose in the pre-demat days, my lord, when the shares were held.
No,
in the
Mr.
physical
Lahiri,
form.
they played at page 37.
Yeah.
They say they are the owner of 2290 equity shares. And then, as in clause relief C, as rightly pointed out by my learned brother, that is for mandatory order directing retransfer of those 1550 and only issuance of duplicates regarding 740.
But regarding that, Milord, there
And
is
court
no,
says that the balance shares stand in the name of them.
Milord, there is no, Milord, that is in the course of, Milord, the court recording the submissions of the parties. But Milord, if the lordship comes to the ordering portion, there is no reflection of this in the ordering portion. Lordship, when it looks at the decretal portion, Milord,
That is only regarding the.
the ordering portion in terms of
Yes,
which-
dismissed on contest means you say that it's a deemed dismissal of the first prayer also.
It's not
That they're the owners of those.
against 2 and 1 and 2.
and moreover, Milord, if they're not subject matter of the suit itself, then Milord, how at the appellate stage they can seek a direction, which goes to Milord the
One prayer is
question of determination of
omnibus prayer. They say they are the owner of these two documents also. But say that the
Duplicate.
no, not duplicate. The ordering portion of the judgment is contrary to its finding insofar as those rest of the shares are concerned, 700 something.
Yes.
But then also, if you have to do that, we have to modify the decree to that extent and say that 770 or whatever those shares.
In concert with defendant number 1 and 2. 1 and 2 never represented the suit in the trial court, my lord, in the lower court.
Even then, it's binding on them.
There is no finding.
What
of
no
the
finding?
trial court that
No, finding it is contrary to the, because by virtue of the judgment, court has dismissed the suit in its entirety. Therefore, also dismiss your prayer A.
prayer A and
We
prayer
can say at the time of hearing of the appeal that yes, prayer, this dismissal is contrary to the finding regarding those 770 shares.
But my lord, right now,
Pick up the application along with the appeal. We'll fix the appeal for hearing week after next. Let us hear out the appeal itself. Yes, a week after next, because then the
week after next.
week. Yes, today we are on 4th, so we'll keep it on 16th of December.
16th,
18th of December.
18th,
18th or 19th. 18th, 19th December.
19th.
No, 18th we take up original side matters, but we can keep it on 18th, but we can whatever you say. 18th. 18th will keep it. Right. The present application for appropriate orders has been filed on the premise of a finding of the learned trial judge in the judgment and decree impugned in the appeal to the extent that the balance shares out of the total 2290 equity shares regarding which the suit have been filed, comma, apart from total 1550 shares, comma, are not the subject matter of the suit. Push up. In the impugned judgment, comma, the learned trial judge found that total 1550 shares are the subject matter of the suit, and the balance shares within bracket out of the 2290 shares bracket close stand in the name of the plaintiff stroke appellant and is not the subject matter of the suit. Full stop. However, comma, ultimately the learned trial judge went on to dismiss the entire suit, comma, thereby refusing the declaration of the plaintiff's ownership regarding all the 2290 shares as well as prayer C. Huh? which sought issuance of duplicates of the remaining 740 shares in favor of the plaintiff. Push up next para. No, not now. We find from the ordering portion of the impugned judgment that the learned trial judge dismissed on contest the suit as against the contesting defendants and ex parte against the non-contesting defendants without any order as to cost. Pushed up. Dismissal of the suit as a whole might have been unjustified in the light of the observation on the in the earlier part of the judgment that the subject matter of the suit is only the 1550 shares spoken about in the judgment. However, fact remains that by virtue of dismissal of the suit as a whole, all the reliefs sought by the plaintiff have been turned down. Next para. Although the appellant has a point in arguing that the said dismissal of the suit as a whole, at least insofar as the balance 740 shares are concerned, is bad in law and contrary to the finding that the plaintiff has failed to prove its claim only over the disputed 1550 shares, in the event the present application is allowed, the effect will be to modify the impugned degree to the extent of the balance shares. Next para. Such an order, if passed at this juncture, would prematurely decide a portion of the appeal itself. Accordingly, we are inclined to keep the present application alive and place it for hearing along with the main appeal itself. Accordingly, Can 8 of 2024 shall be listed along with the appeal for hearing on December 18, 2024.
The affidavit in opposition has been filed. The allegations.
Since no affidavits have been invited, it is deemed that the allegations made in the application are not admitted by the respondent. The first thing we'll do, Mr. Lahiri, when you take up the appeal is modify this portion. We'll hear you on the rest. We have made the observations very clear, and we have finally held that this is contrary to the findings.
Since the order is concluded, may I point one difficulty?
Yes, Mr. Lahiri. Yes.
Prayers will learn it. Question is, my lord, she has said 740 shares. Now, out of this 1,550 shares, 900 shares have been sold to my client, and some of the shares have been sold to Peerless Insurance Company. Some of the shares have been sold to Unit Trust of India.
That is within that 1550.
1550. Now, he has said 740 shares.
No, she says the balance 740.
Balance without.
No, that will specify.
Without indicating the distinctive numbers. Now, if a blanket order is obtained, 740 shares, my lord, that may cause difficulty because nobody knows which shares he is claiming.
The plaintiff must have said something. Yes, plaintiff distinguishes. No.
Not
all right.
Not separately, my lord, not separately indicated.
Schedule A, yes.
It has got to be counter-checked and found to be correct.
No, 1550, these are the 1550 shares.
1550 shares.
But those 740, remaining 740 have not specified anywhere. In the body of the plaintiff have stated the details. Otherwise, how can we? No, we can make it clear, Mr. Lahiri, that apart from the Schedule A shares, the other 740. But those 740 have to.
Got to be.
What are the 2290 have said? 740, you say you are the.
The numbers is there.
Page 39, the numbers only covered by those 1550.
Yes, so the rest, whatever it.
What are the rest? What are the numbers of the shares? We cannot give a plus of.
In the my lord.
In the plaint, is there in description? Those shares have to be enumerated. These are the shares. Otherwise, how can a civil court grant you a decree even? Even if you direct issuance of duplicates, we have to enumerate the shares, the exact shares. You have not specified either in the schedule or in the body. 1550 you have said. What is your averment on that? It's very cryptic.
Connection D.
2290 pairing distinctive numbers, all right. In pair 2. We have to look into that then. Because otherwise the plain schedule does not contain. No, you have not done that now. Yes, but yes.
Let me check the my lord.
Even the course of hearing, my lord,
Which 740 that has to be clarified because this has been repeated in the solution. Yes, what is it?
my lord, the problem is my learned friend's own creation. They should have been more careful.
Yes,
in
yes,
sending
absolutely.
the
We agree with that.
back.
We agree with
Question
that.
is, my lord, if a learned friend, my lord, would come out with the distinctive numbers of the shares, 7 and 40 or whatever it is, in a separate sheet, my lord, give it to ourselves. And
There is
then, my
another
lord,
difficulty, Mr. Lai. The court says that those are not the subject matter of this
in
suit.
that case, my lord, your lordship,
But if you find, I mean, that
falls beyond the adjudication.
no, there is another difficulty. If those have been transferred now, because the parties were not hard on that at all. There is no
Nobody knows
adjudication.
who is the actual owner of
We are
the
in
share.
doubt whether it should be remanded then for those 740
That's-
with a leave to them to amend the plaint by introducing the numbers because those numbers are not before any of the courts.
This is the difficulty.
740 in thin air, we cannot pass a
In
degree.
here, just a blanket, my lord, number.
Blanket, then we'll have to pass the degree as the trial code now for the first time.
That is so.
Because it may be, suppose those 740 shares now stand in the name of some third party. They are necessary parties then.
It is long ago, my lord, 1995.
Exactly. We never know what are those shares. It's a vague, I mean, there's no description at all of those 740 shares. In your plaint, we cannot look beyond the pleadings. That will be another difficulty you'll face. Anyway, let us see. Thank you, Mr. Lairi, for that pointing out. You have to think about that. At the best, we could probably permit you to amend the plaint by giving the details of the shares and remand that portion to the trial court, unless we hold in your favor regarding this 1550.
That will, my lord, anyhow to my learned friend's benefit, my lord. His suggestion. Anyhow to her benefit also.
Yes, but now she cannot do anything
Now, of
also
course, at this stage,
unless it's remanded to the because there's no adjudication on that at all.
no adjudication.
What 740 shares? I mean, that may belong to some third party.
Exhibit.
No adjudication.
Only given number, and we cannot look into the proofs beyond the. No, we cannot look into exhibits if it is not in the pleadings. That's the difficulty. Variance between pleading and proof. Then
No adjudication, but the court did not
there's
have
not a
the
line of pleading on the details of those 740.
no particulars were given, my lord.
We'll look into the cause of action. The plaintiff is very cryptic on that. At least those 7. Let us see. Look into that when we take up the hearing. So we have just postponed the trouble.
Yes.
Yes.
Affidavit of service maybe.
Evidence service filed to be kept on. Yes.
IP number.
Two of the applications are not here. 4 and
But,
5.
3 applications, my lord.
The rest are here.
3, 4, 5,
আজকে
6.
অনেক বেটার কাজ হয়েছে থ্যাংক ইউ এইটাই চাইছি আমরা কোনটা নেই কোনটা পাওয়া যায়নি আর দেখুন হ্যাঁ হ্যাঁ আপনার অর্ধেক প্রবলেম হচ্ছে স্ট্যাম্প রিপোর্টের থেকে ভুলভাল পাঠাচ্ছে ডিপার্টমেন্ট থেকে সেটা আমরা জানি কোনটা আপনি যখন নেবেন আপনি একটু জাস্ট সেরকম জাস্ট দেখে দেবেন না না তো হয়েছে ইয়েস ইয়েস মিস্টার ভট্টাচার্য
But except Milord, this is Milord a transfer brief to my junior Milord. Except can 6 Milord, I don't have anything Milord. Only
you are the petitioner
I'm the petition.
why did you mention then
Milord can 6.
you had mentioned can 6 can 6 is before us
Only 6 was mentioned last occasion.
very well can 6 is before
Recently
us
it has come before the.
right can 6 is before us we can decide can 6 then
Milord,
you are for the respondent
Well, I'm for the respondent. Here with.
yes please.
I'm the judgment debtor Milord and appellant. Now, Milord, the suit for Milord recovery of khas position. Milord, if your lordship would kind enough to come to Milord page 10 of the application. The stay initially, Milord, stay was granted. If your lordship would kindly come to page 12, the relevant portion, Milord. Considering all aspects of the matter, we are of the view that the impugned judgment and decree must be set subject to the condition that the appellant shall deposit 20,000 rupees per month in the executing court till title execution case number 32 of 2013. The amount shall be deposited by the 10th of every month. Any two installments in depositing the amount with the stipulated time will result in the stay being vacated. Meaning on this Millard ground or condition, Millard, there was a stay of the execution case. Now, Millard, problem is we were paying. Now, Millard, COVID intervened and there was a demise in the family. Now, Millard, we could not pay, Millard, from March 2022 to February 2021. Now, Millard, we filed an application to that effect, Millard, which was, Millard, allowed by the learned trial judge. Now, Millard, if your lordship would kind enough to come to page 15. Page 15. Millard, this was allowed. Now, Millard, 5,20,000 rupees, Millard, as area, we were directed to be paid. Now, Millard, as I placed the Millard, the order of the Honorable Division Bench, it was Millard directed to be deposited before the executing court. But for this amount, Millard, good, bad, indifferent, Millard, we have tendered it to the Millard degree holders. They have accepted it, Millard, without prejudice, they have accepted it. Now, Millard, the problem is, Millard, after this, Millard, we also Millard wanted to tender it to the Millard the degree holders, Millard, but they refused to accept, Millard. That's why, Millard, an application was filed under section 151 before the Millard learned executing court. Millard, application. Millard, this is not annexed with the application, Millard. Extremely sorry, this application was filed before the learned executing court, on which, Millard, the present order has been passed.
That would be a modification of the High Court's order.
Millard, they have accepted it without prejudice.
Only that lump sum they have accepted. After that,
Yes.
they are not
No,
accepted.
after that, Millard, since we could not, Millard, show the previous.
No, we can now modify this order. That is a separate chapter altogether. But what happened after they refused the?
No, the department of the Millard City Civil Court is not accepting, since we could not show, Millard, the previous receipts. If your lordship would kind enough to page 17 of the application, we are ready with the Millard amount. Yes. তখনকার এখন তো আরো
Court finds that there was no endeavor on your part to pay the occupation charges since June 2022
Yes.
till filing of the petition.
Yes, kindly, Millard, comes.
Then
to,
you are habitually defaulting.
No,
Yes,
kindly
yes.
comes to Millard page 14. Our demand draft was ready, Millard, as on that day also. 3,80,000, it was due as on that day when we filed the application. Kindly see, Millard, 29 December 2023.
Why 3,80,000? You have to pay 20,000 per month.
Yes.
Your initial problem was regarding March 2020 to February 2021, which you are permitted. What happened after February 2021 till March 2021?
Till filing of this application, it was 3,80,000.
Why didn't you pay every month?
3,80,000 department is not accepting.
You should have immediately approached the department, the trial court.
Millard,
You did not pay for so long.
That is there. Millard, after that, Millard, we are.
You could very well. What is the date of the check? December
29 December 2023.
Then there is no contemporaneous demand draft to show that you had drawn a draft and tendered.
Millard, but Millard,
No.
as of today, Millard,
Why should it be
Millard, we are ready with the amount, Millard. As of today, with current, I have taken instruction, Millard, we can deposit it, Millard.
Your stay has stood vacated.
Okay, that is true, Millard. But
Let them
appeal
execute.
is pending, Millard. That is the kindly, Millard, gives me one chance.
Then you'll have to pay interest on that, Mr. Bhattacharya. We have not yet heard them. We are not closing our minds. But then you have to pay interest on the defaulted amount. Because you have not paid since.
Yes.
In fact, the COVID period we can appreciate up to up to February 2021. We can think about that. But after that,
they have also accepted, Millard.
no, they have accepted without prejudice, and that the trial court could not change the order of the High Court.
No, High
In
Court
spite of their acceptance, Mr. Bhattacharya, it may be said, argued by them that you have defaulted in so far. But that's a technical objection. We may brush that aside. But what happened after from March 2021 onwards for this 1 year?
they will be Milord interested in occupation charges, Milord. Milord,
They are interested. Why shouldn't they be?
I'll Milord pay. Milord.
20,000 per month plus you have to pay interest on that amount then for this till the date of payment.
Milord, that amount, Milord, is ready, Milord, and up to that till current.
Yes, let us hear Mr. Chatterjee. Yes.
Now, my lord, the order which is, my lord, before passed by the honorable division bench is that, my lord, they have to deposit before the court bill.
Executing code, yes.
Now, my lord, first default is, my lord, they are not depositing with the court below. In the COVID interregnum period, my lord, we showed our bona fide as because COVID was there, we accepted the money without even interest, calling for interest. But, my lord, after that, my lord, he waits, my lord, not paying for a month. My lord, he takes a substantial period of 12 months or, my lord, 6 months without approaching the court for depositing, my lord. He again, my lord, draws a draft, my lord, and approaches us. We refuse. We will not accept now because the order was to deposit before the court month by month. And, my lord, any 2 months consecutive default, my lord, the interim order would be stand
No, after the February 2021, they tendered to you.
Yes, my lord, till, my lord.
But you have been consistently refusing.
Yes. Now, my lord, what happened, my lord, in this default, my lord, he is violating the order since long in not depositing the amount before the court. Now, my lord, what he is trying to do is, my lord, when we have police help allowed, as the interim order stood vacated and the date for only next date is for depositing of the police cost, my lord, he takes out this application in 23rd of April 2024.
9 December.
Well, this application as per the, my lord, CIS system, my lord, I find this CAN 6 is taken on 23rd of April 2024. And, my lord, his default stands, my lord, from June 2022.
Not only that, before that also.
And in the meantime, we have proceeded in the court, my lord, for the default to proceed with the execution at a stage where police help stands allowed.
Mr. Chatterjee, if the degree is executed, nothing remains in the appeal.
I mean, it's an eviction
Money,
decree on an influx
compensation-
of time. Lease on influx of time.
Not only
And, my
that,
lord, he is enjoying, my lord, a property which is of more than 10 kathas, no? 10 kathas. Well, it's an entire plot of land.
What is the stage of the appeal? Paperbooks have been filed by them.
My lord, I think, my lord, they have not even complied with that.
they are not compliant.
Direction was upon them.
That advance. My lord, in addition to that, I am.
No, both
one
of you
thing
cannot
is-
argue together.
One
Both
thing,
of you cannot argue
yes,
together.
yes.
One of you argue.
On 19th ওরা জাজমেন্ট ডেটার মারা গিয়েছিল বলে আবার একটা অ্যালাউ করেছিল।
My lord, in 2000, my lord, friend, my lord, says, my lord, in 2009,
Pay some more amount of
থার্ড টাইম ডিফল্ট
interest.
বারবার ডিফল্ট হয়েছে।
Yes,
my
Mr.
lord, even in 2019, pre-COVID, my lord, situation, they defaulted. And, my lord, trial court took cognizance of that. And, my lord, this was done, my lord, because, my lord, one of the respondent died. My lord, for death of respondent, he did not deposit in the court. So, my lord, court said that very well, you deposit upon being substituted respondent or, my lord, plaintiff, you pay.
That chapter
pay
is
to-
over.
That chapter is over. So, my lord, this is the third time they are consecutively defaulting. It's not one time.
Judge will direct interest to be paid. And now the arrears is from from March 2021 till date.
So, my lord, then areas, my lord, directs areas, my lord, interest. My lord, March 2020, they are without paying the amount, my lord, in with interest.
No, we won't grant interest for the period accepted by during the COVID period also.
So it will be
Not-
from Milord June 2022.
June 20.
Why? After from March 20,
Yes, kindly.
March 2020, they have paid to April
March 2020 to April 2020.
2022.
Then
So then May,
from May.
May 2022 till date.
May was
Pay the arrears at one go by this Friday. You are ready with the amount. All the arrears. No further lenience on that. And then interest will give you some time. Interest on that at the rate of 50%. What should be a reasonable interest?
My lord, at least at the fixed deposit.
What old lady? Radhakanta ji.
No,
Oh, Radhakanta is there.
yeah.
In then.
Milord, within fortnight, Milord, the admitted areas, Milord, and
Not for that. By this Friday, you will pay the admitted rate.
10 days. 10 days.
This Friday, 3 days.
The 3 lakh 80 is
10 minus 7. And what about the What should be the rate of interest? Go on, you say what? What should be the rate of, what is the bank prevailing?
FD rate, my lord, senior citizen account would be 8.75%.
No, she gets as a senior citizen. You are not a senior citizen. Radhakanto ji is eternal.
My lord, minor account, my lord, more interest.
Eternal minor. No. The at say 6% per annum. The present application has been filed by the appellant.
Before your lordship starts, my lord, instead of Friday, let it be till Monday.
By the appellant in an appeal which has been preferred against an eviction decree. Whose sub next para, learned counsel for the appellant stroke petitioner submits that initially on June 8, 2015, the eviction decree, the impugned eviction decree was stayed subject to payment of rupees 20,000 per month as occupation charges by the appellant to the respondents. Whose sub next para, it was also recorded in the said order that in case of any two defaults in depositing the amount within the stipulated time, the stay would stand vacated. Whose sub next para, it is submitted that during the COVID period, for the months of March 2020 till February 2021, till March 2021 then.
March 2020 to April 2022, my lord, we have received the amount.
From May 2022
And
to
May
current
20.
months.
No, you filed an application for initially you said from March 2020 till February 2021.
My lord, the application.
You said that from March 2020 till February 2021, you had not deposited, you paid this amount directly to them.
No,
Yes.
that's up to, my lord, April, subject to correction.
April
That's why
2021.
2022, my lord,
April 2022.
he missed it, my lord, it's not 2021.
One,
Very
it
well.
will be
From March 2020 till April 2022,
May 20
And May by bank draft.
by bank draft.
what May?
For the month of May, my lord, he paid a bank draft, not directly to us, but a bank.
March 2020 till,
April 2022 directly to us.
yes,
And my lord, for the month of May 2022, he issued a bank draft.
Bank.
to you.
Yes.
Okay, sentence ki bolo?
Eight of
Please,
application.
yes.
It is submitted that during the COVID period,
During the COVID period, from March 2020 till April 2022, the occupation charges could not be paid by the appellant due to the pandemic situation. Full stop. Next para, however, the entire amount for the said period was subsequently tendered directly to the respondent and was accepted by the respondent without prejudice to their rights and conditions in the appeal. Full stop. Next para, the payment for the month of May 2022 was tendered by way of a bank draft. You did not accept that,
No, I accepted.
which was also accepted by the respondent stroke landlords. Full stop. Next para, however, subsequently when the appellant sought to tender the occupation charges, the respondents refused to accept the same. Full stop. Next para, when the appellants attempted to deposit the said amount in the court below, the same was also not accepted since the appellant could not show the previous payments for the interregnum period before the trial court. Full stop. Next para, before the executing court. Full stop. Next para, it is submitted that although the initial direction was for the appellant to deposit the occupation charges in connection with the execution case before the executing court, since the respondents accepted the interregnum payments, the subsequent payments also are required to be permitted to be made. Full stop. Next para, it is contended that the appellant is otherwise ready to pay the entire arrears to the respondent. Full stop. Next para, learned counsel for the respondents opposes the prayer and submits that the appellant is a habitual defaulter. Full stop. Even prior to the pandemic period, on certain occasions, defaults were made in view of the demise of the original appellant. Full stop. Next para, that apart, the acceptance of the amount tendered to the appellant was without prejudice, tendered to the respondent was without prejudice to the rights of the respondents. Full stop. It is thus contended that the present application should be dismissed, comma, all the more because the present application was prompted only by the action taken by the respondent stroke decree holders by initiating police help application before the executing court. Push up next para. Upon hearing learned counsel for the parties, comma, we find that the non-payment during the pandemic period having been pandemic period and till the month of May 2022 having been accepted by the respondents, comma, we ought not to impose any further interest on the said amount. However, comma, it would be inappropriate in a sense if the uh, the contentions raised by the appellant in the second appeal are rendered infructuous for the technical reason of non-payment of the occupation charges, comma, particularly in view of the second appeal having already.
First appeal, this is the first.
Oh, this is the first appeal. First appeal. Particularly in view of the first appeal being, it is not also ready for hearing.
Not ready for. Well, that's why my lord.
Particularly the full step. Next para. Upon considering the balance of convenience of the parties, comma, we are of the opinion that the purpose of justice would be subserved if the appellant is directed to pay the entire arrears till the month of December 2024 to the respondents. Pay na kore. Should they pay directly to you, Mr. Chatterjee, from henceforth? That will be easier for you also instead of withdrawing from.
That would be modifying the order.
We would modify the order to that extent. If you want to, otherwise they can deposit in the executive court. Executive court.
Directly to the respondents.
That would be easier for you to. To the respondents. Last key
He's directed to pay
by different draft.
December 2024 to the respondents.
The respondents, accordingly, can 6th of 2024 is disposed of by directing the respondents, directing the appellant to pay the entire arrears for the period between, from which month?
From June 2022 till December 2024.
Between June 2022 till December 2024 to the respondents directly by way of bank transfer to an account, comma, the particulars of which shall be furnished by the.
Let it be a bank draft because
Bank
transfer, they will say I have not received the account details because they have already
bank
prepared a bank draft which is annexed. So another bank draft would be.
It will be easier for you because if they directly transfer to the bank account.
If they
Let it be a bank account. Are there many respondents? You have a dispute between yourselves.
There are Shebai, so a bank draft in the name of the Jew Thakur would be easier.
Then account is there.
Account is there of the Jew Thakur.
Then to give the account number to be furnished by the respondents within December 5 by tomorrow to be furnished by the December by the respondents to the learned advocate for the appellant by December 5, 2024. Next para, such payment of the entire arrear amount shall be made by December 10, 2024. Next para, insofar as interest is concerned, comma, the appellant shall also pay interest for the entire amount, comma, till the date of payment at the rate of 6% per annum. Such interest shall be paid on or before December 24, 2024 by the self-same mode by way of bank transfer. Next para. Thereafter, comma, the appellant shall continue to deposit the occupation charges of each month by the 10th of the said month, comma, starting from January 10, 2025, comma, by direct transfer to the bank account furnished by the respondents. It is made clear that in the event of even a single default, comma, the interim order of stay shall stand automatically vacated. However, comma, in case the appellant makes the payments as directed above, including the arrears, comma, interest and the current payments for each month, comma, The interim order of stay shall continue till the disposal of the appeal. Full stop. Next para. The appellant shall next para হচ্ছে, in view of appearance of the respondents, you appear for all the respondents. Appearance of the respondents to counsel, comma, service of notice of the appeal on the respondents is dispensed with. Full stop. Records have come, you don't know. The appellant shall put in special messenger costs for bringing the trial court records within a week from date and comply with other formalities also within a week. Full stop. Next para. Upon the appellant shall thereafter prepare.
The earlier direction was in default of putting in special messengers called lower court records be called for in usual manner. That was already a direction there.
No, we'll direct them to put in the special messenger costs again. That default clause is there without our saying so automatically. Acha, and next, the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, which have liberty to the parties to mention the appeal for inclusion in the list as and when the appeal is made ready for hearing.
But, upon instruction from a counterpart who is there in city civil court, my lord, he says the lower court record has already arrived in high court.
আচ্ছা, যেখানটা বলেছি স্পেশাল মেসেঞ্জার shall put in special messenger bring the trial court records in the event the records have not arrived already in this court. The rest remains the same. এটা ফেরত দিন, মানে এটা রেকর্ডের মধ্যে।
Lordship, item number 3, Lordship.
Yes.
This matter has to be released.
This matter has to be.
Released, Lordship, because Lordship has appeared.
I had appeared for one of the party.
Yes, your lordship consulted with
Since one of us within bracket, since one of us bracket Bhattacharya ji had occasion to advise one of the parties prior to elevation, comma, let the matter stand released from our list on personal ground with liberty to the parties to seek an assignment before a different bench. Please give your appearances in the previous matter. Give your appearances.
Or I appear for the respondent.
Yes, what is the matter?
There are 3 applications. My
Right, right. One is appearing into this list.
lord.
Can 3.
Can 3 is basically for restoration. Now, my lord, I find that this matter was dismissed for default
Yes.
at the order 41 stage. So, my lord, order 41 stage is the FMAT of 2022. So, my lord,
The order 41 will allow the restoration and send it to the order 41 bench. Those applications we have determination.
no, my lord, kindly see is connected application.
Oh, connected applications.
Otherwise, I leave it to lord.
No, you're right. You're right. You're right. Thank you. Yes. Because order 41 and connected applications, we have determination only up to 2020.
Can 3 ballot as my lord it has already placed ballot is in connection
No, it has to go to Justice Tandon's bench. Since we have determination, since this bench has determination to take up order 41 hearing matters and connected applications only up to the year 2020, and the present appeal is of the year 2022, comma, let the matter stand released from our list due to lack of determination with liberty to the parties to mention for enlistment before the appropriate bench having determination. Thank you.
So grateful.
Yes.
But I appear for the appellant. This is my application for stay of blood and eviction decree on the ground of a flux of
Defect has
time.
been removed, Mr. Mukherjee. Deficit court fee was there. We don't find any. There were directions, 3 directions, but one direction was by the registrar administration.
I'm told, Lord, the defect has been corrected, Lord.
Yes, yes.
Yes, Lord, I'm told, Lord, the defect has been corrected. Lord, I'll just, Lord, verify.
We
Lord.
can pass an order and make it subject to your curing the defect. Yes. The application for stay. eviction
Lord,
should act now.
this is the first appeal. Lord, I have suffered a decree, Lord, on the ground of a flux. And Lord, this is a case where, Lord, there was a previous, Lord, the lessee. The plaintiff is a lessee in respect of the property for 99 years. I was given, Lord, a lease, Lord, for another 21 years. Now, Lord,
Beyond 99 years.
No, Lord, within that 99. Within that.
Yes.
And the lease was a registered lease with a clause for sooner determination by, Lord, at the option of, Lord, the lessor and the lessee. Now, Lord, the learned judge in the court below has passed a decree in my against me. That is not the degree of eviction against me. Against that, I am before your lordship in appeal.
Yes, what do you say?
I pray the suit property is 5,000 square feet. It is a commercial property, and not the occupational charges.
They are
Lord.
still in occupation of it, Malad, for about 50 years. From 95, the property, Malad, my determination, which led to the suit being filed, Malad, of 1994. Decree passed in 2024.
But you have to disclose the occupation
Yes,
charges. Yes.
Malad, I am
But it's-
carrying, Malad, we've had it valued by
No,
a chartered
file it
valuer.
by UFN affidavit in occupation. Since you're ready with the papers, file it within how many days?
Will give us a few.
By Monday, you can.
Yes, Monday we'll do it. We'll do it.
So Monday, 3 days for reply, Mr. Mukherjee, and we will
Lord,
come back after that.
But kindly, Lord, stay, Lord, the
Yes,
Till-
unconditionally for that.
Malad, till that day, Malad, we haven't filed any execution application yet, Malad.
Then injunct them
Malad,
not to, Lord, file an execution.
No, we'll pass an order of stay unconditionally till a particular period. Or till disposal of this application, fix this application on that.
not till disposal, Malad, let the pleadings be
No,
complete. Because, Malad, they're enjoying the property, Malad, since 1994 for
But
commercial
I'll put
purposes.
in, Lord, the
Yes.
occupational charges.
For
I
that.
am not shying away from putting
Only
in
for
that.
put in the-
determination of the occupation charges,
I
Malad.
will fix the application itself for hearing next week. I mean, the week after that. The present appeal has been preferred against an order granting eviction against the appellant. Full stop, next para. Since both questions of fact and law are involved in a first appeal, comma, we are of the opinion that a prima facie case for hearing of the appeal on merits has been made out. Full stop, next para. Learned counsel for the respondents argue that the respondent argues that the appellant is in occupation of the suit premises which is located in a prime location of the city, and the respondent is at least entitled to substantial occupation charges as a condition for grant of stay, comma, if granted. Which is the next para. Since the issue of occupation charges is required to be resolved on sufficient materials, comma, the respondent is directed to file an affidavit in opposition disclosing all germane material in that regard to the application for stay within December 10, Tuesday, December 10, 2024. Full stop, reply, if any, shall be filed by December 13, 2024. The application shall be listed for hearing on December 16, 2024. So next para, there shall be an unconditional stay of operation of the impugned judgment and decree till January 24, 2024, or until further order, whichever is earlier.
Only could it, in case it's not called on that day, Malad, could I have liberty to mention at least, Malad, in case it's not called on, Malad, occupation charges, Malad, they have to.
We have granted stay till December 24.
Yes, Malad, the matter is fixed on 13th. In case thereafter it's not taken up, if Malad will only grant us liberty to mention.
They'll mention it after before 24.
But the reply, Lord, maybe, Lord, on 17th of December. My learned friend says that he will not be here.
16th. Instead of 16th, maybe on 17th.
Returnable date.
Lord,
Next
Reply is 13th.
the date fixed for hearing, if it may be kept on 17th.
Yes, very well, 17th. Shall I say 16th?
The order of stay is till December or January, Malad, perhaps?
December 24.
December 24.
But so far,
December 24, 2025. January chilo. Oh, we passed January.
That is why.
No. December 24, 2020.
Deeply obliged.
Thank you. Thank you.
the defect has been removed. Lord,
We're not record. Acharya, we should record that. Artlining, it is
the deficit court fee of 3,850.
So we record that you are submitting. Learned senior counsel for the appellant submits on instruction that the defects have since been cured.
Deeply obliged.
Thank you.
Agreed.
Thank you.
But instead of 17th, made be on 18th.
2014. You designated listen. 2014. 2014. 10 years. Sorry, Mr. Mukherjee, yes?
But made be on 18th, not 17th, but I'm told not there.
Yes, but you will have a crunch situation. 18th, we have the stays till December 24. Very well, 18th.
I will come back. Blood,
18th,
what
final.
was the question of blood, the quantum of the
17th, 18th.
occupational charge?
18th.
Apply.
Thanks.
Lord, I'm great.
Thanks. Okay, 18th হবে কিন্তু।
For the respondent.
For the petition.
Appellant, yes, you are for the.
Whether I'm the plaintiff in the suit, whether the suit was dismissed.
Suit for?
A suit for infringement is easement right. Although the easement right is not applicable, but the principles do apply, which has fallen from your lord of the last occasion. If my lord may kindly turns to the last order of 11th of November 2024, my lord was pleased to grant an order of injunction restraining the defendants to carry out any construction over the common boundary wall between 17B and 17C Goulaha Street. Paragraph 5. My lord, the affidavits have been exchanged. The main contention in the affidavit in opposition sought to be raised by the defendant respondent, my lord, that the construction has been made prior to 1944 and such construction being made does not infringe the easementary right so far as the flow of air and light is concerned. If my lord may kindly takes the arbitration award in the main application being can numbered 1 of 2024 at page 76. This is the arbitration award being passed on 24th of February 1933 on the basis of the entire 17 Goulaha Street. The arbitrator demarcated 17A, 17B and 17C. Dispute arises between 17B and 17C, who are the plaintiffs and the defendant in the court below, being the appellant and respondent before your lordship. But so far as 17A is concerned, my lord, there is no difficulty. My lord may kindly turns to page 76 once. Clause 9. We do hereby further certify that certify and award that each of the respective lot A, my lord, we are not concerned about lot A, projection of lot A and portion of southern boundary as well as wall as mentioned in clause 7A1 and 2, lot B, including the said projected lot B and portions of the southern boundary as mentioned in clause 7B Roman 1 and Roman 2, and lot C shall be held and enjoyed in severity as a complete unit and shall within 3 months from the date of filing of this award be completely separated from each other, so that the one may be free and independent of and from all rights of easement of the other. The entire portion of the partition wall between lot B and C shall be erected by Parikshit Kumar Chakraborty in his own portion at his own cost. Such of the boundary walls are built between the said lot B and lot C and are built under the verandas of the two ends, and in any room may be built up to the ceiling of the first, second and third 3-story as the case may be, and that save and except as aforesaid, no portion of the boundary wall shall be more than 7 feet 6 inches in height. This is the clause that has been included by the arbitrator in the way 1933, much prior to the coming of the present defendant or their predecessor in interest which they claim in the affidavit in opposition or the written statement. But in the written statement, they say...
You are a neighbor.
No, I am the owner of 17C. I am the beneficiary under the arbitration clause. This 17 was, inter premises was 17. That was been made 17A, 17B and 17C. But to show to your lordship, this is certified copy where the demarcated portion has been given showing a map. Map
is not a part of the award.
Yes, that is a part of the award. Kindly see this.
So we can see from here.
But after getting it Xerox, madam, that is not very much legible.
Achha.
I have got it Xerox. Tell your lordship.
Then give a copy to Mr. Nayak also.
Page 95.
Achha, it's there.
It's there, madam.
Already. You can give another copy. Yes. If it's only one copy, then we can.
This is a certified copy.
We'll look into this. Yes.
But my lord may kindly see lot A is there in the upper portion. In the northern portion, in the upper portion, lot A is there.
It's annexed in a reverse fashion. No, it's right.
Right hand side is lot B.
A, yes, lot
and
A.
left hand side is lot C. My lord may kindly
Right.
make it for your lordship's convenience.
No, you can.
It will be.
We have got it.
But so far as the middle portion between Lot B and Lot C is concerned,
Yes.
my lord will kindly find that there is a common passage been mentioned.
Yes, common
Common
passage.
passage. Now, this common passage, on the basis of this, there is a common passage and a wall adjoining the common passage.
Wall on their side or your side? You are Lot C.
Lot, it is on the portion of Lot C.
Yes, on your side
On my side.
of the passage.
Yes.
Yes.
There is a specific award been given that no person can raise the wall over and above 7 feet and half inches. 7 feet and 6 inches.
So what about the now?
Now they have made a construction making an iron structure with glass fitted therein, which I have shot to with a prayer for mandatory injunction. I have made a filed a suit for removal of that
Why was
structure.
the suit dismissed?
But suit was dismissed on the ground. My lord may kindly text it. The memorandum of appeal.
We'll continue after the recess with this matter. We'll continue.
My lord.
With kind leave of Justice Kant, my lord. Extreme urgency, I would not come, my lord, before your lordship. My lord, 29th, my lord, November, my lord, sitting singly in a contempt proceeding, my lord had passed, my lord, order of demolition, my lord, against my client, my lord, I am not the contender, I am not a party. Now, my lord, the demolition is fixed tomorrow, my lord, 11:30 to 5 p.m. anytime, pursuant to my lord's order. Now, my lord, this notice we have got yesterday evening, late evening. I've prepared my lord, a can with the short cost title so that I don't have the full cost title of the contempt even because I'm not a party. Now, my lord, if kindly don't
Appellate side.
appellate side.
What can be done now?
My lord, to leave I am seeking, my lord, to file it with the short cost title and my lord, to place before lordship whenever my lord sits, my lord, and to stamp punch with the short cost title. These are the leaves
I'll be sitting on Friday. I'm sitting in a division which how can I grant that leave even?
Difficulty is that my lord, they have given a demolition notice for tomorrow, 5th. I mean, I was not a party. My lord,
Can't do anything.
my lord, 3 BT appeals, my lord, not even indicated to your lordship.
Maybe, but can't do anything. Sitting in division bench, we can't do anything. I have a division bench. Tomorrow also I have a division bench.
No, may I pray for one thing? Let it be listed on Friday before your lordship. My lord gives me leave with short cost title to file it, number and number to get.
Cannot give you the leave sitting in division bench.
Difficulty, I'll be non-suited. They have.
No, we appreciate that.
I've received it yesterday after 6. I prepared it overnight.
You can't give the full cost title.
Because I don't have the content petition. I am not a party to it. The order has been passed against me. The content petition was against KMC. Now, my lord passed the demolition order, sitting singly, which affects me, 3 BT are pending.
That elevator?
No.
Not really.
That, it's separate. The difficulty is that I don't have the content petition. Naturally, I was not the contender. I was all along litigating as appearing before your lordship. Content petition drawn against KMC order has
I don't know what to do. I can only give you that leave on Friday because Friday and that too at 2.
I become non-suited, Milad.
Appreciate, but nothing doing. What can be done?
Only leave to file it with the short cost title and I'm seeking my lord justice can't leave before your lordship, Milad.
No, but we can't do that like that. Justice can't do that.
Only when it kindly sees the notice, Milad.
Cannot do it, Mr. How can you do it?
What should Milad? I don't ask Milad, but where should I go? Milad, I appreciate Milad. Where should I go?
This bench can rise at 410. 410 and just sit in the
Move before your lordship this application because otherwise it's.
No, have you given notice to the?
I'll give notice that my lord sit at 410. My lord will sit singly. I'll try to move it here.
If you can serve on the other side, on all the sides, I'll consider that. 410. Come back at 410. I can give at best leave. But if all of them are here before me, then I can take.
I'll try to serve, my lord.
Do that.
My lord, sorry for the indulgence, my lord.
Yes, please.
Due to my mistake, my lord, my matter was not listed and I am ill for last 1 month. My lord, kindly allow my mention to my.
Send some of your friends. This is not the mentioning hour. I'm sorry. Yes, please continue with the matter.
My lord, may kindly take the memorandum of appeal where I have annexed the impugned judgment and degree. It has fallen from leadership. What is the reason for rejection of my suit?
Yes.
My lord, may kindly comes to page 17. Page 17, paragraph 35, last but 6th line. My lord, find it. Yeah, my lord, they starts with there is no cogent evidence to prove that such glass pane with iron frame has been installed by the present pen.
Yes. This should be a memorandum. No, right. Second judge's copy ne memo? Memo second judge's copy ne memorandum hai? 17.
My lord, may kindly come to the memorandum of appeal, page 17, under paragraph 35. From the bottom, last 6 line.
Yes.
There is no cogent evidence to prove that such glass pane with iron frame has been installed by the present defendant. This is one of the reasons for the dismissal of my suit. And second ground that the trial court sought to make out is at page 19, paragraph 40. That the plaintiff could not produce any evidence to convince that he has suffered any substantial injury by the action of the defendant. But based on these 2 grounds, the suit has been dismissed. But there was an
What is on merit that glass pane won't prevent your natural light from coming in?
Yes, my case is that it is obstructing my natural flow of air and light, because there was an order by the arbitrator way back in 1932, which was published.
Very well, very well. So this is your case, yes.
But there was an identity order of injunction. Finally, that identity order of injunction was confirmed in at the disposal.
What is the stand taken by them in? Yes, there was an injunction in the suit also.
Yes, yes. My lord, may kindly comes to the identity order. I am not placing, my lord. Final order of injunction at page 117. Upon rejection of their application for vacating. Kindly see, my lord, I am not placing the entire facts. Kindly come to page 118.
Right.
One of the first paragraph. From the contents of the injunction application and the respective submission made by the parties, coupled with the effect of the copies of the relied upon, I find that admittedly the plaintiff is in possession of the portion of C. It will be Schedule C, Schedule A property to the owner thereof, that is 17C. Owner thereof, while the property described in Schedule B to the injunction application belongs to the defendant. There is also no dispute regarding the existence of common boundary wall, partly 7 feet height and partly 7 feet 6 inches in height between the 2 properties, and that this B schedule property is situated on the adjacent southern of the A schedule property. It is further evident from the record that an interim order of injunction restraining the defendants to fix any glass pane or glass fitted iron frame of the common wall of the common passage of the shoot property till disposal of the injunction application is in force, while the application preferred by the defendant for modification and or vacating the interim order of injunction in terms of Order 13 Rule 4 has been rejected on contest. Though it may be a fact that at this stage of this suit, neither of the parties has cared to bring before the court the actual picture of the shoot properties and the nature of the existing structure standing thereon, including the nature and the condition of the common boundary wall. But at the same time, upon taking into the account the respective contention of the party, it is very much evident that there is a real dispute involved between the parties regarding the question of existence or otherwise of a glass pane on iron frame over the common boundary wall. It should not be lost sight that A schedule property being situated on the adjacent, not to the B schedule property, free flow of air and light to A schedule property will obviously get obstructed in the event of raising any obstruction of the common boundary wall. Whether the parties are really entitled to raise any construction on the common boundary or not, such question cannot be decided at this stage of the proceeding. At the same can be decided at the time of trial of the suit after recording evidence. Be that as it may, when on basis of the available facts and circumstances and having regard to the stand of the defendant taken at the time of disposal of the application under Order 39 Rule 4 of the Code of Civil Procedure, the defendants are not facing any sort of inconvenience in respect of the interim injunction passed by this court. I am of the view that for avoidance of any unnecessary complication and for confusion being sprung up before commencement of the trial of the suit, it is just and proper to direct both the parties to maintain status quo as regards.
They have already created that the glass pane thing.
No, they have created in my affidavit. There are 3 exhibits: Exhibit 4 series, 5 and 6. I have annexed in the affidavit.
That has been built already. That glass pane.
They built just prior to the filing of the suit.
So what further apprehension is there in?
Apprehension is that they may make further construction. Yes, they may raise. Secondly, I have a mandatory prayer for mandatory injunction for removal of that obstruction. That is in the suit. My lord may kindly takes the affidavit in reply, affidavit in opposition. What is the stand taken before your lordship? Paragraph 8 of page 4, affidavit in opposition.
Yes.
Starts
in reply. It's below that. No, it replace. No, this is not the opposition. I hope there are not. Right.
Para 8. The common boundary, it starts with the common boundary wall. The common boundary wall between the plaintiff 17C, Goulaha Street, PS, Jorabagan, Calcutta 7,06,000, and these respondents, defendant 17-4, Goulaha Street, Calcutta 6, being a masonry structure with iron plated glass panes on it, has been in existence from before the purchase of premises in 1944. This is one of the stand taken. Second stand, they never constructed any structure over and above the pre-existing one, including the glass plane. Now, to buttress this statement, but I have annexed in my reply.
No, they add something to that. Common wall with glass panes, with iron frame.
Yes.
Varying sizes is existing basically under the open staircase of the respondents.
Yes, ma'am.
So it is their premises which is not getting air and light for that, not yours.
But they are saying so. If
They are
have
saying
made
so.
a
It's their version. Their version.
their
Yes.
version. My says is that you cannot make any construction because the original arbitration award restrains the parties to the agreement from raising any construction, be it a subsequent purchaser or be it in successor in interest.
Now, can it be on the boundary wall and under the staircase at the same time? Because they say it's under the open staircase, whatever that means. They have annexed photographs also.
But they have annexed photographs. Photographs I have disputed. I have
This is the glass pane. This is the boundary wall.
Yes, my lord. Now,
This is from their side.
Yes, but a common boundary wall, just on the right hand side of the common boundary wall, it is my side. That is 17C.
So how can air and light go through their building to your? You see page 7 of their opposition. If this is from their side, then air and light has to. I mean, then the air and light has to be generated in their house.
No, there is a free
Cannot be
flow.
open.
My lord, had there been no construction,
We can see the top of that, which ends more or less coincides with the top of that staircase.
my
So
lord,
if
kindly see the
their air and light will be prevented, in fact, from your side.
My lord,
And it
so-
cannot be the other way around. From this photograph, is this the actual that structure?
so far as this photograph is concerned, my lord, I
You
have
have filed a reply. How did you deal with
yes,
the
I
photograph?
say that this is not the photographs relating to the dispute in question.
Have you annexed any counter photograph?
But counter photographs I have annexed in my those are exhibited, exhibit 12 and 12A. My photographs are already there in the suit. Kindly see, my lord, the photographs they are dealt with by the learned trial judge.
They have annexed several photographs, and those appear to be on their side. I mean, blocking their air and light.
My lord,
Anyway, this much that will be decided in the appeal.
my lord, may kindly
But
see
we have granted injunction not to raise further
further
construction.
construction. And my lord, I have
This will be deciding on the merits of the appeal itself. Whether that
so whether
they may have a good case. I mean, also
whether it prevents my flow, whether the intentionally blocks there.
whether
that
the
is their
glass pane prevents your airflow, that will be decided in the appeal.
Yes.
So it's already there. We won't direct demolition in interim stage, obviously.
No, so I'm not.
Further
I'm
construction.
not for any
We are
demolition.
hearing on further construction.
I'm not. I'm only on further construction for till disposal of the appeal. Since I am enjoying an order of injunction ad interim, a final order, till disposal of the suit.
And they also say that there has been no attempt to construct anything over and above the pre-existing.
But they say so, and I apprehend, my lord, to buttress the-
We'll accept that and grant an injunction.
my lord, may kindly takes the affidavit in reply. They say that it has been the construction existed prior to 1944, and to buttress, my lord, I have annexed.
No, they say the boundary wall.
Boundary wall is
Oh, no,
there.
no, being a message with iron frame glass panes on.
Only on the iron
Yes.
frame and glass plated.
Has been there since 1940.
And now they prior to 1944.
Yes, they say that.
Predecessor in interest from whom they have purchased, they say that inherited that portion on purchase. My statement, my case has been made out. And kindly come to paragraph annexure R1, page 6 of the affidavit in reply. But these are the documents which I have annexed from annexure exhibit 4, 5, and 6, which shows.
Yes.
My lord, these kindly see that exhibit 4 series, 5 sheets on the top of it. And I have specifically stated before the local police station as well as the local corporation, local municipal authority at page 11. It's 5 letters I have given to the local police station just prior to the filing of the suit. And kindly come to page 11.
When did you purchase? You
I have not
or
purchased.
you both of you simultaneously got from your predecessors?
I got from
Not simultaneously.
My predecessor in title, my lord,
Yes.
had purchased the property from the person who was a party to the arbitral award.
All right.
He has, on the other hand, my lord, inherited this.
All right.
And I have been in possession since the arbitration award. My lord, may kindly comes to the 144 proceedings that I have instituted prior to the.
But these are all unilateral, your allegations.
Yes, my allegation. So it prima facie shows that the construction has been sought to be made just prior to the institution of the suit.
All right. Very well. Let us hear them.
My lord.
Yes, Mr.
I
Nayak.
am praying for an order of injunction, my lord, which your lordship has passed in the ad interim stage, my lord. Then let that be continued till disposal of the appeal.
Yes, Mr. Nayak, why should you make further? You have stated that you don't want to you don't intend to make any further construction. We'll injunct you from doing further construction only.
I'll oppose that prayer that they make, my lord.
Yes.
Principally on the ground that would be beyond the scope of the suit as well as the injunction application. For that, my lord, I'll rely on two things. Number one would be some of the observations made on facts, my lord, by the decree, because I'll not take your lordship through the papers and the photographs. But before I do that, my lordship kindly looks at the plaint ones.
Yes, we were going to do
9.
that. In fact, we are searching for the plane.
Yes, page number 9, my lord. The plaint commences. Lordship kindly takes up page number 13. Those are the prayers. This, I would presume, my lord, is the scope of their suit. The first prayer, my lord, declaration of the plaintiff is entitled
B
to.
covers it.
B, my lord.
Prayer B.
With respect to construction. But the entire prayer that they make is based on easementary rights, which from my learned friend's submissions, my lord, would be with respect to light and air. Nothing else. So that effectively would cover the entire suit. There is no prayer for a mandatory injunction.
No,
so that's sufficient.
Yes, he said mandatory injunction.
There was an amendment. Kindly see the.
You have not annexed the amended plaint.
No, but kindly see the.
But I'm looking at the application.
Kindly see the degree.
But it's your annexure. Your application does annexes a plaint which does not contain that prayer.
Unamended plaint.
You should have annexed the amended plaint. You are misleading them also.
No, I kindly see the degree once. Kindly see the degree.
Why should you see the degree? You have annexed a plaint that does not contain it.
That amended copy of the plaint my client did not get from the advocate and record in the court below.
So,
but
filed it, my lord.
Please take your seat. Mr. Naik is representing you. Yes.
Kindly see the degree once, my lord.
They have prepared themselves on your annexures.
So
This
that
is
would be slightly
unfair.
unfair.
This is unfair. Yes, mandatory injunction appears from the yes. BB.
Injunction directly on the defendants to remove the iron
Yes,
frame
yes.
glass pane as already fixed by the defendant on the side of the common boundary.
Very well. Very well. We'll proceed on that. Mr. Naik, we are not granting that mandatory injunction. They have
I'm
not
not
even
saying that. I'm not saying that. But, my lord,
So,
that
but
would
this
have-
permanent injunction B covers the present prayer also.
Your lordship is referring to the suit.
Yes,
The
so
plaint
the
one.
plaint which has been annexed.
Yes.
We are forgetting BB for the timing.
Yes,
We are not granting. We cannot grant.
No, very well. I understand that would be the subject matter of the appeal.
Exactly,
I'll
exactly.
not even invite your lordship. But lordship, in that case, my lord, takes up the affidavit in opposition once. my lord.
Yes.
Whether the injunction, the reason I argue for whatever I argue, my lord, in the next 10 minutes is principally on the ground.
No, not next 10 minutes.
5 minutes.
Yes.
Is principally to counter the point if an injunction can be passed for the asking. This is to sum up. That's the only reason I make the submissions.
No, not for the asking, Mr. Naik, but
Because
they had to spend on the photocopies and all.
The
Not for the
photocopies are
asking.
fixed by me.
No, this is their application.
Oh, in the application.
Photographs have been annexed by it.
Right.
So not for the asking, they have had to spend money for it and spend on the lawyer also.
They
So
would have
not
to
for the asking.
showcase, my lord, two things.
They're entitled to
There aren't any
to
more.
make any further construction that will add to the
There
woes.
cannot be any scope for further construction is my second argument. But the principal argument is whether they come forward in the application, the injunction application that they file, and whether they make out any prima facie case of any imminent threat at all. There is no pleading. That could have been there in the Order 39 Rule 1 and 2 application before the suit. They don't reproduce anything. Which is why I make the submission that they come and ask merely for the asking. That cannot be the position of law. That I was enjoying an Order 39 Rule 1 and 2 application which was passed in my favor upon contest, upon affidavits. Therefore, in the first appeal, merely because it's an extension of the trial, I am supposed to be put back to the same position. Or that order is to be restored. That cannot be the position of law, my lord, which is precisely why I make the submission. Lordship kindly takes up page 7 of my affidavit in opposition once. They have not denied these photographs. This is the disputed portion. In their reply, they haven't denied. So just to give a visual representation to your lordship, my lord, I show this.
Yes, we have seen that. That is
Precisely, your lordship has been
yes,
right.
yes. we
This
have asked
wall, I'll just indicate, my lord, this wall that is there, this is approximately 6.5 feet from my side. From the other side, because there's a lower base, that would be about 7.5 feet. There is a glass pane which is on top of this, which according to their plaint case is the subject matter of the dispute. That I counter by saying is a construction which was made in 1944. the decree upon evidence, my lord, holds that there has not been any contrary evidence that has been led by the plaintiff. The plaintiff admits to this being there.
There's
The
a glass pane in the neck. No, we are not on the glass pane. Let you enjoy your glass pane.
Which is now I'm on the
Further
injunction.
construction mission.
No, I'm on the injunction bit, my lord. I'm on the injunction bit because this also has other ramifications in the sense
What
that
ramifications?
this building, this wall exists in 1942. I cannot, my lord, allow this injunction order if it happens, if your lordship passes it, my lord. I'm saying this order, my lord, otherwise should not interfere with my right to repair, etc. I don't want to get into the controversies for the future, take out an application, which is precisely why I'm arguing this case, my lord.
It's just the subject matter, the property is the subject matter of a suit. In any event, you should make an application for repair if you want to.
I would, my lord. The reason I say
This will not prevent you from
Lordship,
making a repair.
30 seconds. I'm sorry, my lord, 1 minute, my lord. The reason I make this submission is because today there cannot be any injunction because this is with respect to further construction that goes beyond the scope of the suit. The scope of the suit is easementary right. Easementary right is with respect to the light and air that they claim as a neighbor to my property. That would be the principle that we followed in West Bengal.
Yes.
But if your lordship looks at the first photograph that I've annexed, I'll show one more photograph that I've annexed. There cannot be any light and air that will be passing through my building. Today, I'm not saying that I'm making any construction, but even if I am to illegally make any construction in violation of the award, my lord, that would not violate the right of easement, which is the scope of the suit. Today, there is no light and air that is passing through my house. So to give a better picture, lordship kindly turns to, my lord, page number 9 of my affidavit in opposition. This gives a bird's eye view, my lord. The pink portion is mine.
This is from the top.
This is from the top. This would give a
Right.
better view.
Right.
The pink portion is mine, which is on the left side of the screen, my lord. And the yellow is there. They cannot deny this. This is the subject matter. In fact, their client has also annexed these documents, exhibited them in the trial. Lordship looks at the stairs, which is on my side of the page, my lord, which is on the pink side. The wall is on the left of that in the photograph. So when your lordships look at it from the front,
the wall is on the right.
left.
Has to be on the right.
I'm sorry, my lord, the wall is on the middle of the page. The
Middle of the page. Yes.
The middle of the photo.
As per your earlier photograph.
That's right. So if the wall is to, let us assume that the wall is also not there. I'm taking their case to be the highest. Let us assume that the wall does not exist. Even then, there is no air and light which is flowing to their side. So there is no question of easementary right. I understand this will be decided in appeal in the final hearing. But today at the prima facie level, my lordship has to take a view whether the injunction that they claim on
Why
the
didn't you produce these photographs in the court below?
These were probably produced, my lord. No, 2024, the exact same photo could not have been
No,
produced.
could not have been.
Could not have been produced.
Bird's eye view, yes.
In fact, they had brought these documents on record. So from their side of the premises, there was a wall, which is precisely why the decree was passed in my, I'm sorry, the suit was dismissed. So today, even if there is a further construction, there is no prima facie case or balance of convenience that they make out. There cannot be any injury at all. Whether irreparable or repairable is a different question. There cannot be any light or air coming from my side of the building. Unless, of course, my side of the building is scaled down. It is demolished. Then they can claim light and air. So, my lord, today the injunction, if at all, my lord, the injunction is allowed, the difficulty is that they have not disclosed any prima facie case. That's, my lord, one part of it. The lordship kindly, my lord, to establish whatever facts, I'm not taking your lordship to the papers, lordship kindly takes up the impugned order once, my lord.
The judgment?
Impugned judgment, my lord, which is a part of their memorandum of appeal. Lordship looks at page number 16 of the internal page number 16, my lord, of the judgment.
Yes.
Lordship looks at paragraph 34. There was a commissioner who was appointed, my lord. He comes in as PW2. In his commissioner's report, my lord has specifically mentioned that he had seen glass panes and iron structures fixed on the common boundary wall of premises number 17B and 17C. One other thing, my lord, they come and argue that there is a common passage. There is no common passage. It is only a wall. Next to the wall is my staircase, which takes me to the first floor. So there is no passage as such. Goela Street, Commissioner mentioned that the fixing of the glass pane with iron structure was only in ground floor, and except that it was open to sky from their end. And above the boundary wall, there was no roof. From the report of the Learned Commission, it is crystal clear that above the common boundary wall, an iron-made frame with glass pane, there is no roof above the ground floor, and the space is open to sky. That being the position of the common boundary wall, no doubt there is no scarcity of fresh flow of air and light from the space above the common wall and the open sky in the premises occupied by the plaintiff. From the photographs produced by the plaintiff and admitted by the DW1, it is evident that a small portion under the staircase situated in between the wall and the staircase was glass fitted with frame. Just after the glass pane, there was another wall. As the photographs were produced from the plaintiff's side, there remains no confusion that the photographs were taken from the side of the premises of the plaintiff. The photographs do not establish that there is any space or vacant place after the glass pane to bring air or light from outside. Because of my building, it is clear enough from the visibility of the glass pane in the photographs that the opposite side of the glass pane is also covered by walls of premises number 17B, my premises. So it is not believable that such portion of the glass pane with frame between the staircase and the common wall prevents free flow of air and light of the plaintiff. No documentary evidence could show that the plaintiff has made any complaint of any authority for fitting such iron frame with glass pane over the common boundary wall under the staircase. As per the defendants, such iron frame with glass pane was in existence before they purchased the suit property from the erstwhile owner of it. There is no cogent evidence to prove that such glass pane with iron frame has been installed by the present defendants. No doubt such fittings protects the premises in possession of both the parties from unauthorized invasion of the others. The plaintiffs have failed to establish that such iron frame with glass pane prevents free flow of air and light at their premises. In order to succeed, the plaintiff must show that the substantial injury has been occasioned by the infringement of his right. The mere fact that the ventilation is to some extent affected does not give rise to a cause of action, as the plaintiff has to prove that there is an actionable nuisance. I, on the other hand, am saying, my lord, my light and air is affected, not theirs. I'll not trouble your lordship with the rest of it. Lordship comes to 42, paragraph 42 on page 19. Cross-examination of a witness and means of all of that, my lord. DW1 in his cross-examination categorically divulged that there is iron-fitted glass wall over the boundary wall since their purchase in the year 1944, as in my predecessor in title. No contrary evidence is available. Existence of such glass pane is thus evident since the year 1944. For that, the issue number 5 is decided. Lordship, for the time being, disregards everything that I have said or submitted. Let us take their case to be the highest. Let us say that I am unauthorizedly making that construction. Let us assume that for a moment. In that scenario, the plaint case that would have sustained is the fact that I am making an unauthorized construction over and above the boundary wall. That is not their plaint case. Their plaint case, based on which they seek an injunction before the appellate court today, is that their light and air is getting affected that they are otherwise entitled to in law under easementary rights or the principles of easementary rights. That is the scope of their case. They are not saying that my wall is either unsanctioned by the municipality or...
Yes.
So, in fact, in their affidavit in reply, whatever complaints that they bring, which they have issued with the Kolkata Municipal Corporation, none of those allegations pertain to glass pane walls, which they have exhibited, which my learned friend had shown. So,
You're not on the glass pane, we're on further constructions.
No, I understand, Milord, but that further construction they would have to show is affecting their right. That
You have made your arguments. Let us hear them now. Let us not continue with the injunction
very well,
application for so long.
that is
You have
my-
argued sufficiently.
My conclusion, Milord, is that it should not be allowed. And if
Yes, please stand up. What is your answer to this bird's eye view photograph? Please come to page 9 of the affidavit in opposition. It's very evident that the construction would not affect even if it's made above the glass pane. I mean, it's a cloistered area within in the middle of both of your houses.
But so far as the
Even if a construction is made at least up to the roof level, you are not affected. No free flow of air and light can go from above at the west.
But the flow of air is also horizontal as well as vertical.
Where is the horizontal scope of horizontal air?
But the
Unless they generate that air.
but
Please come to page 9 of the opposition. See the left side.
But there is an open space over and above the staircase.
Yes.
That leads to the sky. Open to sky.
Maybe there will be.
But so far as
Yes, there are cross currents of air.
Obstruction to air and light is concerned, it is not always horizontal. It is vertical as well as horizontal.
Vertical is not being prevented by vertical construction.
But
Then there has to be horizontal construction on your property.
But the landed trial court came to a finding that so far as the vertical portion is concerned, they have only concentrated to that. So far as the horizontal flow of free air and light, the court has restrained himself. Kindly see the order impugned. Kindly see page 30, paragraph 38. The impugned order.
Read for us. Yes.
Each owner, every owner of the land has a right to so much of light and air as passes vertically thereto. It is
Yes,
clear.
yes. Vertical, they are not opposite.
Yes, it is clear that the right of an owner of a property to light and air is limited to what reach him vertically. That right does not embrace a right to light of air passing on the property laterally or falling at an angle to vertical.
So you are on the angular.
The free flow of air and light, it cannot be only always vertical. It has to be horizontal. But
Maybe.
the court has restricted him only to the air and the light that is come vertical. That cannot be. If there is an open space, kindly visualize the situation. Now it is a mall culture, a flat culture. So far as in earlier days, there was a vacant land in between the premises, so that the free air of light and
Your premises does not have that.
air is concerned.
It's not present in your premises because you have made construction both sides.
No, I have not made any
Both of
construction.
it.
Construction was there.
Yes, your house is also more than one story, and we see from both the sides.
Two-story. Construction was there. What was there in the arbitration award? That construction.
That culture was not maintained in your house also, in your side of the.
Two-story building. Earlier one, it is a two-story building.
Let us pass orders. Yes.
But the conception of the easementary right is following from where that every dominant owner.
Learned counsel for the appellant argues that the appellant had all along been enjoying an order of injunction in line with that prayed for herein during pendency of the suit, and places reliance upon an order dated March 20, 2013 passed in connection with the suit from which the present first appeal arises to underscore such statement. For next para, learned counsel also places reliance on the copy of an arbitral award of 1933, where it was recorded that there would not be any construction over the common boundary wall between the two premises in question, which would be more than 7 feet 6 inches in height. Full stop. Since the respondents claim to one of the parties to the arbitral award, it is argued that the respondents are bound by such clause of the award as well. Push up next para. By placing reliance on the findings of the learned trial judge in the judgment and degree impugned in the appeal, it is contended that although no injunctions were passed, no injunction decree was passed, the arguments of the parties were recorded, which goes on to show that the learned trial judge did not deal with the aspect of vertical interplay of light and air between the premises. So next para, learned counsel for the respondent opposes the prayer for injunction and submits that the injunction sought here is beyond the scope of the suit itself. So it is argued that the subject matter of the claim in the suit is not on the strength of the arbitral award, but the plaintiff claims free flow of right and air and consequential easementary rights. Push up, by placing reliance on the relief sought in the plaint, it is argued that further construction on the glass pane which is already existent on the boundary wall is not within the purview of the suit. So next para, furthermore, learned counsel for the respondents relies on the relevant paragraphs of the impugned judgment, where it was recorded by the court below that there is no contrary evidence to the glass pane on the boundary wall being there since before the year 1944. Push up next para, learned counsel for the respondent next relies on the several photographs annexed to the affidavit in opposition to the present application and argues that the location of the glass pane on the boundary wall is such that, if at all, it would prevent free flow of light and air to the premises of the respondents and not the plaintiff stroke appellant. Push up next para, by placing reliance on certain bird's eye view photographs annexed to the affidavit in opposition, comma, it is submitted that free flow of air and light, comma, if at all, comma, is vertical in respect of both the premises of the plaintiff appellant and the defendant's respondents. Pushed up, hence, comma, a vertical construction on the common boundary wall would not in any event, comma, affect the free flow of light and air to the premises of the appellant. Pushed up, next para. Upon hearing learned counsel for the parties, comma, we find from the records that an arguable case has been made out in the appeal. Full stop. Moreover, comma, since the first appeal is required to be heard both on facts and law, comma, we are not inclined to comment at length on the merits of the appeal at this juncture. Full stop. In any event, comma, at the present moment, while deciding the present injunction application, comma, we are not deciding as to the fate of the glass pane which has already been constructed on the common boundary wall, and the same is the subject matter of the final hearing of the appeal. Pushta, what concerns the appellant stroke petitioner at the present stage is further construction which might be made on the boundary wall at the present moment. Pushta, next para. The respondents have argued that in the injunction application, comma, no categorical case of urgency has been made out by the appellant. Push up, however, comma, we find from the very fact of opposition of the player by filing affidavit in opposition and the arguments advanced that the respondent also expresses the apprehension that an injunction order might prevent the respondents from making repairs to the boundary wall. Push up, next para. As such, comma, we find that nothing has occurred in between the passing of the ad interim injunction in this court and comma, more so since there was a subsisting injunction order throughout the pendency of the suit, comma, to deviate from the ad interim order by vacating the injunction order already granted at the ad interim stage. Push up, next para. In any event, comma, although a strong objection has been taken by the respondent to the contention of the appellant that the free flow of air and light, comma, if any, comma, would be vertical and not lateral, comma. Upon a perusal of the bird's eye view photographs annexed to the affidavit in opposition, comma, we find that there might be some obstruction to flow of air and light at different angles to the vertical if further construction is raised on the boundary wall. Full stop. In fact, comma, the space in question on the side of the plaintiff stroke appellant might get more suffocating stroke stuffy in the event further construction is made on the boundary wall. Full stop. Prima facie, comma, we are also of the opinion that the free flow of air, comma, even if vertical, comma, is not restricted to the perpendicular, but may be at different angles between lateral and vertical. Full stop. As such, comma, it cannot be said beyond doubt at this stage that further vertical construction would not further suffocate the premises of the plaintiff stroke appellant. Full stop. In any event, comma, we find that for the purpose of getting an injunction, comma, a sufficiently strong prima facie case has been made out in the light of the discussions above. Full stop. Hence, comma, we are inclined to continue the ad interim order of injunction already granted. Full stop. Next para. Accordingly, can 1 of 2024 is allowed on contest, comma, thereby restraining the respondents from making any further constructions on the common boundary wall between the premises of the plaintiff stroke appellant and the defendant stroke respondents till disposal of the appeal. Full stop. It is, comma, however, comma, made clear that in the event either of the parties seek to make any repair to their premises and stroke or the boundary wall, comma, it will be open to both parties to approach this court by way of a proper application to that effect, which shall be heard in such case upon giving opportunity of hearing to both sides. Full stop. Nothing in this order shall prevent any such application from being taken out. No arrest to cost. Yes. The appellant shall put in due requisites. আচ্ছা তার আগে একটা notice of service of the appeal on the you are appealing for all the respondents.
Yes. Yes.
Notice of service of notice of appeal on the respondents is dispensed with in view of appearance through counsel. Full stop. The appellants shall put in due requisites, including written up notice form and declaration within a week from date. Full stop. The trial court records be called for by special messenger at the cost of the appellant, comma, also to be put in by within a week from date. Full stop. After the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, liberty to the parties to mention the appeal for inclusion in the list as and when the same is made ready for hearing.
One small thing, Mulot.
Yes.
Very small thing, Mulot.
Yes,
With
sir.
respect to some of the observations that your lordship has made with respect
It
to
is
the
made
that-
clear that all the above observations are tentative in nature, comma, arrived at for the purpose of deciding the injunction application and shall have no bearing whatsoever at any subsequent stage of the appeal.
I'm grateful.
এটাই no order first আগে debates also. Yes.
My lord, this is an application for modification of the order dated 20th August, my lord, 2024. My lord. What's the first miscellaneous appeal was disposed of by Honorable Justice Muthuresh Prasad and
Modification, you have to go there before that bench. We cannot take up a modification. What is the modification?
modification with regard to the extension of time to file the written objection, my lord.
Extension
We have already affirmed within the due time, my lord.
for filing?
A time was given for them to use a written objection and a time was given to us to file affidavit in reply. But till 3:30, they were the learned court below called on for hearing. They were not present. Later on, they came after 3:30. They say that they have filed it, and it was indeed filed.
We affirmed on the
So
same
what
day.
was to be filed? I mean, the
A
appeal
written
was disposed of.
objection to my injunction
Appeal is
application.
disposed of.
Well,
Appeal
then you
is
have to
disposed
go
of.
before that bench. Then you have to go before that bench.
As you know, my lord, that
It's not a mere extension of time.
only extension of time, my lord, to written. We have already filed, my lord, the written objection only to acceptance, my lord.
Yes, what do you say, Mr.
And a copy also been served.
Obviously, copy has been served.
My lord.
So you filed on the same day, but later on.
My lord, no, my lord.
After the hearing was
We went
concluded.
there, my lord, and the court not in the seat, my lord, and the court
Court
officer.
was doing what?
My lord.
Court was not in the seat doing what?
He-
Will take steps. Which district?
My lord, in the chamber, my lord,
Which district?
am
We'll
not
say
on
that you have
I am
alleged and
not-
we'll record in our order and take steps against the judge.
My lord, I am not on that issue, my lord.
Why?
My
Court
lord,
should
I
be in the
went
seat.
there.
If you walk around here, then definitely you
Officer
complain to our
directed
chief justice.
Come, serve and come, my lord. The advocate appearing before the court below was not in Seresta, my lord. And we have tried on the next day, my lord. On that date, my lord, court was not in session, my lord. And on that date, my lord, we have served through registry post, my lord.
Let us see the relevant portion of the order.
My lord. Page 13, my lord. Paragraph number 14, my lord.
You are challenged what? An injunction, identity refusal of injunction or grant?
Granting of the
Grant, you have challenged. All right.
I'm the dependent. They are enjoying the
So court did not interfere, directed you to file objection and all. So para
14, my lord.
para 14,
Page
yes.
13, my lord.
Yes.
Last portion, my lord. The learned counsel appellant submits that the objection shall be filed
Within a
filed
fortnight.
by them within a fortnight from the date, and the trial court should thereafter grant 1 week's time to the plaintiffs to file the reply. If required, the process the consider an application for injunction without granting any undue adjournment.
How many days after the fortnight did you file?
My lord, on 5th, my lord, on 20th.
Fortnight expired when?
On that was the due date, my lord.
On that day.
5.
On the same day.
Same day,
on the expiry of the fortnight.
Fortnight.
So then why this application?
My lord, we have prepared, but we could not file, my lord.
Filed when?
The court below, my lord.
Tat-
My lord.
Filed when?
It was taken with the record. May I,
Mr. Ali, you explain.
Lordship, may I assist, Lordship? Lordship, after the hearing was concluded, apparently they came and they tried.
Hearing was concluded on the same day. How could it be?
Lordship, not on the same
After
day.
a fortnight, they were to file.
The date which comes on the
On the fortnight, on the
yes.
14th. On that
14th
date,
day.
the court disposed of, should not have.
No, my lord, not disposed of. We said that this was the order of
hearing
the
was-
Honorable High Court. They have not, but on repeated calls, they were absent.
So they filed later in the same day. Relax.
Filed with the record in the same day.
Wait. This application is an innocuous one for seeking extension of the time for filing written objection before the trial court. Full stop. The brief facts are that the appellants stroke petitioners challenged an ad interim order of injunction. Full stop. Video order dated August 20, 2024, comma, the our coordinate bench disposed of the appeal by directing the appellants to file their written objection to the injunction application before the trial court within a fortnight from that date. First of the trial court was to give a week apostrophes time to the plaintiffs to file reply if required and proceed to consider the application for injunction without granting any undue adjournment or unnecessary delay, comma, expeditiously and preferably within a period of 8 weeks thereafter. Full stop. Learned counsel for the petitioner submits that although the written objection was filed on the day of the expiry of the fortnight as per the direction of the coordinate bench, comma, it was filed at a point of time when the matter you had not filed on the same day.
No.
So
We have filed on 1st October, my lord, and served on 6th, my lord, to them.
you had filed within a fortnight.
We have prepared on same date, my lord, and attempted to file, my lord, but it could not be filed, my lord.
What did you do on the 14th day?
14th day, my lord, we have prepared an FR and went to the court, and that moment, my lord, there was no court, my lord, and the
When did you go? At 6?
No, my lord, 3:30, my lord. At 3:30,
There was no court.
No, my lord.
Can't be 3:30.
Why was the court not there?
At 3:30, Lordship, we did the matter. It can't be 3:30.
You went at 3:30, my lord. I personally.
How many days after that you filed?
My lord,
The next working day?
Next working day, my lord, and the court, my lord, on 5th, my lord, passed an order for show cause. And on that day, my lord, we have filed, my lord, 1st October, my lord. Although we have served on 6th, my lord. And we have attempted to serve on 6th, my lord.
ফাইলটা কেটে দাও এখান থেকে কেটে দাও তার বদলে কন্টিনিউ করো although the written objection was affirmed and prepared on the day of expiry of the said fortnight, comma, when the appellants went to file the written objection, comma, it was found that the court was lying vacant and the objection could not be filed, push up. The same was, comma, however, comma, filed on the very next working day. Push up next para. Learned counsel for the respondent opposes the contention of the appellants and submits that the court was very much there when the matter was scheduled to be taken up.
An order was passed.
Yes, pushed up. Next para, be that as it may, comma, since we find that the appellants had actually affirmed the written objection by the time as granted by this court, video order dated August 20, 2024, and had already served a copy of the same on the learned advocate for the respondents in the trial court, comma, a hyper technical approach ought not to be adopted. Full stop. Hence, comma, the time for filing written objection in terms of the order dated August 20, 2024, passed in FMAT 270 of 2024, is extended. You have already filed it.
Already filed.
You filed it on
On 1st October. In the order appearing.
extended till October 1, 2024, when the written objection had actually been filed in the trial court. So we have filed a reply, no?
No, my lord.
The time for filing reply is extended for a week from date. Pushed up. When does that 8 weeks expire?
8 weeks have expired long back.
Expired long back. 1 week from
6th
date.
December is the next date of
From
hearing.
date. Pushed up. The time for disposal of the injunction application is accordingly extended till December 24, 2024, before the closure of court. Can 2 of 2024 is disposed of accordingly. Next. That will be the only matter. Yes, 80.
Sir, it is that, my lord, though I am not filed any caveat, my lord, no copy was served.
Yeah, what about this defect? The appellant number 2 and appellant number 5 have passed away.
It has been cured.
Substitution has been
Court fees.
not deficit code. Appellant number 2 and appellant number 5 have passed away.
Yes, my lord.
Wakalatnama have been executed by 3 appellants only.
My lord.
But there are 5 appellants shown in the memorandum.
Yes,
Let
my
us-
lord, because they have made the parties in the
Oh, you have indicated since deceased.
everything indicated, my lord. Everything is indicated.
Their heirs are on record.
Yes, my lord.
The
They
rest
were
are-
unmarried. They were unmarried.
They don't have any other heir. There's
No.
very good. What is the matter?
If the heirs are recorded, we are the heir. The rest.
That is what we are saying. Yes.
My lord, it is an injunction hearing, although it is an injunction.
Since he's appearing, give him a copy. Come back tomorrow. Come back on Monday. Why Monday? Tomorrow come back.
My
Stay
lord,
application.
Stay application, my lord.
What is the decree for?
It is a decree for, my lord, partition of a Shebite ship. Partition of Shebite ship of a Devattor estate.
Shebite ship is partible.
No, it is not partible. But the order has been passed to that effect.
Oh, they are the plaintiffs.
They are the plaintiffs.
Partition of Shebite ship.
Yes, my lord. That is the
Next we'll hear partition of the Shebites.
And even, my lord, one paragraph was written in that plane that
Can you give them a copy and come back tomorrow? So since they are appearing, it will save you cost, postal cost. Give them a copy.
Then, my lord,
You are appearing for which?
all the appellants, my lord.
No, you are appearing for all the respondents also.
I'm doing all plenty, my lord. I appear all.
Yes, all the plaintiffs are the respondent only.
All the plaintiffs are the respondents.
Give them a copy. Come back tomorrow.
My lord, can it
Mr. Mondal, learned advocate, appears and submits that he has instruction to appear for the respondents and a copy of the application be given to him. Push up. Accordingly, the learned advocate on record for the petitioners shall hand over a copy of the application on Mr. Mondal during the course of the day. Push up the matter shall be listed tomorrow under the same heading. We'll take up tomorrow.
My
Just
lord,
give a copy to
my
them.
lord, tomorrow at 2:30, I have one fixed matter at DRT, my lord. It is a, so if it can be done.
DRT gets precedence.
No, my lord, since it is.
DRT has to get precedence because it is about money. That gets precedence. So you are there, we'll pass an order, expert will dismiss for default. No difficulty on our part. Yes, next. 2:30. This will be over by, I mean, I don't
Much obliged.
much before that.
Much.
This is how it is. Money. Money always wins when in court. Yes, yes, Mr. Bhattacharya.
There will be no requirement, my lord, to open the brief, my lord.
Out of time?
There is a section 5 application, my lord. Second appeal.
Lordship, I am appearing on behalf of the respondent.
Order
My
40.
learned advocate on record is there in court. No section 5 has been served upon me, my lord.
That's
the memorandum of appeal, my lord.
Memo they are not entitled to. Anyway, my lord, I don't think this will travel to that.
Why? You're withdrawing the appeal.
7-3, my lord, defense struck off, my lord, concurrent finding of both the courts below.
Then?
There is, my lord, no chance of success. My lord, 83-year-old lady, my lord, we want some time.
How much?
83 years.
83.
Some time. My lord,
So this is the first appeal.
no, second appeal. Order 41. The first
This is First appeal. So you'll have to file an undertaking then.
because yes, because even if my lord, my lord move, my lord, there is my lord burden of occupation charge which she will be.
Occupation charge and you won't have a prima facie case in the state. Yes, what do you say? It is submitted that we understand his predicament also. She's a lady of
Yes.
83 years old.
Yes, yes.
7-3 concurrent not concurrent finding. 7-3 defense has been struck out. She does not have the money apparently. So we can, I mean, you have filed a section 5.
Yes.
We can take up lock, stock, barrel and dispose of the entire thing by recording their undertaking, and they'll have to file a formal undertaking on oath that they'll leave after a limited period, which will make a part of our order. If you agree
My
to
lord,
that, take instruction.
my lord, I will have to take instruction. My learned
instruction.
advocate on record is in court. May I just take instruction and come back, my lord?
Yes, come back tomorrow. Can you come back?
Yes, yes, my lord, certainly.
Very good. Very good. So how much time? Not 1 year.
31st March 2025.
31st March. Yes, fair enough. Till 31st of March, which is, I mean, the previous trend was 1 year.
1 year, yes.
He wants for 4 months only, up to 31st
My
March.
lord
I think
kindly
that
allows me to come back
I think
with
that's reasonable.
comment.
Come back tomorrow.
My lord,
I'm obliged, my lord.
December is police help.
So tomorrow we'll take up. 6th December is police help. Today, no, tomorrow if you can't take up the matter for some reason mentioned, oh, then we won't have time. We'll record a short order. What should you record? Your submission should you record?
My lord, my just taken instruction.
The present application is one for condonation of delay in preferring a first appeal. Full stop. Or we are making it an order of the court. If
Or my lord, section 5 condoned and tomorrow.
no, together, all together. So what is the delay?
47 days delay.
Very well. 47 days delay will condone, and main
My
appeal
lord.
will say that. Very well. Upon
My
hearing
lord.
both sides, we are of the opinion that sufficient reason for the delay has been shown in the application. Full stop. Accordingly, can one
Can one.
of 2024 is allowed on contest, thereby condoning the delay in preferring FAT 372 of 2024. Full stop. The appeal be registered duly. Full stop. No orders to cost. Next. We find upon hearing learned counsel that the present appeal has been preferred against an order of eviction passed under the West Bengal Premises Tenancy Act 1997. Full stop. The learned trial judge struck out the defense of the appellant under section 7 within bracket 3 of the said act. Full stop. From the materials on record, it transpires that the appellant has not made out any prima facie case in respect of the appeal. Full stop. Moreover, on instruction, learned counsel for the appellant submits that the appellant is an 83-year-old lady and does not have the financial means to bear occupation charges, even if stay is granted. Full stop. Next para. As such, the appellant seeks some time, we'll put that in, seeks some time to vacate the premises, at least till March 31, 2025. So next para. In view of such fair submission, we grant a day apostrophes adjournment to the respondent for learned counsel for the respondent to take instruction from her client as to whether the respondent is agreeable to such proposition. Full stop. In the event the respondent so agrees, the appellant shall be directed to file an undertaking supported on oath in respect of the above. Full stop. Next para. Let the matter stand adjourned till tomorrow. Come back tomorrow.
I'm deeply obliged, my lord.
Thank you. Next.
On behalf of the appellant.
Since they have restricted to, must have some alternative arrangement. Yes, Mr. Vanis, sorry.
Nice.
Yes.
My appeal, my lord, from an order, my lord, refusing to grant, my lord.
I'm
sorry, my lord, sorry. My lord, this is from refusal to grant ex parte ad interim order of injunction. My lord, in a suit.
FMAT. Injunction FMAT.
FMAT must be. Yes.
2024, not City Civil Code.
City Civil Code.
City Civil Code we have determined. City Civil Code order 41.
Thank you.
Yes, refusal of injunction.
Ad interim.
Ad interim. What is the matter about?
My lord, suit was for declaration and injunction. Declaration to the effect that, my lord, the development agreement we entered into as owners, my lord, with the developer has been cancelled and power of attorney has been, my lord, revoked, and injunction so that, my lord, the developer cannot proceed any further for the purpose of development of the property. My lord, there was a development agreement. My lord, the development agreement said that, my lord, this would be 30 is to, my lord, 70, 30% would be, my lord, a developer's allocation. Our allocation 70% would go to them, and my lord, they will prepare a building plan. My lord, the building plan will be vetted by us, and in the building plan, my lord, they will indicate specifically with different colors that, my lord, what would be our allocation and, my lord, what would be their allocation. And only after we approve, my lord, that will be, my lord, submitted. And my lord, there is a, my lord, century-old building which would be, my lord, then demolished and a new construction would come up. My lord, agreement also says that time is the essence of the contract and all. My lord, this was an agreement of 13th of March 2019. Now, my lord, what we have come to learn, my lord, nothing was being done. My lord, we terminated, my lord, the agreement. We revoked the power of attorney. Notices are there. My lord, now what we have come to learn that, my lord, a plan was, my lord, submitted without, my lord, placing it before us. The plan was submitted for, my lord, reconstruction, rather, my lord, repairing, my lord, of the building. My lord, that was not at all the idea. The idea was, my lord, to pull down the existing structure and, my lord, to erect a new structure. My lord, since the new thing has come up, my lord, we approached before the learned court below saying that, my lord, we have already, my lord, cancelled it and all. And what they are doing, my lord, is not even conceived of, my lord, in the agreement. When the learned court below has passed an order, my lord, refusing to grant ad interim injunction without, my lord, giving, my lord, an iota of reason. And my lord, there is something recorded which was not even our submissions.
What sort of injunction you are asking for? No, no construction.
My lord, let them do nothing, my lord, as of now. Let them come and, my lord, answer, my lord, what they have done and what they are proposing to do. Till that time,
Let us see
they
the
have-
impugned order once.
yes, my lord. The impugned order is
Because
there at
immediately
page
after
one.
the order 41, we also have to take up the injunction application.
Yes.
So therefore, let us see the impugned order once.
No, 176 of the stay application, if my lord can say, take. My lords can, my lord, straightway come to internal page 4. The reasoning, my lord, I will show to your lordships. My lord, somewhere down below, my lords will find, my lord, a one-word paragraph considered.
Hmm.
My lord, after that, the reasoning is there.
But the aspects have been considered. Let us see what has been. Oh, acha.
This is the reasoning. And my lord, the paragraph immediately preceding, my lord, this one-word paragraph is something imported, my lord, we do not know, my lord, from where.
Absolutely without reason. In narrated their arguments and we want status quo. That's the property. Well done. Status quo we are deprecating without indicating the status.
Well,
Will
kindly
restrain
injunction
them from
doing
doing everything.
My
Anything.
lord, with regard to the property. My lord, admittedly, we are the owners. May I show, my lord, the relevant paragraph, clause, my lord, of the development agreement, which, my lord, stipulated this.
No need, no. Leonard, you have checked up yourself.
Yes.
You have checked up the
My lord,
document.
kindly see it
No,
for
no,
once. Kindly, my
no.
lord, see it for
No,
once.
no. I have to take some responsibility.
Very well. Very well.
Yes. So that later on we can fix it on you.
My lord,
If
I
they
will
file
lose
a
my
vacating
good night's sleep,
application,
my lord, I will go to my go back to my chamber and will read that clause, my lord, again and again.
and we'll take a good nap. Resting on your.
Kindly see it once, my lord, for my lord, good night's sleep.
You must have checked it up.
But I have.
Either you or Mr. Kormokar, none of you checked up.
I have, my lord, I have
Ashok
marked it.
Tanman.
Kindly just see
We will not
once.
record that we are relying on. We are relying on our own.
Page 76, my lord.
The present, acha, na.
Yeah.
Order for already. We find from the impugned order refusing ad interim injunction that the order is absolutely devoid of reason, full stop. After the narrative as argued by the plaintiff stroke appellant, comma, the learned trial judge straightaway observed that in his considered view, the other side is necessary to be heard before passing any order, and as such refused the ad interim prayer of the appellant. Full stop, next para. Even from the materials annexed, comma, we find that prima facie the respondent acted in derogation of the development agreement originally entered into between the plaintiffs, between the appellant stroke owners and the respondents developers. Pushed up, whereas the agreement required the developer to have the sanction plan vetted, VETD, vetted by the owners, comma, the same was not done. So furthermore, comma, apparently the developers proceeded to seek a sanction for certain repair works, which was beyond the development agreement. Push up. In such context, comma, The plaintiffs stroke appellants averred in their plaint and injunction application that the respondents' opposite parties became extremely aggressive in dealing with the property by illegally and forcibly ousting the existing tenants in the shop rooms, and with the help of local politically and financially influential persons are the opposite parties are even trying to deal with the property in utter prejudice to the interest of the petitioners. Full stop. Even having recorded such averments, comma, the learned trial judge refused to grant ad interim injunction, which, in our opinion, comma, is prima facie derogates the law. Full stop. Next para. Accordingly, the appeal will be heard on all the grounds taken in the memorandum. Full stop. Next para. In view of a strong prima facie case for hearing of the appeal on merits having been made out, the respondents respondent numbers 1 and 2.
My lord, they are respondent numbers 1 and 2.
Pro formas are with you, or
Pro forma is not with me.
so will not with them also.
No,
So
not
can we
with them
dispense with
also.
service of
Yes, my lords can. My lords can.
restraining the defendant numbers 1 and respondent numbers 1 and 2 and or their men and agents from selling, transferring, encumbering, and not alienating the suit property in any manner, comma, from changing the nature and character of the suit property and or dealing with the suit property in favor of third parties, and stroke or disturbing the peaceful possession. You are in possession.
No, I'm not.
Acha, and not disturbing the possession. In any manner whatsoever, till disposal of the present application. Full stop. Next para. Nature, character we have given: selling, transferring, alienating, encumbering, dealing with.
I'm not carrying out any construction or demolition work, my lord, in the premises.
Nature, character. Nature, character. Till disposal of the application. Full stop. Next para. The petitioners shall, appellants to petitioners shall serve copies of the injunction application on the respondent opposite party numbers 1 and 2, indicating that the matter shall be listed, that the injunction application shall be listed for hearing in the listed for hearing on January 20, 2025. Full stop. An affidavit of service to that effect shall be filed on the next returnable date. Full stop. Affidavit in opposition, if any, shall be filed by January 10, 2025. Full stop. Reply, if any, shall be filed on the next returnable date.
Mr. Tomokar was insisting that they should also be injuncted from proceeding any further on the basis of the power of attorney revoked by us. They can show it to the corporation, get a plan again, sanctioned and create.
Where is that power of attorney?
But the power of attorney is there at page 116. Which will be revoked at page 167.
যেখানটা till disposal of the application বলেছি সেখান থেকে তারপর full stop এর পর the respondent numbers 1 and respondent opposite party numbers 1 and 2 shall further remain restrained from acting on the development power of attorney annexed at page 116 of the present application, which has allegedly been revoked since by the appellants, comma, also till disposal of the application.
So great.
None appears for the parties at the time of call. Let the matter stand adjourned for the day. These are coming from the department, so they will give us some time.
But I am for the app.
Yes. Right now, you don't have a right of hearing, but after.
Yes.
Yes. Please take this. Yes.
Lord, I prayed for a declaration in respect of title in respect of a property which my father, Lord, had purchased in the year 1964 in respect of 41 decimals of land. Now, Lord, it was a case of the defendant that they, by virtue of, Lord, a deed of gift, shows that in respect of this particular dag number, one dag number is only involved here. That they have obtained by way of a gift about 18 decimal of land in that particular dag number. My case was
demarcated according to
No.
them. 18 decimals.
18 decimals. Now, my lord, so far as my lord, there are my lord, 3 deeds are concerned which are my lord exhibited in the court below. One deed is my lord pertains to my lord a sale in respect of my lord in my predecessor favor. And my lord, there was another gift deed which was executed on the same date in favor of my lord the defendants, my lord the predecessor. That was a deed of gift.
Same day.
Same day. So both, my lord, at a point of time,
Yours
deed
had a
was
larger area, 41.
41
And
days.
they are a part out of that.
Lord, that is where, my lord, the difficulty has arisen.
All right, please proceed.
That is, my lord, the gift deed also, my lord, in respect of that dag, 18 decimal.
And in your deed?
41. 46 decimal.
In respect of
Same
that?
dag.
Oh.
1304. Now, my lord, in respect of, my lord, the sale deed, there was another, my lord, a corrigendum deed executed later on. The corrigendum deed of the defendant that was not exhibited. The corrigendum deed said that I have transferred 18 decimal in respect of, my lord, a bata dag. That is, my lord, a dag carved out of, my lord, the parent dag.
Bata dag is
that is, my lord. Yes.
No, the predecessor in interest was same person executed. He was your predecessor, otherwise no,
No.
a third party.
No, that was my predecessor also.
And they are a stranger.
Yes. Now, my lord, no, they are also, my lord, my
related. Very good.
Brothers, my lord. If your lordship kindly comes to, my lord, internal page 5, my lord,
Yes.
of the trial court, I'll just relate from this particular document. It will be easier, my lord, for us to relate.
Yes. Page 5 of this. This is the correct to because we arrange your memorandum, report judgment, could decree, could decree, because it's reverse. First could decree, could judgment, then could judgment. Memorandum because this is the correct first then Yes, Mr. Mukherjee. Page 5.
Yes. Now, my lord, so far as exhibit 1 of my client is concerned, that is, my lord, a sale deed of 2 bigha of land in, my lord, CS dag number 1304. The only property, my lord, we are concerned about is dag number 1304.
Yes.
This is a deed from Tara Prasanna Ghosh and another to Shikhar Basini Devi. That was of the year 1924. No problem with that. Then the exhibit 3 is sale deed number 6278 of 1964. This is where we are coming. This is not from Shekhar Basini to Ramesh Chandra Mukhopadhyay, my predecessor. That is 46 decimal in 1304. The dag number is same. Exhibit 3. The correction deed, which is exhibit 4, it was executed on 3rd of March 1984. This correction was
1984.
After 20 years.
Correction did who are the parties there?
Yes. Shekhar Basini to Ramesh, who was, my lord, the vendor in, my lord, the 1964 deed, and, my lord, the purchaser in the 1964 deed. The same parties. That this particular exhibit 4, it has a deed number of 1750 of 1984. This particular correction was in respect of, my lord, other dag numbers excepting 1304. I've got all the deeds with me. Now, my lord, kindly skip over to, my lord, the exhibit, that is, my lord, the deed of gift, exhibit I. The next page it is there. That is the defendant's, my lord, the deed of gift.
Defendants are alphabetically. Plaintiff exhibits are numerical.
On different exhibit 1 to 3 4 means 20 and exhibit ABC means different.
I. Exhibit I, my lord. That is the next page, 6.
Oh, sorry.
Last
Yes,
entry.
yes, yes.
Yes. The deed of gift. Mine was a deed of sale. This is a deed of gift.
Right.
Then 6779 of 1964, that is also executed on 9th of October 1964.
That is in respect of 1304 only.
1304, 18 decimal.
By Shekhar Basini.
Shikhar Bashini. To Lord,
Them.
it was to Robindranath Mukherjee, that is, my predecessor was Ramesh. This is Robindra, they are related.
Not Suresh. Yes. Right.
Now, my lord, there was another, my lord, a correction deed which was executed by Shekhar Bashini in favor of my learned friend's client, my lord, predecessor of learned.
You should all sue Shekhar Basini posthumously.
That particular,
What was the date of that?
That was the same date. No, for 84 the date. Yes, 22nd of March 1984. Our correction was 3rd of March 1984. There was 22nd of March 1984.
All right.
But this was not taken on record even by you of an additional evidence. Although I applied under Order 41 Rule 27, the learned code below, the appeal code below was of opinion that I did not satisfy the ingredients of Order 41 Rule 27, did not take that into record.
You did not prefer a revision?
No.
So we can look into that.
Yes, that
section
was
105.
dealt with when the final judgment was delivered in the appeal. So, in that correction deed, what is that content is, that in respect of that 18 decimal, the area remains constant. The plot number is changed to 1304 by 2128.
Yes. Your correction deed is not relevant
My
because it
correction
does
deed
not
is not
touch
relevant
1304.
because it doesn't touch 1304 other properties.
And 1304 by 2128 is a bata of 1304 original.
Yes. The difficulty is in respect of that bata dagna is comprises of only 5 decimal that will transpire from the ROR which has been exhibited.
But the correction deed says 18 decimals.
18 decimal. This is where the exact the problem lies.
Right one once conferred on them by the gift deed cannot be taken away. So.
Lord, I will come to that,
Unilaterally,
Lord,
by
in
the
a way.
donor even.
Lord,
He lost title.
Because in which point of time, Lord, that was executed, that is not German here. Because if the sale deed was not executed at prior point of time, the gift deed could not have given Lord that particular area which was subject matter of sale.
If it's executed on the same date, then registration time is recorded.
Yes, well, that is the registration act says so.
Registration time is recorded here.
No, time to record.
Then it relates back.
It was executed on a date. Registration was subsequently on the same day of both the dates.
But the moment it is registered, it relates back to the same date.
But that is the execution date and the registration.
But once registration is effected,
yes,
immediately relates back. If your deed was registered earlier, there is they coincide. Your 46 and his 18.
Yes, apparently, Milord, that is the defendant's claim is that out of that 46, now it is 41 because I have sold Milord 5 decimal. That their 18 decimal is inclusive into my property because of the fact that the gift deed contained Milord the same dag number. And the defendant failed to produce Milord the correction deed. In the correction deed, it was Milord the dag number which was corrected to bata dag number. Now, if bata dag number is not considered, then the area of the bata dag number is 5 decimal only. That will find from Lord the exhibited ROR.
But you filed the suit for declaration of a title regarding the entire 46?
41, Lord, because 5 has been not sold out. The learned trial judge said that there was a correction in the record of right and pursuant thereto, Lord, there was a miscase filed under the West Bengal Land Reforms Act. In that, Milord, the name of the defendant were recorded in respect of this particular Milord, the property in respect of 18 decimals of land. That has attained finality. There was section 51C2 debars the civil court from Milord interfering with the indictment of the revenue officer in the record of rights. One.
Land Reforms Act.
Then, but that your lordship will find, the finding of the trial court,
So, but
in
on
the
the
internal page,
what about the merits, Mr.
but the merits on the point of law,
Even
that
if
the
we
learned judge
say
has-
that that's a good ground,
But first of all, the learned judge should have not been swayed away by not being swayed away by that entry in the record of rights. It is
True.
at best evidence of possession.
yes.
But title deeds cannot be brushed aside.
The title deeds are looked into the conclusion. Why shouldn't he agree? I mean, Mr. Mukherjee, 1964 gift deed was executed simultaneously on the same date with you. So they get a right that cannot be curtailed by a subsequent 20-year after deed.
Now, Lord, so far as my sale deed is concerned, Lord, it was executed on 7th of October 1964. Executed, not registered.
7th of October, 64.
64. And
Yes.
Lord, their gift deed is executed of 9th of October 1964. But registered on the same date.
If registered on the same date, then your deed wins.
That is not the only point that I will be.
Section 47 or
But I'll just-
Registration Act probably. Most probably Section 47. We don't have a Registration Act.
But the learned, none of the courts went into this question. The trial court was of opinion because there is a order in the miss case. I am not touching. I am.
Appeal court did not improve upon that.
Lord, the appeal court even rejected that additional evidence. Your Lordship will kindly come to the finding of the appeal court. Starts at internal page 4, the decision with reasons.
Yes.
Then order 41, rule 27 is dealt with up to page.
This is the entire trial court judgment.
No,
yes,
Lord, the trial court judgment is
yes, 51C2.
That is the trial court judgment. That is the trial court judgment.
The first substantial question of law is why you obeyed, you briefed. Yes, 51C2, appeal court also.
But,
is there anything against you, Mr. Mukherjee, on that? I mean, anything else was considered?
No, Lord. Lord, all are going by Lord that because
no, they are your arguments.
Record of rights are there, and Lord, there is a presumption of Lord that they are the owners. None of the courts dealt with Lord the effect of Lord the deeds, whether the title deed will prevail over the entry in the record of rights. Then Lord, internal page 6 of the appeal court, whether 18 decimal or suit plot has been correctly recorded in the name of defendant number 1 in LR record of rights. This is one of Lord the question.
Can you see that the prayers in your plaint once?
Yes.
How could the courts do this?
Character copy.
These are consequential. One is that either
Have you got a registration at section 47? Mr. Mukherjee, please check up whether it's section 47.
47.
Will be one of the things because after registration it relates back to the date of execution. Yeah, if their deed is second both the courts will
We're admitting without hearing you. But immediately after that, we'll hear you. But that's all. The two grounds, Mr. Mukherjee, one section 47 and the other records of rights. And the other records of rights. Yes.
Blood order 41 rule 27 additional.
Very.
Because without that blood, but that will be very difficult because the correction deed.
Very. The present second appeal will be heard on the following substantial questions of law, niche Roman 1. Whether both the courts below substantially erred in law in placing reliance on the entries in the records of rights while deciding the title of the parties, comma, in the teeth of the well-settled proposition of law that entries in the records of rights do not confer or extinguish title. Second, Roman 2, whether both the courts below erred in law in failing to take into consideration the effect of Section 47 of the Registration Act insofar as the sale deed in favor of the appellant was executed on October 7, 1964, whereas whereas the gift deed in favor of the respondent's predecessor was executed subsequently on October 9, 1964. Full stop. Third substantial question of law, whether the first appellate court erred in law in dismissing the appellant's application under Order 41 Rule 27 of the Code of Civil Procedure without considering the effect of Order 41 Rule 27 within bracket 1 within bracket small b and small bb. Full stop. Next para. You've got any connected application? Injunction. The injunction application is now taken up for hearing. Injunction টা appear করছে তো লিস্টে? তুমি কনভারসেশন ছিল নাকি? অনিদিন আপনি একটু দেখে দিন ইনজাংশনটা appear করছে লিস্টে? কেন দেখাচ্ছে না?
কেন দেখাচ্ছে না?
Then go before the single judge. Then they'll have to go before the single judge, right? Because second everything after order for turn has to go through.
ওটা একটা কন্ডোনেশন ছিল, ওটা হয়ে গেছে, ডিসপোজড হয়ে গেছে।
Very well. This much.
But there's
so should we direct you to put in the requisites and all?
my lord. And since my lord,
Mr. Yes, you are appearing for. We can record your appearance and say that service of notice is dispensed with, because there is no application, there is no scope of conduct. In view of appearance of the respondents, you are appearing for all the respondents.
Actually,
in view of the appearance of the respondents to counsel, comma, service of notice of appeal on the respondents is dispensed with, full stop. The appellants shall put in the due requisites, including declaration and written up notice form within a week from date. Stop. The trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 4 weeks, Mr. Mukherjee.
Lordship.
4 weeks from date,
Lordship.
because only these papers are. Within 4 weeks from date, and serve a copy thereof on the learned advocate for the respondents. Full stop. Liberty to the parties to mention the appeal for hearing as and when the records arrive and examined and are found to be complete, and the appeal is otherwise made ready for hearing. Thank you.
Lordship. But may I include the correction deed in the paper book? Because why I say this?
You can include the order for Rule 27 as an annexure to that. You can, because you know, Mr. Mukherjee.
Yes.
Because if it's a ground in the appeal, even in a second appeal paper book, you can incorporate.
I'm great.
It will be easier for all concerned.
Yes, Lord, that is
right.
That will be one of my.
That is one of the grounds in our today's order. So you can include.
I'm great.
Thank you. None appears for the parties at the time of call. Let the matter stand adjourned for the day. Order for second appeal, order for the doing of the stop in civil case. When we got the right to do order for matter, we got illegal because we did civil matter. None, same order. Adjourn for that. It's very good. More commercial matters, these matters are not very good. These
But this matter,
Yes.
that was heard. Petitioner
Yes.
is the lawyer of Jalpaiguri court. And the
Do I know him?
wife-
Do I know him?
Yes, he's my client.
No, do I know him? Then we have to.
I think, my lord,
Pojit Singh, I don't remember.
I don't know, respondent is a judicial officer now posted at Andaman. For a custodian.
Andaman.
What?
I am the zonal judge of Andaman. I cannot. I should not take her.
Orkovati Singh.
She is now the zonal. She is now in Andaman. You're sure?
Now, previously, Mr. Parthabothi was the advocate for respondent. Now he has given no objection. Now I'm told the Shishandu Madhubada now he has engaged.
I am not. I don't
Another
have any
matter, my
qualms
lord,
otherwise.
is the custody of the child, my lord.
Because I am as a zonal judge, I am only in charge of on the administrative side. So if she's a party somewhere, no difficulty.
It's not difficulty. So may I do one thing, my lord? I just subject notice because my client has also.
Because
filed-
otherwise, every judge will be
Yes, that's it.
one side judge,
And
one
it's
side
taking up this
advocate.
matter also.
You will never get it heard.
Yes. But one suit for divorce has also been filed in the Jalpaiguri court.
This
Yeah.
arises from what, Mr.
No,
Patel?
it's a guardian of what side?
You
Section
paid for
25.
custody.
For custody.
You paid for custody.
No. Wife.
Wife paid for custody, got it.
And now, admitted during COVID period.
Custody under which provision? Guardianship, what is that?
Guardian brother. The promise, my lord, my client also filed a divorce suit also. That was going in the Jalpaiguri. Now transferred in Malda district court. Now the twice he paid for first that was transferred on the prayer of the wife. Now again, she has paid for section 24. She has paid for transfer in Calcutta because she has transferred to Andaman. And that is also going on.
It was transferred first from where to Malda?
Jalpaiguri to Malda.
Jalpaiguri, Malda, then again to Calcutta. Now it has come to Calcutta.
No, has not yet.
That is
going
pending.
on. And that's there she has filed a division application, second division application. Since she has transferred to Andaman, now again she paid for
That is regarding the divorce suit.
that deposit.
But
No,
we are not concerned with
no,
that.
but I'm saying
Hmm.
it's a question 2 times that matter is going to for mediation. But
Again, sending
that
to
appear
mediation.
failed.
If it failed before mediation, then we have to decide either way.
No, my lord, this is guardian.
Yes.
No, no, better. I
This
said,
appeal is appearing for the first time.
this appeared for the first time. Today, no.
No, no.
Yes, that appeared. The first is appeared before Maharaj is Somapti Chatterjee and this is Mondol. And thereafter.
It was admitted formally. One line of
yes, they have also filed an opposition also.
Acha.
So as a sub notice upon the system, the one that side inform him.
Do that then. When should he keep it?
Then as a.
What is the age of the child? Must have become an adult now.
Yes.
Become an adult?
No, first. First or youngest is the adult. She's all along she was in the.
Elder is adult.
Elder.
And the younger is?
Younger, no, has not.
What is the age?
He's going to join.
Younger is?
Younger, not yet adult. He's reading in.
17 years,
class
364 days.
No, he's a class 9 or 10. Now he's still in the custody of the mother.
He'll become an adult by the time this is over. So nothing will remain in this.
The mother, once upon a time, I talked to Orkovati Singh also, where is agreeable for mutual divorce.
Yes.
Initially, she agreed. Now, well, I do not know why. But she is not agreeable.
But regarding the child, what is the use of carrying this on? I mean, if the child has been he or she, child.
He.
If the child is now, I mean, in class 9, 10, he has been with the mother all along.
Obviously, grandfather, grandmother, they are very much.
Visitation we can
interesting.
consider. Visitation we can. Visitation has not been given to you.
No. Oh, yeah, yes, that mediation has been during vacation period.
Anyway, give a notice to the other side.
Yes.
Uh,
The elder son is all along is staying with the mother. And the father, he was with the custody of father.
this is now an ego problem.
Ego.
Anyway, if you,
She was agreeable initially for divorce.
who is the respondent number 1? How many respondents are there?
Yes. Yes.
Apart from,
Fauji
oh, it's written in the order sheet. Very well. Learned counsel for the appellant submits in his usual fairness that the respondent is represented by an advocate, full stop. Accordingly, the learned advocate on record for the appellant is requested to serve a notice on his counterpart appearing for the respondent, indicating that the matter shall be listed. When should you list it? Tell us. Next week we are listing. Shall be listed under the same heading. This is order 41. Then order 41 it cannot be.
I don't, it cannot be order for. One time, the last petition is heard by my Lord Judge IP Mukherjee and Nijamuddin. The matter was released.
And the other one will also become. Next be listed on December 12, 2024 under the heading hearing. Who's up next para? But when was that order passed?
Last order.
No, it was never admitted formally to have been.
No, but opposition, they have used it.
Oh, yes. Who's up? আচ্ছা যেটা বললাম এটা থাকবে তার আগে একটা লিখে নাও প্রথমে। Oh, yes, Justice Shamati Chatterjee also released on that ground,
Yes.
zonal judge.
Release, yes, and other judge.
You'll never get a judge. Let us hear it up.
Other there will be
In view of the প্রথমে এটা করছি in view of the previous orders passed and keeping in mind that the present first miscellaneous appeal concerns questions of both fact and law, comma, the appeal is deemed to be admitted. তারপরে যেটা বললাম
it will be listed on next.
Listed on 12th December, next week, Thursday. এটা কিন্তু হিয়ারিং লিস্টে আছে, হ্যাঁ?
My lord, in this matter, Sularna Bhattacharya appear for the petitioner, my lord. His personal difficulties take the not this week, my lord.
It has been admitted.
I don't know. I have
You are
no
not
idea, my
sure.
lord.
I will check it. No, apparently not. Well, on the prayer of the appellant, the matter is adjourned for the week.
Yes, my lord.
Thank you. দেখি তো আগের কোন অর্ডার আছে কি? You give them a last chance. When none appears for the parties at the time of call, full stop, as a last chance to the appellant to appear and argue the matter, comma, the same is adjourned for the day. কাল থাকবে। দেখি একবার আগের অর্ডার আছে কিনা, সেম অর্ডার, একই অ্যাডভোকেট, ইউর রাইট, ইয়েস, IDFC and Tata Financial. Cholamandalam, I don't know what happened to Chola, that I don't find clear. Yes, I remember Cholamandalam. আগের অর্ডার আছে, সেম অর্ডার। I dreaded line. না বড় Mr. Dotto and Mr. Bera, we are not taking up appeal hearings. Yes.
On the last occasion, I undertake to file this.
What?
The report, my lord, and other information, those are not on the record.
What I am submitting, the copy which is served upon us.
Yes.
That it does not do any consonance with the order passed by your lordship. The last occasion, they bring the original award, but your lordship seeing that, please make it Xerox. That has not been supplied. Kindly ask them once again.
Mr. Dotto, please supply the copies. We'll take it on record on the next day because we won't take it up.
Next day, but kindly pass an order. I have got the copy. I have checked it. The award has not been produced. Unless award is produced, I cannot proceed with the hearing. Ask them in that direction.
No, award is not there, Mr. Dotto.
Award is not there.
Award is there, my lord.
Just show Mr. Bera.
Page 20, page
No,
27.
kindly see that is then that
Please
is
check up, Mr. Bera.
I have seen that. That is an interim award or that is a preliminary award. There is no preliminary award has been marked with the final award. And
Well,
they
there
have
are-
irrelevant documents.
There are two awards
They-
have been, my lord. Yeah, my lord, initially, my lord,
The big document they have produced, they have not annexed it. I am telling your lordship with
Sir, also
responsibility.
please check up. The final award has to be.
front page has not been.
Original দেখান দেখান আপনি awardটা এখানে
Final award has to be there.
kindly দেখান
Your official, probably there is some communication
two
gap.
pages of the apportionment
Some communication gap with your officer. Just tell him that the final award has to be.
final award
And
দেখান
ওইভাবে কেন রাখেন কোনো রেকর্ড মেনটেন করেন না
Where is this copy?
Well, this is the total picture, my lord.
That is not the total picture. Picture is still left.
Only in respect of the award past.
That is not the award. That does not disclose the date. What they have annexed only apportionment of 2 pages. That is not the award. Award is must be in form number 13, I think.
Mr. Bera, Mr. Dotto, ask your client to have a conference with Mr.
They will not produce. Kindly keep it.
Ask your client to have a conference with Mr. Bera. He will sort out the document.
My
and-
lord, he will make my lord inspection of the award, my lord, original award.
Do that.
Yes.
Whatever you like, you do, but I'll not take it up without
I am
Justice
with
Uday Kumar.
responsibility, generally I do not. But this is the document your lordships ask for to produce.
Yes,
They
yes,
have
absolutely.
not-
That
and
that
ask-
will.
That they have not. I want to see the award. That for this day.
Sir, Doctor, can you just please ensure that you have a sitting with Mr. Bera, right? I mean,
Yes, yes.
wherever you can, so that
Right
it
now,
can be
my
resolved.
lord, he can
Right now, it
inspect,
can
my
be
lord,
done. Yes.
enter award.
Mirror, what I
You can use the chambers of any of the council who are sitting here and do this.
not mirror,
Or their chairs in the bar station.
your lordship's
Take your time
presence,
until they go back. Do that.
Only I want.
My lord, this is impossible to make.
Only I want front 2 pages of the award and the last page of the award.
Is since
My lord, I'm giving that one.
since the regular bench is not sitting now, let the matter stand adjourned till December 19, 2024. Next matter.
My lord, I'm giving that up front of 2 pages.
Do it, do it, do it. Next matter.
Last page, the date. Last page.
Next matter.
Yes, my lord.
This matter.
Yes.
Mr.
Mr. Mr. Probal Mukherjee, I won't grant any time on his ground.
Just a minute. Madam, your lordship is fixing our matter on next week.
19th. 19th after Justice Kumar comes back. Because Justice Kant will not be available after tomorrow.
Much obliged.
And somebody else will be there for it.
Happening matter, my lord. Some exhibits are not in the paper book. Supplement papers are ready. Unless they give the directive to file the supplement available and copy I submit.
No, if you have taken the name of a senior counsel, you have to pay the fees also. Do you know that? We have resolved that in the last meeting also. If you take the name of a any senior counsel, you have to pay him full fees because this tantamounts to appearance. He cannot act without you, but he can react without you. You want to file a supplementary paper book? Give a copy to them, Inspector.
Hey, file that.
Give a yes. Do you have extra copies?
Extra copy I have.
File it. Give a copy to them. So the original paper books are there.
Yes. Yes.
Yes. So we'll take it up on the same December 19th. Supplementary paper books filed on behalf of the appellant. Appellant today be kept on record. A copy thereof is served on the learned advocate for the respondent. Full the matter shall be taken up for hearing on December 19, 2024.
Number 23.
You want to go towards the subset for this you have there. Yes. Sorry. Yes.
I have got the response.
And for the applicant.
Yes. First appeal hearing
Hearing probate matter.
next week after next, because we won't be able to finish only for that. We have tomorrow also, but even if we complete hearing by tomorrow, then we won't be able to pass judgment.
90.
Yes, and Justice Bagchi will come back and let the matter same order. Since the regular bench is not sitting, let the matter stand adjourned till December 19, 2024. Short matters we can take if this is small matter.
What matter?
Citations. I think number 12 is the journal suspense.
Yes. No, 24 হবে না। 25 হবে। 24 তো no date fixed. আগের কোনো অর্ডার আছে কিনা অর্ডার শিটটা শুধু দিন। None appears for the parties at the time of call. Let the matter stand adjourned till December 19, 2024. সব ডিসেম্বর 19। আরো বেশি করে অর্ডার 41 পাঠাতে বলবেন, ফাঁকা হয়ে যাচ্ছে লিস্ট। Tomorrow we can hear out some order 41 matter because the appeals cannot take a period. Order 41, 5 minutes matter, 10 minutes. এটা তো দেখে নিন তো কোন আগের অর্ডার আছে, শুধু অর্ডার শিটটা দিন, পেপার বুক লাগবে। কেউ না থাকলে শুধু অর্ডার শিট দিন, সেম অর্ডার 19। Yes.
For the plaintiff respondent.
What is this order 41 stage?
41 stage.
Wait.
So, guys, আসুক করে দিচ্ছি। আসেনি, আমার জুনিয়র আসেনি, ও
But give your junior's name because I cannot record your name. On the pair of the appellant, the matter is adjourned for the day. Ask your junior to give his name also. Whenever he or she comes, ask them to. We are adjourning.
অভিজিৎ রায়, অভিজিৎ।
Yes, Mr. Bhattacharya. Yes. বড় হিয়ারিং হলে এমনিতেও নেবো না, তবে হ্যাঁ ইনশিওর করে আপনি যদি তাহলে
These perhaps are all separate matters. All separate. Perhaps it was, since it's assigned, perhaps it has.
maybe the same order of assignment. Yes, you are right. Absolutely right. So তাহলে এক এক করে ডাকুন।
28 শুধু বলুন।
হ্যাঁ এগুলো না আর একসঙ্গে দেখাবেন না, বুঝলেন তো? এইটার জন্য হ্যাঁ হি ইজ অ্যাবসলিউটলি রাইট। Right. So one by one.
Well, 28 is my appeal.
Yes.
My lord, I'm praying for an urgent stay, my lord, on the impugned order. And before I place the impugned order, my lord, may I just
This was admitted under order 41.
No, it's
Formal
appearing-
admission has to be
it's-
done.
It's appearing for the first time.
All right, we'll admit and then first miscellaneous appeal, automatic admission, Mr. Mitra. We'll
It's a
record an
mis-
order of admission, but regarding the application, we have to hear.
Yes, my lord, there's grave urgency, my lord. We are on the verge of, my lord, losing our place. My lord, there's a building. We are 4 tenants in the building. Now, my lord, the landlord.
Let us just formally record the order of admission.
Yes.
Since the present first miscellaneous appeal includes both questions of law and fact, comma, the appeal shall be heard on all the questions raised in the memorandum of appeal. Next. এরপরে ক্যানের উপর অর্ডার হবে, ক্যান 1 of 2020. Yes, please continue.
My lord, before I place the impugned order, may I just give a brief background, my lord, of the facts? My lord, there is a building.
Yes.
It's a ground plus 5 storied building. It might be 4-storied building, my lord. G+4. It is infested with tenants, quite a few tenants. I am 4 of the tenants who are, my lord, in the building. The landlord had, my lord, written to the KMC alleging that the building is dilapidated and you please allow me to demolish the building. The KMC did not take any steps. Then the landlords preferred a writ petition.
Mr. Akmal, please give us half a second. এই অনিন্দিতা শুনুন না, আপনি না এইটা either
telling the KMC that we would wish to demolish this building, you please allow us. KMC did not give any approval. In action against KMC, the landlord then approached the writ court. The writ court passed an order that KMC will deal with the landlord's representation, will take into account the interest of the tenants, and if the municipal commissioners of the view that a demolition is necessary, prior to that, he must consider a plan in which the tenants would be reaccommodated in the building and that the interests of the tenants must be taken care of. That's the order passed by the writ court, where we were private respondents as tenants. The landlord had implemented us in the writ as private respondents.
Right.
We were awaiting the KMC to intimate us an opportunity of hearing. Some months lapse.
It was incorporated in the order itself. That
Yes, it's there in the order. I'll place the order. It's a part of the record.
Let us proceed.
Then suddenly, I am served with a plaint and a copy of an ad interim ex parte order passed by the learned city civil judge, wherefrom I learned that a suit has been filed by a developer who claims to be a developer of the same landlord who had filed the writ petition, wanting to demolish the building, where these landlords have been impleaded as pro forma defendants.
And who is the defendant?
And we are the defendants who are private respondents to the writ petition. We are the defendants.
What is the suit for?
And the suit, the prayer is that there should be a declaration that the builder is allowed to construct the building in terms of a purported plan, which has been approved in complete breach of the order in the writ petition. Because what plan we do not know. As per the writ, we had to be given an opportunity of hearing and our interests were to be protected. So in terms of some purported plan, the plan is mentioned, declaration and injunction, perpetual injunction, restraining us from interfering with development work in terms of the plan. So effectively, they would demolish and I would be a spectator.
That has been granted.
Now pending that, there's an interim prayer that they would be allowed to continue with the development work without touching my portions, four rooms that we have, without touching our portions. They would continue with work in the other parts of the building.
Is it feasible?
That is, it is not feasible. Firstly, it is not feasible. But having said that, that is the prayer. This was granted at the ad interim stage. We came in appeal to the High Court, Justice Showman Sen's bench. Appeal court sent us back to the court below, clarifying that if we are in possession, we cannot be evicted without due process of law. Having said that, we haven't been able to show much that we are in possession. So we have the liberty to bring on record whatever documents that we have to show our possession and approach the court below, and the court below will decide.
But in any event, the ad interim injunction does not touch your possession otherwise.
Yes.
At least on paper, it does not.
Now under Order 39 Rule 1 and 2, the main prayer in the suit has been allowed that the building can be demolished and I'll be looking at the building.
A negative form that you won't be able to restrain them from doing that.
Yeah. So what has been granted is in excess of the prayer in the interlocutory petition. The suit has been allowed at the ad interim stage.
The interlocutory petition itself was the prayer in the injunction application was not in tune with the plaint.
No,
it was only that
other portions.
Setting aside your portion.
Other portions.
Oh.
And in that application, the suit has been decreed. Suit has been decreed, and also the interlocutory application has not been disposed of in the order. The order doesn't say that I'm disposing of the interlocutory.
Let's see the order first.
Kindly see the order now for a moment. This is one of the background in which the orders.
Objection and whatever was exchanged. Written objection was filed by you.
My lord, I must also point out before my lord placing this order that the court below appointed a commissioner. 2 advocate commissioners were appointed to go and do an inspection.
Yes.
The commissioners filed an inspection report. In the report, it is stated that I am in possession. All 4 defendants are in possession. We filed an exception to the report because the area which is shown is less. As per us, the area of the room should have been little more. So to that extent, we filed our objection. We also filed an application to cross-examine the commissioner, the advocate commissioner, under Order 26 Rule 10. That application is pending. No hearing of that application. My exception to the report is not heard. I am in the dark. Matters adjourned 3 or 4 occasions, and suddenly this order is passed alleging that I haven't taken necessary steps in the matter, and therefore it appears that I do not wish to proceed with this matter. I am showing no interest, and an order is passed decreeing the suit altogether.
Let us see the order.
Kindly, have a look at the order. Page 167, Today is fixed for passing necessary order. 1 application for extending the ad interim order of injunction has been filed. Let it be kept with the record. It is a long pending dispute, and I have heard both the sides. For last few months, the defendant's side have stopped taking any steps in this record.
You didn't take any steps for the last few months.
This is contrary to record. My advocate on record before the court below is here with me today. I had specifically, my lord, requested for this. My lord, steps have been taken. We have always, my lord, been there, and we filed our hajira, which is, my lord, what is done in the.
But you did not file the written objection to the main
See-
injunction. Have you filed your
Yes.
objection to the injunction?
We filed our written objection to the injunction.
Very well.
Yes, everything is on record.
Let us proceed.
The dispute is regarding demolition of an almost 100 years old dilapidated building where one promoter has already been engaged by brothers and mother of a family. They have engaged one developer for reconstruction at the place where the old dilapidated building situates. All the relatives agreed for the removal of the old building and construction of new building over the dilapidated building. Now the tenant occupiers of one particular brother, namely Pramod so-and-so, are up against the plaintiff, though plaintiff tried to relocate them and provide them with space and also promised on this behalf for shifting of their articles, if any, from the old structure to the new place which he selected for them, but verbally he submitted before the court that those occupiers started claiming ownership rights for few shop rooms in the proposed new construction, though they all are in fact have become trespassers over the suit premises. My lord, some verbal submissions, my lord, are being considered. My lord, there is no rule in that court. Frankly, I have been there, my lord. I have been severely reprimanded at times. My lord, I have seen anyone can submit anything and anything is taken cognizance of. And I'm saying this with utmost responsibility.
I can identify with that. Anyone says whatever they like in my court also. But I also say whatever I like. That is the difference.
Like your lordship referred that gentleman to the Chief Justice's court once.
So that has made me popular worldwide for the wrong business. Yes, please continue.
My lord. This court with the order dated so-and-so engaged Shri so-and-so advocate commissioners in order to inspect the condition of the suit building because it was claimed that nothing has happened to the building and the condition of the building is very good. They visited the site and submitted their report along with their field note on so-and-so. The field note attached with the Learned Advocate Commissioner's report has clearly mentioned that the suit building is completely dilapidated and very old. May I pause here? My lord, he is no authority on whether a building requires demolition or not. The authority is the municipal authority. And there was a direction upon them to safeguard my interest. I'll place that order. My
You
lord.
remember the tweet submission of it.
Learned advocates found one yellow colored board of Kolkata Municipal Corporation where the word so-and-so has been mentioned. Defendants put their signatures along with the advocates over the field notice where some have mentioned the word objection over it. Though defendants initially objected regarding shifting from the suit building, but subsequently they stopped appearing before the court and they lost all interest in the suit. This is contrary to record, my lord. Defendants lastly took step in this record on so-and-so since they have stopped appearing before this court. Plaintiff is unable to carry on his work of construction as per development agreement. Keeping in mind the findings of learned commissioners who were engaged by this court in order to take the exact and proper information regarding the condition of the suit premises, conduct of defendants and condition of a very old and dilapidated building which have a potential of endangering the human life and limb, it has been felt necessary by this court that construction work should begin at the site by removing the old building, which may injure people and even prove fatal to human life. Hence, it is ordered that the prayer of the plaintiff is allowed. This is the prayer in the suit, my lord, not in the injunction application. Plaintiff is directed to begin the construction work over the dilapidated building as per the report submitted by the learned advocate commissioners and as per agreed terms and conditions with a development agreement dated so-and-so over the suit premises, which is G+3 building, fixed so-and-so for report from the other. So, my lord, the suit has been decreed without even considering, my lord, a word that I have stated in my affidavit in opposition to filed in the...
What is the plaint relief?
Kindly, my lord, now see, if your lordship, my lord, takes the plaint.
Yes.
The plaint is at page 79. And at page 87 are the prayers. Your lordship will consider the parties, my lord. It's a collusive suit. Kindly, my lord, see the page 79.
You are the defendants.
No, my lord, kindly see page 79.
Principal defendants, you are the principal
Yes,
defendants.
yes, my lord, kindly see
How
page
can it be a
79.
collusive suit?
Kindly see page 79 for a moment. Kedarnath Enterprises, he's the plaintiff. My lord, we are defendants numbers 1, 2, 3, and 4.
Yes.
And then, my lord, kindly see at page 80 the pro forma defendants.
So they have to be made pro forma because they are the owners.
So what the pro forma
So they have not
defendants,
sought any relief against them.
what the pro forma defendants could not do in the writ jurisdiction,
Yes.
now through the back door,
Suit
they are-
cannot be said to be collusive in that. Oh, in that
no,
sense. That's
they are now using
They
Kerala
are
Enterprises, my lord, as a pawn now to, my lord, throw me out.
all right.
And a development agreement has been entered into, and a plan. Now, my lord, this plan also is under challenge before the High Court. In the writ proceeding itself, we've, my lord, sought for the contempt to be purged. There's a contempt petition filed, and for the contempt to be purged by way of setting aside the plan. So that is, my lord, that's also a part of the record before your lordship. Now, my lord, kindly see the prayer in the suit.
Yes, yes. Yes, Mr. Mitra, how do you support this? Let us dispose of the appeal itself, if you agree, and we'll direct your injunction prayer to be reconsidered regarding leaving aside their portion and making
And that has been, while the order issued, my lord, that order practical part.
No.
Whereas, my lord, the court-
Directed to begin the construction work over the dilapidated.
So far as their protection is, their possession is concerned.
Nothing in the order.
My lord, that has not been properly reflected.
Properly, it has been said, Mr. Mitra. It's a blanket order directing you to make the construction.
As far as that is concerned, we shall protect, we never treat before the court.
No, but they cannot depend on your mercy because this order has to go. We can direct the injunction application to be heard afresh, and your prayer for making construction, leaving aside their portion, can be considered by the court, reconsidered by the court, but only upon appointment of an engineer commissioner to see whether it is technically feasible without disturbing their position, because otherwise cracks will appear in their portion.
Which have started.
Their position is concerned.
Yes.
We have prayed before the court and that prayer was originally allowed by order way of temporary.
No, this is the temporary. Ad interim injunction might have been that. Ad interim, they preferred a challenge. It was relegated. They were relegated to the trial court.
Ad interim, they child, my lord, they kindly look into.
But this is beyond that. This is much beyond that. The suit relief has been granted here.
My lord, so far as the entire, my lord, the court by the order issued, my lord, the actual temporary injunction has been allowed.
Temporary injunction till disposal of the suit.
So
What will remain in the suit after this?
my lord, so far as their possession is concerned.
That has not been protected. Not been protected at all.
My lord,
You are directed to begin construction work over the dilapidated building.
dilapidated building is concerned, so far as their possession is concerned. we
Court finds before that Mr. Mitra should begin at the site by removing the old building.
My senior friend's client has filed an application under 151, restraining me from going there and taking
My lord,
police help.
that has not been passed, my lord, so far as.
No order
that
is passed there,
concerned, that should be contained, my lord.
Either we set aside now, Mr. Mitra, or we stay it till disposal of the appeal. Your choice.
So far as that
We
is
stay it till
concerned,
disposal of the appeal and direct them to file paper books and everything.
that, my lord, I can't.
That is why we put that option. They gave that option to you. We can decide it right now, but we'll set aside this order. At best, we can direct the injunction application to be reheard in the light of the prayers made there. Made there, and this will be and before passing any order, the court has to ascertain by appointment of an engineer commissioner whether it will be feasible to make construction development work there without disturbing their possession.
And until then, my lord, a status quo on construction, because our walls
No,
are
we
not
won't
damaged.
grant anything. That will be beyond the scope of the appeal again.
My lord,
We'll
but-
set aside this order. There won't be any injunction as they pray. That you have to pray independently in the court.
No, my lord, because my contention would be there was an ad interim order passed behind my back. Now, after I've
We're not
entered a-
sitting in judgment over that. That stands.
No, that stands because, my lord, the suit has been disposed of by this order. Effectively, my
We'll
lord,
set aside this order. We'll revive the injunction application. But we cannot go beyond the stage of passing this order.
my lord, subject to correction. The earlier order, my lord, and this order is, my lord, much more than the earlier order. The two ought to have, my lord, they deemed to be merged now.
You'll get the lesser evil now. You have already got the lesser evil. You challenged that in an appeal.
We did.
In that appeal, it was not set aside. That order was not set aside. That was
No,
not interfered.
no, but
we
in-
cannot do it in the final hearing.
But my lord,
final appeal.
no, my lord, in that order, there was a finding which said that if I'm in possession, I should not be touched.
We don't touch that order. That remains. We
and-
redirect the injunction application to be heard.
And my lord, the court holds that
It goes back at the position as it was after that order of the previous.
Your lordship, just consider that order for a moment. The first, my lord, order. Kindly just, my lord.
To us.
My lord, kindly take. page 108.
We don't touch this order. This order will remain.
Yes, my lord, kindly,
The injunction application will be considered in the light of this.
something which the court wasn't aware of at that point in time, now is before the court. My lord,
What?
kindly just consider. My lord, just see page 109.
Yes.
Kindly see the last, third paragraph there. However, my lord, somewhere in between it starts, however, in the event.
Yes.
However, in the event they are found to be in possession in Schedule A, they cannot be dispossessed without due process of law. It is not clear as to whether they are in possession in respect of Schedule A property. The nature and extent of occupation of the present appellants are given in Schedule B, C, D, and E in the plaint. If they are in possession of the said respective portion, then they cannot be the person affected by the impugned order. This is one of the finding. Now, my lord, the report has been filed by the Advocate Commissioner. Now, my lord, what is Schedule A? Schedule A is a plot, and Schedule B, C, D, E are, my lord, portions of a building on that plot. Kindly see the plaint now. These schedules are in the plaint itself. Kindly, my lord, consider page 88.
But the court has found that if they are in possession of the said respective portion, that means B, C, D, and E,
yes,
then they cannot be the persons affected by the impugned order.
So, my lord, in terms of the plan, this building is to be demolished and a new building is to come. Now, for example, if I am
You did not challenge this order further.
if I am on,
This order stands in your face.
no, certainly, my lord, it does. And
This
which
is against you.
Yes, this
It says you cannot be affected if any order is passed regarding B, C, D, and E.
on the basis, my lord, the court not having clarity on where B, C, D, and E is. But now, my lord, there's an inspection done, and the inspection said it's a building.
Court has a clarity. Court says, in the event they are found to be in possession of Schedule A, they cannot be disposed without due process of law.
Yes.
It is not clear as to whether they're in possession in respect of Schedule A.
It is not clear. But now clarity has come.
Regarding Schedule A.
Yes.
Then it proceeds further. It says the nature and extent of occupation of the present appellants are given in Schedule B, C, D, and E in the plaint. If they're in possession of the said respective portions, then they cannot be persons affected by the impugned order.
May I say this? I understand what's falling from the. My lord, I am on the third floor. If the second floor is demolished, I won't remain. If your lordship may at least protect me to the extent that nothing
No
would
further order of protection.
No, nothing would be done that
Nothing
would
beyond. You
that
did
would
not file
result
an
in
injunction application. No. We
that
can
would
always set aside this order. You can file an independent injunction application counter injunction. Protection that is beyond the scope of this appeal. We cannot grant something which you did not ask for in the court will.
Look, both the orders now have merged. Because my lord, this is my lord in the nature of a final order.
You have not asked for injunction. We won't grant you anything in this appeal against their injunction application order. Definitely not.
Your lordship will at least protect my portions.
We will not protect anything. We'll just protect you from this order.
And my lord, that the engineer would go and inspect and see if it's feasible to segregate the two. My lord, that
you have put to him as a suggestion. No finality on that as yet.
No, my lord may consider giving finality to that. Because, my lord, frankly, if the second floor is broken, what will I do on the third floor? But practically, now, my lord, there's a report filed before the court below. We filed an exception to that report.
Report says it's a dangerous building, and on that basis, the court has done this.
No, report was,
commissioners, what will the advocates do? They will go and see that the building is in a particular condition.
They may not be.
They cannot say. They are not engineers that they will be saying that that it can be structurally possible to demolish your.
No, they can't. Of course, they can't. They can't even comment on, my lord, demolition.
So why should we advise you? You should have filed an application for injunction and supported by an application for engineer commissioner. What are you doing? We won't advise you further. We will charge for that. We can't do that.
Advice has been given.
So no gratis advice. Yes, Mr. Mitra.
Commissioners was appointed to look into the position of the respective party.
Can that be done?
My lord, that was
Possession by visual inspection.
kindly look into the order.
That is the order.
Mr. Mitra, this will have to either stay or set aside right now and dispose of the appeal. Your choice.
Dispose of the appeal by granting the so far as the position that was there.
Injunction application will demand for rehearing. As on the date, I mean, we don't need to say anything further. We'll just remand the injunction application to be heard afresh by the trial court. Whatever is there previously is there, we don't touch it. We can't touch it. We'll just put in an observation, Mr. Mitra. It will be open to the parties to seek appointment of engineer commissioner. Because we can't resist that. Otherwise, they'll be ousted. Their portion, the day you start construction on one portion, their portion will start cracking.
So far as their
You will protect the tiger, will protect the deer. You are the developer, you are demolishing, you have obtained an order, you will protect the existing tenants, Mr. Mitru.
So far as the tenancy is concerned, they are trespassers to the property in question. But since
Therefore, they
are
can
in
be literally the floor can be taken off from under their feet.
They are in possession, we have granted, my lord.
You don't have a defense in this appeal.
My lord, even also to the, my lord, before the court, they filed also made prayer for compromise. But ultimately, they did not act.
To my knowledge, there has been no compromise at all.
My lord, this is the order reflect.
If I am assured a new place of the same size in the new building, I will prevail upon
We'll
my
take
client.
up the appeal for hearing on consent.
On consent.
The appeal itself is taken up for hearing. আগের যে order portionটা আছে admit করেছি formally. তারপরে এটা add হবে। Oh, can. আচ্ছা, canটা ছেড়ে দিন। The appeal itself is taken up for hearing along with the connected application on consent of parties. Push up next para. Upon a bare perusal of the impugned order, we find that the same has gone much beyond the scope of the injunction application in connection with which it was passed. Full stop. In the plaint itself, declaration has been sought by the plaintiff stroke developer stroke respondent number 1 and consequential permanent injunction restraining the defendant stroke appellants from disturbing the carriage of repairs stroke construction stroke demolition work at the suit property in accordance with a sanctioned building plan issued by the KMC in favor of the plaintiff stroke respondent number 1. Push up next para. In an injunction application filed in connection with the suit, in respect of which the present order has been passed, the plaintiff sought an injunction restraining the defendant stroke appellants from preventing the plaintiff from making construction and development work in respect of the suit property, barring BRRING, the portion occupied by the defendants stroke appellants. Full stop. However, by the impugned order, the learned trial judge has directed the plaintiff to begin construction work over the dilapidated building as per the report submitted by the learned advocate commissioners and as per agreed terms and conditions with a development agreement dated March 13, 2019 over the suit premises. Full stop. Next para. It is required to be considered that the said development agreement was between the owners and the developer and the appellants stroke tenants of the property were not a party thereto. Pushed up next para. In fact, as a build up to the present suit, a previous writ petition had been preferred by the present appellants in respect of the self-same property where an order was passed directing a hearing to be given to all concerned, including the present tenant stroke appellants before demolition stroke development
They were in possession
of the property. Full tenant property. Full next para. It further transfers from the that part add করুন. The continuation. Moreover, in a previous challenge against an order of ad interim injunction, a coordinate bench had recorded that the court shall decide the injunction application upon taking into consideration the interest of the appellants. Full stop. The division bench had observed that in the event the appellants were found to be in possession of Schedule A, they cannot be dispossessed without due process of law. Full stop. Although in the same breath, the division bench had held that it was not clear as to whether they are in possession in respect of the Schedule A property. Full stop. Next para. However, the tenor, TENOR, of the said order was that the position of the appellants, comma, if any, in respect of the suit property, is to be honored before deciding the injunction application finally. Full stop. Apart from the fact that the trial court did not take such factor into consideration, comma, it has also been observed by the appellate court, by the trial court, comma, by placing reliance on the observations of two commissioners' report, comma, that the concerned building has been marked as a dangerous building by the Kolkata Municipal Corporation, and the condition of the very old and dilapidated building has a potential of endangering human life and limb, and it is felt necessary by the court that construction work should begin at the site by removing the old building, which may injure people and even prove fatal to human life. Which of next para, such observations are entirely extraneous and beyond the purview of the suit itself. Which of next para, the suit has been filed on the strength of a development agreement executed apparently by the owners in favor of the plaintiff stroke respondent number 1 stroke developer, and has nothing to do with the orders passed by the Kolkata Municipal Corporation. Push sub next para, that apart, comma, we are convinced that the relief granted by the impugned order, comma, while deciding the injunction application, comma, was much beyond the scope of the injunction prayed for in the application, and tantamounts to decreeing the suit itself prematurely. Full stop next para. In such view of the matter, comma, FMAT 282 of 2024 is allowed on contest, comma, thereby setting aside the impugned order, being order number 23 dated June 18, 2024, passed by the learned judge, comma, 12th bench, comma, City Civil Court at Calcutta, in title suit number 1721 of 2023, full stop. The injunction application is remanded to the learned trial judge. Full stop. The learned trial judge shall now decide the injunction application upon giving a fresh opportunity of hearing to the parties. Full stop. In the event the learned trial judge feels necessary, comma, the learned trial judge shall appoint an engineer commissioner before deciding the injunction application to ascertain the technical feasibility of development work in the rest portion of the suit building by leaving aside the portion of the building occupied by the appellants, and the concerned and the safety concerned of the appellants in that regard should also be addressed by the learned trial judge before deciding the injunction application finally. Push up, it is made clear that it will be open to the learned trial judge to decide the injunction application on its own merits without being unnecessarily influenced on merits by any of the observations made above. No address to cause admission. আচ্ছা, আরেকটা লাইন অ্যাড করে can 1 of 2024 is accordingly disposed of as well.
My lord, only one indulgence. My lord, if necessary, my lord, can it be, my lord, a request to the trial judge to appoint an engineer, or in the alternative, if maybe we may be given liberty to file an application for appointment. I'm grateful, my lord.
As well. Yes.
Grateful.
Thank you. Oh, yes. Come forward, Mr. Mitra is also there. Mr. Mitra, the difficulty in that matter is, as we are apprised by the department, that without a specific number, the list cannot be printed. A matter has to be there. Your matter does not have a number as yet, so it could not be listed. With the leave of Justice Kant, I am granting you that leave to file it with short cause settle. You can communicate to the department and just একটা leave দিয়ে দিন. This is appellate side.
Appellate side.
একটা leave দিয়ে দিন to file with short, leave is granted to file with short cause title. এটা শুধু আমার leave granted by
Short cause title, stamp punch
and filing.
stamp punch and file.
Oh, your language.
Let only
That leave is granted. This will appear whenever I see it singly. Day after tomorrow.
Yes. One more thing, Milad, I observed that point of time, Milad. He would have tried to serve on the Milad petitioner in the content, but he has refused. But Milad, the KMC had, Milad, Milad, they have received. Only thing is that Milad, they are going to Milad take Milad, the notice is for demolishing tomorrow. Milad, let them don't not take any action, Milad.
No, Mr. Dasgupta, we won't pass this.
Otherwise,
We
Milad,
cannot, I
application-
cannot pass that order sitting in a division.
My
We cannot.
application becomes infructuous.
No, we cannot. This will be, I mean, we'll be going back to the previous days when without files, without publication in the list,
In this
3
matter,
orders passed in the same matter on the same day, we won't do.
I don't want Milad
I won't do
to
that.
go back.
No.
But Milad, only
Whatever happens, it may be demolished, but I cannot pass an order in
But
division.
Milad, I am being non-suited then, Milad. The issue is that Milad, I was not a party to the contempt. No allegation.
Not in this fashion. Not in this fashion.
He has refused to take Milad. The private respondent said that I will not receive.
Mr. Dasgupta, you can fully appreciate, but nothing can be done at this point.
Party
We cannot do it.
for not Milad passing the order after
No
passing
order,
the
Mr. Dasgupta. No order sitting in division bench in a single bench matter. No. Just like that, we cannot pass an order.
Kindly thinks Milad of the Milad, my petitioner's
I'll
predicament.
think overnight, but because of your predicament, it will cause me to think. But I cannot help you. No.
Yesterday, 6 p.m. it was served. We have Milad made it.
Mr.
but I
Dasgupta,
have
we
done
cannot do something which is palpably
From
no.
my side, I have done everything.
One illegality cannot be cured by another illegality. No.
Or Milad, if Milad makes the matter returnable tomorrow anytime. Milad,
Cannot,
in the
cannot.
morning,
How?
Milad.
We cannot do
Because
like
they
just like
will take steps from 11:30. Otherwise, I become non-suited. Or Milad, if Milad, Mr. Ghosh is here, if they can wait till 6th Milad, I have no difficulty Milad sitting on 6th singly. Otherwise, I become non.
I won't pass an order of court.
If Milad sits tomorrow, Milad any time for 5 minutes, Milad before 11:30 at any time.
But then also, unless you file it, we cannot publish
We'll
it.
try to file it, will get the can. না, phone করতে পারবে?
No. Won't get it. You can mention it tomorrow morning after filing. After filing, you can mention, we can think about that.
Then I will be sitting. Well, I'll get the
Yes, we'll be sitting in the middle of the middle of our matters. You can
rising Milad, then Milad I'll.
rising. If you wait till rising, then we won't be.
My lord sits Milad at dot at 10:30. They will not be in the very well.
Yes. During court hours, you can mention it in time. Whenever. No, we cannot take up immediately, but we'll suppose it has to be before 11 at least. Because we can do this, I can direct the list to be published, a supplementary list with your number at 12, and we can advise to that. We cannot do more. Right now, I cannot pass any order.
I will Milad bother your lordships tomorrow Milad in the midst Milad. Any
Yes, you do, but do that before around 11. If it's later than that, it will be very difficult then to publish a list also. Yes.
They don't Milad. I'm told Milad 11.
Bring them, do like the elections for the political parties. Bring them from home and get it at home. We cannot do anything. We cannot help you.
Milad, Mr. Ghosh is there. কালকে কোনো step নেবেন না?
Mr. Ghosh may take steps. We won't pass any order. We are not witness to anything.
Because of the court's order.
Although now our blindfold has been removed, but I still keep my blindfold on.
For the timing, Milad, I was Milad be
No,
sitting a lot.
you're not distinguishable to us.
Very well, I'll try.
Yes. Next, একটা matter call হয়ে যাবে দেখুন। If you two are appearing, it cannot be heard. So, in 4 minutes.
For eviction, my lord, filed in 1979, decreed in 2009.
SMAT, acha, order 2100.
My application order 21 rule 98.
That was dismissed, my lord. I'll tell your lordships very briefly. Suit filed, my lord, in 1979 in respect of our property on Theatre Road. A shop, a portion of our property. Decreed in 2009. Appellate court directed, my lord, payment of occupation charges at the rate of 2 lakhs rupees per month.
This has not been admitted as yet.
No.
So we are admission. This is for admission here. Mr. Mitra will take it up tomorrow. Tomorrow because this will go up tomorrow. Some of the matters we have relegated to 19th because the regular bench is not there. The hearing matters mostly are relegated to 19th now. So this will go up. We'll take it up tomorrow as order for.
We have a preliminary point of maintainability of this.
Order for no, you don't have a right.
I satisfy your lordship.
You don't have a right of here.
I agree with her, but
You know that.
I just indicate why I say this because I think it can be disposed of over here. Kindly give me 2 minutes. I know, although I don't have audience, but give me 2 minutes on that.
We'll consider tomorrow with fresh mind. affidavit service.
Possibly it was not required.
No,
but it has
Mr.
been
Mitra, keep it with you. We'll take it when we take it up tomorrow. Right now, we cannot take it on record also before hearing you on order 41.
Yes.
Immediately after that, we'll take that and hearing on the maintainability also.
Definitely.
আর ডেকে নাও আর 2 মিনিটে কি হবে এসো এটা কোনো অর্ডার পাস করা দরকার না কালকে নেবো 2 মিনিটে কিছু হবে না বেকার